Right. I don't know if that's someone that's. Well.
Oh, no.
All right, are you ready? All set? All right, we're back on the record with 2020 CV 339937 for day 8 of trial. I think we may be waiting on 1 or 2 more jurors. But when they're here, we will be resuming cross-examination of Mr. Wood. And so until that juror arrives, let me first check in with the plaintiffs. Anything to address before we would resume on the part of the plaintiffs?
We're just waiting for the tax returns, Your Honor.
Okay, we'll start there.
I have those here.
Why don't you take a look at those? You can let me know if you think those appear at first glance to be sufficient, Mr. Beal.
Thank you, Your Honor.
I've only got one more. You good?
Thank you.
And Your Honor, I would point out the court that these returns from 2022 and 2023, my most recent returns, that they have been redacted on each page with respect to my social security number.
Good.
We have some matters to take.
Yeah. Okay, so it looks like we'll come back to that while you're looking at it to make sure that that's sufficient. Anything else that the plaintiffs need to bring up before we resume?
No, Your Honor, the scheduling after we finish with Mr. Wood, is that the end of the defendant's evidence?
That was what had been presented to me.
Well, we reserve the right, I've told the court that we reserve the right to call one or more of the plaintiffs for purposes of cross-examination.
Okay. But other than that, we'll be done.
I would imagine so.
We can do brief motions and then,
We would have motions and then we would segue into a charge conference.
okay, do that and then close.
That's right.
Okay.
So I think the earliest we're closing is going to be after the lunch break.
Okay. I'm not going to be long with this.
Okay.
I know I've got an hour and a half or something left in time, or 2 hours. I'm not going to take that much time. And I know that's been a promise in the past, but
Promises made, promises broken.
We'll
Well,
find out together, Mr. Beal.
He did cut it down significantly, Your Honor. I can attest to that.
All right. Anything else, Mr. Beal, that we need to clarify on your end or the plaintiff's
I
end?
don't think so, Your Honor.
All right, let me turn it over to Mr. Wood.
Thank you, Your Honor, and good morning.
Good morning.
We still do not have the documents from the plaintiffs with respect to our notice to produce. So we haven't had a chance to look at those to see if they have relevancy, which we believe they do, beyond any issue regarding the financial condition of the plaintiffs. And so we're going to need to see those before we can finish our case, because we very well will call one or more of the plaintiffs for cross-examination. So I'd point that out.
Okay, on that issue, I know we'd had some discussions about it. We had talked about honing in as to the core of the request. And as I'd indicated before, considering the motion to quash, the initial notice to produce, it was an expansive request, and I would modify it to relate to any of the documents in all its terms and definitions and scopes that reflect any indication on part of any of the plaintiffs that they declared or suggested they have an ownership interest in L. Linwood PC. And two, during that time period, I believe that the relevant information requested is whether they received legal income from any other source other than L. Linwood PC. And so that's what I would modify the notice to produce. And to that end, those would be the documents that have to be produced as responsive.
Thank you, Your Honor.
Okay, Mr. Beal,
We have no such documents in response.
I don't know that until I see it.
I understand that, Mr. Wood, but I don't think that the way that these notices to produce work that I have to do some kind of massive in-camera inspection, or that we need to be sorted through in bulk. I don't think we can use notices to produce as just well, it might be in there, at least
No,
as I've
it's
used
in
them
there.
before.
If you look at what we requested, it's clearly relevant and will show sources of income, and it will show whether they had any partnership interest in terms of filing partnership returns with their tax returns. But I can't know that for sure until I see them. I appreciate Mr. Bill's representation, but I don't trust him. And I'm entitled under the law to see them. And then if they contain the information that Your Honor has indicated would be relevant, then I'm entitled to use that limited information. If they don't contain that information, obviously I can't use them under the court's rule, but I'm entitled to see them.
Were these anything that you requested through the discovery process?
Didn't have to. I request them by notice to produce, just like they requested by notice to produce information that they had not sought during the discovery process. Notice to produce is not limited to producing documents identified in discovery.
I agree with you there. Mr. Beal.
First of all, Your Honor, it's only appropriate to do it during the discovery process because they are not admissible as such. Here, these requests are admissible if we get to a phase 2. If not, I give it back to them or shred
Well,
it.
I mean, they could be admissible if the information I've indicated is in there. It would be admissible as either impeachment or relevant to the facts of the case. It's more so, I think, process. Is he's saying that he has a right to cull through these just in case your representation is not accurate.
And clearly, Your Honor, he does not. He's asking us to prove some kind of a negative. This should have been done years ago. What he wants is to get their financial records to put them on Telegram, which he has done with every, can I go ahead?
He's got to finish.
With every single phase of this case for 5 years. This is going up on some social media platform to insult Taylor, Jonathan, and or Nicole. Probably starting in reverse order. His favorite has been Nicole, and then Jonathan, and then Taylor. But other than the order of personal attacks, the overall goal is pretty clear. And none of the information requested is relevant. All income comes from them. He had them on the stand. We asked them repeatedly under oath, have you ever received any income from any source during this time other than L. Linwood PC? And they said under oath, we have not. So that issue is done. And this becomes a ridiculous delay of this trial, looking for something that everyone admits doesn't exist. Mr. Wood was their employer for 4 to 6 years. He would have known if they were working on another case. He could have searched the internet and say, give me filings by Jonathan Grunberg, and then made sure they all said Ellen Wood PC. When he took their depositions, he could have said, what other sources have you done? He was sitting next to them for 5 years. He would have known if they were working on something else. Now he seeks again to delay this trial while he goes into some kind of inquiry on discovery he didn't conduct, and he didn't conduct it for a reason. He knew it didn't exist.
All right, I didn't, okay,
I
Mr. I'll
raised-
give you the last chance to respond, and then I just need to rule on this.
We requested, the notice to produce was filed at the beginning, before the beginning of the trial. The only delay that's occurred is the court's ruling on it. I'm not interposing the notice for delay. I would have preferred it be ruled on before the trial started. So Mr. Bill has his version of the truth, and I have my version of the truth. I've made it clear what we have asked to see and why we've seen it. What I put on social media is not evidence in this courtroom. And if I put something on social media that violates an order of this court, the court can address me. I haven't done that. So I don't, and I haven't attacked the plaintiffs on social media. I've honored the court's ruling about non-disparagement. In fact, I've praised them. So I don't know where he's coming from, but he's got something to hide. I don't know what their relationship was between themselves, whether they took on cases and split fees that I didn't know about. I don't know that.
In your honor,
Well,
Honor's ruling previously made the most sense. Request if they have any evidence of any other income during this relevant time period. And we have represented to the court, they have represented under oath that no such document exists. Now asking for 6-year-old tax returns from our clients, because I guess it would have to be 2019 or 2018. I'm not even sure they would have them. But it is, we would contend it's in bad faith. The notion that Mr. Wood has not attacked the plaintiffs.
all right, I think I'm ready to rule, Mr. Beal. We don't need to go any further. I think a lot of the points you raised really aren't what I'm trying to drill down on, which is exactly what a party is entitled to with a motion to produce, which lies separate and aside and outside of discovery. And so I'm trying to confine myself to the statute, title in our evidence code. And as I understand it, the standard there is when a motion to quash has been filed, the initial burden falls on the requester to show that the documents are relevant and non-privileged. And I've already said that in line with the statute as well, that I found the request overbroad, that I found it needed to be honed in. And so I've indicated how that would be tailored. And now the question is just whether the process is that I'm not supposed to accept the representation and take those documents and review them myself, either in camera or they have to be turned over. I'm not aware of any authority that says that's how this works. I think the discovery process outside of this notice to produce in large part depends on and accepts representations throughout a pretrial hearing. And I don't believe a notice produce is in the nature of discovery where it can be used generally as the term is commonly used as just a fishing expedition, where I think something may be in there, but I don't have any evidence to indicate that it is. And that's where I think we're at, is that you haven't shown me that there is a specific reason to believe that what you're requesting is in there. And so to that end, I don't think you've met your initial burden, Mr. Wood.
Well, Your Honor, it's amazing that this lawyer says that he doesn't even know if they have their 2018 and 19 tax returns, and yet he represents to the court what's not in there. How could he know that if he hasn't even seen them and they don't even have them? I believe that the tax returns from 2018 and 2019 are clearly relevant to the issue that Your Honor has drilled down on. And that is to have me have the opportunity to see whether they had other sources of income and whether they reported their income as 1099s and not filed with the government a partnership return. I don't think they did, but again, I haven't seen the return. So I don't think it's onerous to ask for those 2 years of returns. And he's represented there's nothing there, but yet he on the other hand says, I don't even know if they have them. Somebody's not telling the truth. If they have them, then he can produce them. If they don't have them, I can cross-examine them on it. But it seems to me that I'm entitled under a notice to produce to get from them that relevant information to determine whether or not it does contain information within the scope of the narrowing Your Honor has indicated. I can't prove a negative. And it may be that when I look at the returns from 18 and 19, there won't be anything there, but I don't know that. And I shouldn't be forced to take Mr. Bill's representations of what's there and not there when he stands here and says he doesn't even know if they have them. The
Okay.
law requires you to maintain your tax returns for a certain period of time. I
All
think
right.
they have them.
Understood, Mr. Wood. I think you've laid out your position. I think the issues are clear here. And I think I've explained where I believe I fall. And so I'm issuing that ruling. It's preserved. And I think we move on to the next issue.
Reserve meaning that it's
Your objection,
for purposes of appeal.
of course.
All right.
So what else do we need to take up before we would resume the cross-examination?
I have a motion. It's three
Okay.
parts.
All right.
All right. At this time, Your Honor, on behalf of the defendants, we move for a mistrial. And the first basis for the mistrial is that it has come to our attention that Your Honor and this court have been for an extended period of time displaying photographic images of the jury. I have the evidence in part to show you. Marked as Defendant's Exhibit 108. Apologize for no label.
Of course.
So during the course of this trial, at various times, in fact, many times, the jurors' actual faces have been shown to the public. The law in Georgia requires that the court protect the jurors. Names and addresses can be used. That's what I asked for the other day with respect to the jury list, that I would need those to look at the question of meeting with these folks afterwards if they're willing to talk to me or to know who they worked for. That's not absolutely protected. Otherwise, they're absolutely protected. So what you have is you have a situation where someone could go out, identify them from their photographic images, intimidate them, bribe them, or otherwise put them in fear that they might have to find against me. Not talking about a rigged jury going in. I'm talking about a jury that would be subjected to influences during the trial that would be adverse to the defendants. And you can't unring the bell. You can't unring the bell. It's happened. It can't be corrected. It requires a mistrial to be granted. Georgia law is clear. To show images of a juror during a trial invades their protected right of privacy, and it potentially prejudices my case because we don't know what influences could be brought to bear on the jurors by virtue of their identity being exposed to the public. So that's my first basis for mistrial. I have two others.
All right. Why don't we go through all three?
Second basis, Your Honor, is based on Your Honor's conduct in terminating abruptly my direct examination. You did that in front of the jury. You admonished me. That prejudices me in the eyes of the jury. And it's not the first time. And I have been accused directly of being a racist. Mr. Wood has a plantation. Mr. Wood is white. Mr. Wood is wealthy. They are playing on the prejudices potentially of a jury that's made up of 10 black people. We've objected to the characterization, but Your Honor has allowed it. And so that interjects in the jury the question of whether Wood is a racist. It was Dr. King that said that we are to judge people not by the color of their skin, but by the content of their character. They've tried to prejudice this jury based on the fact that I'm a white man, and they claim improperly that I now own a plantation. I do not. It's a former plantation. When I bought it, it was no longer a plantation. They used Reynolds Plantation. When I bought a condominium there, it was Reynolds Plantation. And shortly after I purchased the condominium, before I then purchased a home there, they changed the name to Reynolds Lake Oconee. But they have repeatedly used Reynolds Plantation to Motley Plantation. And that bill cannot be unwrung. And I believe that's the basis, second basis we submit, that I'm entitled to a mistrial. I'm entitled to a fair jury. I'm entitled to a jury that is not prejudiced by outside influences that has been interjected in this case by Mr. Bill over objection that Your Honor has allowed. That's my second basis. I have a third.
You can proceed.
For third and independent basis for the mistrial, I believe under the entire trial record, I'm entitled to a mistrial so that I can then have the trial record produced, transcript, to show, Your Honor, that you are biased against me. And that can be shown as far back. We'll stop at the pretrial. When we didn't get a pretrial order until just before the trial. Literally, I got it Friday or Saturday before the Monday trial. I believe Your Honor entered it on Thursday. There was no reason for the delay. Your Honor knew at the time of the initial pretrial that there were issues that were unresolved. And then you resolve them, I think, with all due respect, in error. You got parts of my case on the day before the trial starts. And then repeatedly during this trial, both in your remarks to me and the way you've treated me, you stopped my direct examination because you said I was talking over Mr. Bill. I will state in my place, and if necessary, can produce the medical records. I suffer from hyperacusis, diagnosed by a general practitioner in Beaufort, Georgia, and diagnosed by an ENT specialist in Beaufort, South Carolina. What hyperacusis does is that it takes sharp sounds and makes them very loud, and it mutes out the softer sounds. So I got yanked off the stand because I had somehow interrupted Mr. Bill, and I didn't hear him. Mr. Exum pointed that out to Your Honor. So you're taking a disability in terms of the hyperacusis, and you're using it against me to embarrass me and demean me in front of the jury by yanking me off the stand when I have not completed my direct examination. I couldn't figure out what you did it for. I didn't know. Then I look back and it's because I interrupted Mr. Bill. I didn't hear Mr. Bill. I have repeatedly throughout this trial, and the record will show, I have asked Your Honor to speak up. I've asked the witnesses to speak up because I can't hear them. They talk too soft for what the condition I have causes. I can go on, and I will, if Your Honor will allow me. I believe, and I've asked Your Honor, if you were a Freemason and you told me you didn't know what that meant. I don't understand how you don't know, but the point is, you allowed me to examine the jury on voir dire about Freemasonry to determine whether or not they might have a bias against me because of Freemasonry. And you are a Freemason, and you have a bias against me. And I know it, and I believe the court knows it. And that bias alone should allow me the opportunity to have it addressed by another judge to determine whether or not you're fit to hear my case, qualified. And that requires that we mistry this case and get the matter heard by another judge. The rulings in this case are replete. You have made rulings halfway through my question, cut me off, sustained the objection without giving me the opportunity to make a full record to state my question. You've claimed, well, I know where you're going. You don't know the future. Only God knows the future. Yet you've prohibited me from making a full record on many questions where I've been interrupted by Mr. Bill, and you've sustained the objection without allowing me to complete even the question. I have asked at times to be excused to go to the bathroom. Your Honor is aware that I also have a gastrointestinal problem. I'm surprised that we don't have 15, 20-minute breaks in the morning and the afternoon. That's been my experience in trials. But then you'll give me 5 minutes. You know that I'm having trouble walking. It's as if you say, well, go 5 minutes. Walk down to the bathroom, do your business, but be back in 5 minutes. That's not fair. That's not humane. That's not treating your fellow man correctly. And you know how difficult it is for me to walk. It takes me almost 5 minutes to get to the bathroom and walk back. You have continued to enter orders during this case that should have been ruled on prior to trial in the pretrial order. Sometimes I don't even know what you've ruled. A lot of the issues that we've been presented with in this case, where you've ruled one way or the other, those should have been handled at the pretrial order. I'm entitled to a fair trial.
All right, we're repeating ourselves there, Mr. Wood. We've already addressed the pretrial order. Do you have any additional reasons to support your motions?
I have a number of reasons, but it would require that I get the trial transcript, and then I can be able to put them down, and there will be a long list. That's why I'm moving for mistrial, to give me the opportunity to get that transcript, to make my case about your bias against me. And if I'm right, this case has to be retried in front of another jury, in front of another judge. I'm not questioning your right to be a Freemason, but I am questioning your bias against me because you are a Freemason. And you have given Freemason hand signals. You've been captured on video doing the hidden hand in your robe. You have been captured on video doing this. Jonathan calls it the shh. That's a Freemason symbol. Now, you may have a reason for doing it unrelated to Freemason, but it's a known Freemason symbol and signal. So I'm not making that accusation without a basis. I know you were appointed by Brian Kemp, both to be Inspector General and then to be a Superior Court judge. Brian Kemp is a Freemason. He is a member of the University of Georgia Gridiron Secret Society. I have photographs of Brian Kemp giving Freemason handshakes. So I know that Freemasons are going to appoint Freemasons. That's the way business is done in the world of Freemasonry. I have not minced my words outside of court that I was being subjected to a Freemason tribunal. And I am. And anyone that has responded on social media knows that I'm right because they've seen it with their own eyes. They've heard it with their own ears. I don't think, Your Honor, with all due respect, appreciates that this trial is being closely monitored to see what happens. And based on what monitoring I think is being seen, something's going to happen. Someone is going to take action. I don't suggest who that person or group of people might be. I think I know. But I know this. God is watching everything that happens.
All right.
And God will reward you according to.
All right. I think we've gone afield of legal arguments, Mr. Woods. So I think you've made a record of your three bases and going through them as it relates to, we've got D-108 that'll be tendered just for the record, not as an evidentiary exhibit. We can have that, I guess, provided to our court reporter here. It shows that there are reflections being shown in the TV behind, and D-108, it's the TV behind Mr. Wood. I'll note that it was actually his request to turn off the TV, making those reflections possible.
I did not know that.
But regardless, I think it's pretty clear that no one intentionally is trying to, I'm ruling Mr. Wood, it's not your turn. Displayed these images. Certainly we want to keep influences or the possibility of their identification, reduce that possibility. I think that this can be, to the extent there is any danger of that, before they begin deliberating, that's something we could ask them if they think that they've been subjected to any outside influences. Before they begin the deliberations, we can ask them that. If they are able to reach a verdict afterward, I think that cures whatever concerns we have there. And these videos can always be taken down or made non-public if need be during deliberations. Mr. Beal, on that point alone, do you have any input?
And it is also an open courtroom, so people can just sit in here and look at it.
At that point too.
And you can't tell who any of these people are, even by his best exhibit. You couldn't tell. I mean, I couldn't identify any of those people. And Your Honor has made every reasonable accommodation. And in fact, I said when I insisted that something be left on the screen, the reason is there can be a reflection. And I assume that's where he got the idea to make this motion. I can real briefly address any others.
I think we spent enough time on it. As to the remainder of any indications of bias, it's legally improper this time. That needs to be raised through the uniform rules as a motion to recuse. He hasn't done that. And I think the case law is there, that there's no affidavit or written order reflecting that. Most of the things he's raising, he claims to have known or have happened for some time. It needs to be timely to make that sort of a motion. And as the only other thing I would add to his other complaints are that I have found throughout the last 8 days that he has repeatedly defied my orders, my directions. He's essentially unmanageable. And I find that they've been intentional in knowing. And so I think that the conduct, any that has occurred in front of the jury, has been limited. It could have gone much further, but I don't think it comes anywhere close to impacting the fairness of the trial. I think it's been fully justified. The record is preserved. No, you may not. Let's bring in the jury and we'll
I-
resume
I just have a
cross-examination.
real brief oral motion in limine based upon what he has said here. We would ask for a motion in limine from your honor that Mr. Wood not be allowed to make any comments about the people who are monitoring this trial or threats of retaliation based on the outcome of this, because we can see that that would be a very effective closing argument, that people are monitoring and they're going to come get you and the boogeyman's out there. And this would be wholly and completely improper.
Absolutely.
And it
And
would
I'll,
be almost criminal, I think. I'm not.
well, we'll
Expert
we'll
on
take it as it
criminal law.
comes. I will be mindful if there are any phrasing that comes close to that, as I will not tolerate any kind of jury intimidation.
Your Honor, we have submitted to you what you required us to do on a general bullet list. We did not copy counsel on that because that would be improper. You're not entitled to know the scope of my examination. You've asked for it, we've given it to you, but that's why we didn't copy it to them. Just one comment. The idea that I asked the monitor to be turned off on the screensaver to reflect.
I'm not saying you did that intentionally. What I'm showing is that this was clearly unintentional on everyone's part to the fact that there was a reflection.
Let's assume it was unintentional. That doesn't change the fact that it happened.
Okay. All right.
You did post on Telegram that you wanted that to happen, the image.
That's not
and the
true.
Reflection.
I'm not monitoring that telegram, and I don't think we need to bring that in as part of the record. I think we need to keep moving forward. So at this point, Mr. Wood, I'd ask you to resume the stand and we can bring in the jury. Thank you, Deputy Scott. Yeah, you can take that.
Yeah, I kind of. Okay. So let's get up there and get started on that.
Here's volume. Not sure which one.
All right, the jury.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, apologies for the delayed start, but we're ready to resume the case at this time. And the plaintiffs may resume their cross-examination.
Thank you, Your Honor. Mr. Wood, I believe we left off with some testimony regarding the DeVita case and some of these other cases where you were referred the case by Rick Miller. Is that correct? We talked about that.
Well, you're talking about some cases. I don't know what cases you're talking.
Okay.
I know what happened with DeVita, and it was not a direct referral from Rick Miller.
All right. So
It was done.
of that
indirect.
large case,
I was trying to answer.
you
It was
shared
done.
some of the
Ma'am,
fees.
Let's hear the actual question instead of, and hone in on what exactly you're wanting to learn about the DeVita case. Mr. Beal.
In the DeVita case, you shared some of the fee with Sharif Azell. Is that correct?
Yes, $10 million, and she was not working on the case.
Okay. So you paid Sharif Azell $10 million and she was not in your law firm. She was not working on the case. And if I remember your testimony correctly, you said she wasn't even an actively practicing lawyer. She had to reinstate and become reactive with the state bar. Is all that true?
I think you're generally correct. Let me explain. The arrangement, I was asked to represent DeVita by a lawyer named Marlon Wilbanks, who had brought the case to Brian Cave. Brian Cave turned it down. I made the decision to contact Marlon directly. Miller said that's a good idea. And then Rick struck a deal because of the anticipated amount of expenses where he said his wife would advance 1/3 of the out-of-pocket expenses. And she did. And when issues arose about my concerns about Rick Miller, who is a Freemason, those issues were what led me in part to discuss that division of fee with her. They framed it up and I signed it as essentially a litigation expense arrangement where firms will go out and advance money to help you finance litigation. She was, I think, an active member of the bar. She reactivated her license during the DeVita case, but she had not worked on it. And I began to feel like that I had not done correctly by giving her a percentage of the fee, and I raised it. And that's why I was looking to find my emails about Cherie's involvement when I found my computer in total disarray.
So the answer to my question is yes, you shared fees with Cherie Fazell, who is not a member of your firm, didn't work at your firm, didn't even share space with your firm, had to reinstate her license to become active and never did a day's worth of work on the file. Are those statements correct, sir?
You've misstated what I testified to. I stand by my testimony.
Okay.
That was a concern to me that in fact she was not
Objection, Your Honor, this isn't responsive. It's a
Well,
yes or no.
No, I think you opened the door to his previous testimony. So you can finish that thought, Mr. Wood.
It was my concern that occurred to me that she had not worked on the case. I went back and saw the agreement where she said she was in effect going to advance expenses. But the deal that she struck with me through Rick was that she would receive a percentage of the recovery, which ended up being, I think she advanced $600,000 and she ended up with $10 million. And I raised that with Rick. I raised it with Brian Cave. I raised it with Rick, who was going to leave Brian Cave and go to work for McDermott Will as a managing partner in Atlanta.
Objection, Your
And I
Honor.
raised
We're
it
now
and-
way far out.
Yeah,
Well,
I got the answer.
we are.
didn't-
We are.
and I
beyond
need
that.
to move on.
I didn't reach the point
I
where I
don't.
took it up with the state bar. I decided to
Mr.
move on.
I'll hear the end of this sentence, Mr. Wood. End of the sentence.
I didn't take it up with the state bar. I was inclined to do so, but I decided move on.
Okay.
All right, Mr. Beal.
So would it be fair to say you didn't take it up with the state bar because you were absolutely positive that that deal of giving $10 million to some other lawyer that didn't do any work on the case had to be a violation of your ethical duties regarding knowledge of the client and consent of the client?
I was very concerned.
Yes or no?
Well, yeah, no, not, I can't answer yes or no. I was concerned that I may have inadvertently violated the state bar rules, that Cherie Fazell may have violated the state bar rules, and that Rick Miller may have violated the state bar rules. I was concerned.
Okay.
The clients, Daniel Barbier and Alon Vayner, they were aware of what I paid to Cherie Fazell, and they did not object. So my concern was not that I didn't have client permission. I did. What I was concerned about is whether I had violated the rules by making that payment to a lawyer who had not worked on the case. And it raised ethical concerns that I may have violated the rules, Cherie Fazell may have violated the rules, and Rick Miller may have violated the rules.
So you paid her $10 million and you got over 20 million. Is that correct?
No. That's not what I got.
All right.
And what does that matter? What I got? What I got was what I.
All right, Mr. Wood, let's stick to the questions.
And the entire, and part of the reason for Cherie to be in these cases is that if you paid the referral fee to Rick Miller, he had to put it in a pot with hundreds of other lawyers and divide it. And Rick wanted to take the money directly, and you helped
Objection, Your
him
Honor.
do that by paying it to his wife.
Testifying what Rick Miller's.
All right,
claims that
Mr.
he had.
Exum can raise objections
Miller's
on your
not
part,
here.
but it is not appropriate for a witness to be raising objections.
All right, John, if you would object. to
And
what
it's
Rick-
not appropriate for a witness to be instructing their attorney what to do from the witness stand. That'll be the last time that happens, Mr. Wood.
May I have a moment to confer with my counsel?
No, you may not. We're in the middle of a cross-examination.
So let me ask this question. So it was okay for Cherie to get 10
I
million.
don't think I answered your last question.
I think he withdrew it. He's re-asking, I guess, another question.
All right.
So it's okay for Cherie to get $10 million when she doesn't even work for you or with you or work as a lawyer. But it's not okay for these lawyers on your website, on your pleadings, working in your office every day, representing that they are members of your firm, to get paid $845,000. Is that correct?
That's apples and,
State's testimony.
To that objection, it's overruled. The witness can answer whatever component of that he wants to.
Right. that is just a gross mischaracterization. Again, you're comparing apples to oranges. My relationship with these lawyers is what it is. My relationship with Rick Miller and Cherie Fazell and Marlon Wilbanks is what it is, and they were different. So you can't
Okay.
compare the two. And it was not my case.
Yeah.
Marlon Wilbanks associated me, and Marlon Wilbanks maintained the position of making the decisions on the case because they were his clients, and he had brought the case to me to associate with him. So you're misrepresenting that I had control over DeVita when in fact it was Marlon Wilbanks.
And you shared fees with Cherie on other cases, including the wrongful death case involving Sharon Lindsay.
I did.
Is that correct?
Yes, and I brought that up with Joey Burby. In fact, it was the Sharon Lindsay case that I asked them about because I was concerned. And that's the case where they came back and said, you've got to have client consent. And so I got an agreement from Ms. Lindsay that gave me the right to divide the fee as I saw appropriate, and she
Right.
agreed to it.
And
she
you
signed
saw
the
Ms.
agreement.
Lindsay's testimony where she said, I don't know who Cherie Fazell is.
I also presented into evidence where she claimed not to have signed the settlement authorization.
Objection.
We put,
She didn't say that.
no, I'm not talking about, I presented evidence that she did in fact sign that authorization.
And do you remember her testimony that she might have signed it? She just couldn't remember.
But she signed it. We have
Right,
it in evidence.
she did.
We found it.
She did. Let's look over at Exhibit 303. Does this appear to
Hold on,
be
I've got it. Let me get to it.
volume
I've got to
2?
get to it.
Volume 2, Drew?
Yes, 303. And my question to you is,
Would you let me just find it first? All right, I have it.
okay, does this
But wait-
appear
wait
to
a
be
second.
your
Hold
email
on one second.
sent to
Hold on one second.
Todd
Andrew,
McMurtry?
hold on. I have under tab 303 a document. The plaintiff's exhibit number on the document is blank. I'm assuming that this is 303.
Yeah. So does this appear to be your email to Todd McMurtry dated 3/18/2020 at the top of the page, one day after you signed the settlement agreement? And this is already
I'm
in
sorry.
evidence, so we can pop him up through Todd McMurtry's deposition. It's already in evidence, Mr. Wood, been testified to.
You want me to testify to it? Give me a second to read it.
Well, I'm just gonna, I'll direct you and it'll probably save us some time. Are you forwarding to Todd an email that you sent on March 17th, the day of signing the agreement at 10:03 PM?
Yes, that I had sent to my,
Children.
and to my former wife, to my administrative assistant. Yes, I did that.
Okay, thank you.
Wanted to know the truth.
And it says my children, and then it's a page in a Porter email. Is that right?
Well, yeah, that looks fair.
Okay, so let's look
Page in a
over at
Porter.
page 2 on the email. And that paragraph, the short paragraph with the bold in it, let's look at that one.
Okay.
Throughout this email, you've made a lot of comments about WGW. Is that correct?
You'll have to point them out to me.
Well, let's look at this paragraph first. Please note their admissions today that they have never been my law partners and they have no information or belief at any time which would raise questions about my mental health or competency. Did I read that correctly?
You did. What's your question?
Why were, this was sent hours after you signed the settlement agreement, right?
Yes.
Okay. So the same day and within a couple hours of signing the settlement agreement, you forward an email to your kids saying, hey, they're not my law partners. Is that correct?
I said that the document admitted that they have never been my law partners. The description of their association with me is contained.
Yes or no is kind of the
contained.
question.
I said no, but what I was trying to tell you is that I'm telling them that the agreement.
Objection, Your Honor. This is a real yes or no
He can-
question.
I have the
Did
right
you
to
say
explain my
that
answer.
you were
Yeah.
not their law partners?
He can say yes or no and explain to the extent that explanation is
So
relevant.
did
to his
you
answer.
say to your kids, note that they admit they have never been my law partners 5 hours after you signed the settlement agreement?
Yes, and that's the truth.
Okay,
We're not,
that's all I'm asking.
well, let me explain. They were not my law partners. I partnered with them on individual cases. I partnered with them in an office sharing arrangement. I partnered with them on a lease.
This is just
And so-
extraneous.
He's got you on cross.
I have the right to explain.
But I'm not asking you.
Well, you
Anything
don't
about it,
want me
did
to
you
explain. Let me finish and we can move on, Drew.
On this
Andrew.
point, Mr. Wood, I think it's a very targeted question. You've answered it, you've explained it. We'll move on to the next question.
Yeah, I would, if I might just, I was.
No,
You
Your
said we're
I
gonna move
was-
on to the next question.
I was reflecting what the
No,
agreement said.
Okay. you've
We all
answered the
know what
question.
the agreement said.
I do.
We're gonna keep
And
going.
were you telling your kids, hey, I wasn't law partners because you were setting in motion your plan that very night to back out of the deal on this agreement that somehow they weren't in your firm? Was that your intent? The same
That-
night you signed the agreement?
That is, in one word, garbage. That is not my intent. And you manufacture it out of thin air. I
Okay,
wanted my children to know that while Jonathan and Taylor had been questioning my mental health and conspiring with my son about my mental health, that they had agreed straight up that they had no concerns about my mental health or competency. My son was being used, and I wanted him to know the truth.
thank you.
You're
Let's look
welcome.
at the paragraph right above it. And in this paragraph, on the third line down, we start the sentence that says, I have many more important things to do in the future for my clients, my family, and my country. But I held my false accusers' feet to the fire on the lease obligation. Did you feel that false accusers was a breach of the non-disparagement agreement of the settlement agreement that you had signed 5 hours before?
No,
You didn't. Okay.
no, I didn't. And I don't specifically point out to their names. There were other false accusers.
And
But I was talking about the fact that they had denied being responsible for the lease when in fact the landlord's lawyer agreed with
Objection,
me
Your Honor.
that they were responsible.
objection, Your
for it.
Honor.
All right, well, you asked him if he thought they were false accusers. He's answered that. Next question.
Now, you're the one who drafted the non-disparagement clause into the agreement, you and your lawyers at Alston and Byrd.
My lawyers.
Is that correct?
My lawyers drafted the agreement. I did not.
Okay. And let's look over, well, let's finish with this and then let's look over at Exhibit 102 on that language.
So you want me to stay on 303? Or
The next sentence says, they knew that I was done with them in the future because of their interference with my relationship with my children and your loving concerns about your dad. So that was your motivation in writing this. You felt that the plaintiffs had interfered with your relationship with your children, and that's what caused you to write this letter. Is that right?
in part, I also felt that they were interfering with my relationships with my clients, both my efforts for Richard Jewell and what I expected to be my ongoing efforts for Nicholas Sandman. And obviously, as I said, they were interfering with my relationship with my son, Matt. It's documented in text messages between Jonathan and Taylor and Matt.
Okay, let's look over at Exhibit 102 in the first binder and direct your attention to page 3,
Give me a second, please.
the non-disparagement
Can you give me a
clause.
second to get there? There's got to be a better way to do these binders. All right, 102. I got it now.
Page 3, number 3, non-disparagement.
Okay?
Read along with me. LLWPC and LN Wood individually agree not to disparage WGW. This agreement is not to be construed to imply or suggest that LLWPC and or LN Wood has disparaged WGW or its members prior to the date of this agreement, period. Nothing in this provision prevents the parties from prohibiting truthful information about each other and its members in response to a court order or subpoena or during any federal, state, or local government body investigation or proceeding. LLWPC and LN Wood individually do not seek in this agreement any legal protection regarding any future disparagement of LLWPC and LN Wood individually, but shall address any future false and defamatory statements by WGW and its members about LLWPC and LN Wood individually on a case-by-case basis as provided by law. Did I read that correctly?
You did.
Now, you're not telling this jury that Alston and Byrd fellows dreamt that kind of language up and drafted in the agreement a one-sided deal where you agreed not to disparage and didn't put mutual requirements on the plaintiffs. That was your idea, wasn't it, sir?
Alston and Byrd didn't dream up anything. Alston and Byrd consulted with me and drafted this agreement. With respect to the disparagement, the plaintiffs wanted that clause in. I said, fine.
But you can't
Hang on a
find
second.
a
Let me-
single
let me-
email
Honor, I'm in the
anywhere
middle of answering.
that addresses the plaintiff's
In the middle- I'm in the
desire
middle of
I know,
answering.
but I
To
I
put
think that
this
you,
language
Mr. Beal,
in
Mr.
there.
Beal, what I'm when I'm trying to clarify here, we can't just plow ahead.
Sorry.
All right. I think that you had addressed the question as asked, and now
But
Mr. Beal
not the
can
second
respond.
part, Your Honor. I said that they wanted the non-disparagement. The second part said I did not, that I would deal with them under the law with respect to any statements they made about me.
All right.
And I agreed not to disparage them, but I was allowed to make truthful information during any federal, state, or local governmental body investigation or proceeding. And I think that's what I did.
Okay. Mr. Beal.
Mr. Wood, I'm handing you what's been marked Exhibit 405 for identification. It's been all over this case, but
Is this a new exhibit?
it is indeed. Does this appear to be?
I've never seen this. I mean, I've seen it, but may I have a moment to review it before I'm questioned on it?
Well, first, let's see what the question is, and then if you need more time to answer his question,
I'm
you
gonna
can
need time to
ask for
review
more
it
time.
before I answer.
Does this appear to be your email to Matt Wood, your son, the carbon copy to Charlie Wood, and Mark and another individual with a blind carbon copy to yourself dated April 28th, 2020 at 8:18 p.m.?
Yes.
Thank you. Now let's look at the last, Your Honor, at this time, we would move Exhibit 405 into evidence.
No objections.
Thank you.
405 submitted.
May not have it. If we look at the last paragraph on the first page, Mr. Wood, and this is dated April 28th, about a month, maybe 5 weeks after you sign the settlement agreement. And it says, I am now having to make a decision on whether to pursue a civil fraud and unjust enrichment case against Sharif Azell and Rick for damages in excess of $10 million for fees paid to Sharif in DeVita, Halifax, and Lindsay cases. The agreements have been reviewed by Alston and Byrd on my behalf, and the conclusion is firm that they each violate state bar rules on fee splitting.
I'm not following you. Can you start again?
I'm now having to, you with me on the last paragraph?
I am.
Okay. I'm now having to make a decision on whether to pursue a civil fraud and unjust enrichment case against Sharif Azell and Rick for damages in excess of $10 million for fees paid to Sharif in DeVita, Halifax, and Lindsay. The agreements have been reviewed by Alston and Byrd on my behalf, and the conclusion is firm. The conclusion is firm that they each violate state bar rules on fee splitting. They are void and unenforceable as a matter of law. The same problem exists for the recent agreement coerced from me by Taylor, Jonathan, and Nicole. Did I read that correctly?
You did.
Okay, so on April 28th.
Finish the paragraph though.
So on April 28th, you were convinced that the fee split you had entered into about a month or 5 weeks before with the plaintiffs was somehow void, and Alston and Byrd had already advised you of such. Is that correct?
No.
Okay.
I was advised about the question of client consent for the first time in late April. And that, I believe, coincides with the date of this email to my son, Matt. Copied to my son, Charlie, and copied to Mark Stevens, who was the lawyer that referred the Vernon Unsworth case to me, associating me in it. When I learned about the question of consent, then I believed, based on the law that they gave me under Rule 1.5, that the agreements were void. That's the law. And that the only way that I could try to avoid just simply the agreements being void
Objection.
would be to get
It's
client
just
consent before the money was paid. So I was looking into, and that's the very reason that explained why Alston and Byrd found Rule 1.5 in April. I was asking them to look at what had gone on with respect to Rick Miller and Sharif Azell in the DeVita, the Halifax, and the Lindsay cases.
Okay. And the reason you brought that up is because you didn't know whether it was a state bar violation for you to pay millions of dollars to a lawyer who wasn't working on the case, wasn't part of your firm in any way, and in some cases that your own client didn't even know about. You were confused about that, right?
That's just absolutely nonsense. That's not the truth at all. Ask
Okay.
me a question.
So you did know that it violated state bar rules when you did it,
No, I did not.
and you did it in order to get the 20 million.
No, I did not. I was going to get my share of that money regardless of what Cherie got. The money was owed to me under the agreement with Marlon Wilbanks and the clients. What I decided to do with Sharif Azell, known to Marlon Wilbanks, was my business. He agreed to it.
Okay.
The point, wait a second. So the point is, you're
Well,
saying
Your Honor,
that,
now.
you're saying that I knew something on April the 28th. I had just learned at that time about the problems or issues arising from Rule 1.5. It had not been addressed by me, my lawyers, by you. Nobody addressed it until we raised it in April, late April, in response to my asking them to help me look at the situation with Rick Miller and Sharif Azell on the DeVita, Halifax, and Lindsay cases.
Well, just to be clear,
before
you
that.
never
Just
to be-
asked
just to
me
be-
No,
about,
you're repeating yourself, Mr. Wood. We're going to stay responsive. We can't.
you never asked me about this crazy deal with Sharif Azell, did you?
No, of course not. It wasn't any
Okay, because
business.
I would have told you that.
Okay,
Well,
Mr.
right,
Beal, you're not a witness.
Right. Let's look over at Exhibit 76.
I didn't consult with you on any legal issues, sir.
Thank you.
Not then,
Let's look
not
over at
now,
Binder
not ever.
1 on Exhibit 76. Okay, I'm getting it in. Does this appear to be
I'm
your
just,
email?
hang on a second. I just got there.
Mr. Beal, you can ask your question, and then Mr. Wood can decide how much time he needs to answer it.
Thank you. Does this appear to be your email to Taylor, Jonathan, and Nicole dated April 16th, 2 days before you wrote that email to your son, in which you talk about the scheduling of the probate court hearing?
No, I wrote my son on April the 28th. This
Oh,
is
you're
an
right.
email
It's
sent, excuse me.
12 days,
This,
not 2 days. Yeah, you're right.
thank you. This is an email I sent on April the 16th to Taylor, Jonathan, Nicole, copying it to Joey Burby on the status of what was happening and might happen in terms of the consummation of the Sandman case. This is my email, yes.
And
And it also dealt with the lease.
Julie Sandman had already been appointed as conservator of her son's estate at that time.
I did not know that. I didn't have anything to do with the probate that was underway in Kentucky. Once it was delayed and I found out it was not going to be done by telephone, and I informed everybody, Todd McMurtry handled that as he testified in its entirety. I had no idea that Julie Salmon had been appointed executor. He didn't tell me.
Okay.
I didn't know it.
Your Honor, at this time,
Or-
we're
or
moving
appointed
Exhibit
guardian.
76 into evidence.
I misspoke. She had been appointed, I'm told, by you that as guardian.
All right, is there an objection to item 76?
No objections, Your Honor.
It's submitted.
Thank you. Now let's look over at Exhibit 79.
Okay?
Does this appear, this one already in? Okay. Does this appear to be your email to Nicole, Jonathan, and Taylor dated April April 29th, about 10 days or so after the last one, discussing the scheduling of the hearing.
I said, WGW, please see below regarding the consummation of Sandman versus CNN settlement. And there's some attachment to a PACER document. Todd has been exclusively handling and negotiating this aspect of the case. It appears that the consummation will now occur on or close to July 31. I will keep you posted as to any further developments. Let me know if you have any questions. Lynn, I wrote that.
And all of that, at the time you wrote that, the agreement had already been made to wait till Nicholas turned 18 on July 24th. Is that correct?
I don't know the date that Todd reached that agreement with CNN, so it may have been before April 29. It may have been after. My recollection would have been that it was afterwards that Todd told me that he had reached an agreement with CNN that they were going to wait and distribute the settlement proceeds on Nicholas's 18th birthday because CNN felt that that would further enhance the confidence.
That's hearsay, what CNN felt.
He's asking me about CNN
No.
and
All
Todd.
right. We confine yourself to the question asked. Mr. Bill, maybe
Thank you.
repoint your question if you need to.
And in this email, you write directly to Nicole, Jonathan, and Taylor, even though I was representing them at the time. Is that correct?
I did. I'd done that once before out of what I thought was a sense of urgency to keep them apprised, and I should have copied you on it.
And you know that it's an ethical violation for a lawyer, and back then you were still a lawyer, to
Still am. It's
contact
not
clients directly when the lawyer knows the clients are represented by counsel. I believe your lawyer talked about that on direct, but you wanted them to have this. Is that right?
I wanted them to have this as soon as I learned about it so that they would be fully apprised of what Todd was doing with respect to the consummation and the probate proceedings in Kentucky.
Okay.
Did I technically violate a bar rule by not copying you? Yes, but it was
Not
information.
copying me, right? You have to go through me,
You
not
were,
copying them directly
you,
at all. Isn't that correct?
it depends. It depends on what your position is. You were aware that I had written them directly back when I told them about the settlement, the consummation being delayed in probate court because it was not going to be done by telephonic means. I copied you on that. You knew the substance of what I was saying. I was trying to be helpful and informative. If you believe that I violated an ethical rule, then you knew it at the time and you didn't say one word or do one thing about it. And
Isn't it true, Mr. Wood, that I repeatedly admonished you, just as you've been admonished in this court, to stop trying to communicate directly and exert pressure over these three plaintiffs?
All right. Jury will disregard any
Sorry.
directions
hold
from
on,
this
sir.
court. You can rephrase your question, Mr. Beal.
And did you communicate directly with them because you were trying to continue to perpetrate the fraud and you didn't want to go through me and involve me filtering your communication?
Objection, Your Honor.
On grounds.
Testimony.
All right. Overruled. You can answer the question as you understand it.
If I understand it, your question is errant nonsense. There was no fraud. Everybody knew what was happening. I was trying to inform them about the delay in when they might receive the money. That's not part of a fraud.
Okay.
That is errant nonsense, and I disagree with your statement.
Thank you.
Not supported by any
Let's
fact.
look at Exhibit 79. You say Todd has been exclusively handling and negotiating this aspect of the case. It appears the consummation will now occur on or close to July 31st. But you knew that wasn't true because he was going to turn 18 a week earlier and you were going to deny any payment 8 days earlier than July 31st. Isn't that true?
More errant nonsense. It is not true.
Okay.
You're making it up. You're connecting dots that don't connect.
Let's look over at Exhibit 92. And I'm going to direct your attention to page 3. Oh, Your Honor, at this time we would move. Did we move 79 in? At this time, we would move Exhibit 79 that he testified to into evidence.
Objection to 79.
Hang on. 79? I thought it was 76.
Well,
where
we
do you-
did 76, then we did 79.
Okay.
It's the email.
No, I don't see, no objections.
79 submitted.
Okay? Your question?
Oh, sorry.
Not at the
Yeah,
moment.
yeah, I'm sorry. I forgot what I was going to ask you. So in Exhibit 92, does that appear to be a multi-page email exchange between you and Joey Burby?
Yes.
Okay,
Well,
and on
hang
the
on,
third
hang on a second.
page,
Hold on. Yes, Joey Burby.
thank you. Your Honor, at this time, we'd move Exhibit 92 into evidence.
Objections, Your Honor.
92 submitted.
Okay, and we look up here at the top of the third page, and you are emailing Joey on Friday, June 19th at 1:19 in the afternoon and say about his bill, no write-off requested or necessary. Anytime Monday works for me on my cell. Don't keep me in total suspense all weekend, exclamation point. Is Sandman enforceable with the usual, enforceable, it unenforceable, paren, with the usual caveats, exclamation point, question mark. Thanks, Joey. Signed, Lynn. Did I read that correctly?
Yeah, I mistyped. I said, is salmon enforceable? It. I should have written or.
Right.
Yes, I was absolutely looking for an answer from them about the status of salmon based on their research that they had begun in late April. I wanted to know what the deal was, and they were supposed to tell me, and they ultimately did, that I had to have client consent.
Let's look back at Exhibit 79.
Okay?
Oh, that's right. Okay, thank you. Okay. Now, on Exhibit 79, you're saying you're going to keep them apprised, and you think it's going to be July 31st when there will be approval to disperse the money, even though at that time you knew that Matt was going to get it. Excuse me. Even though at that time you knew that Nick would be 18 a week earlier, and the plan was for him to receive the money a week before the date set forth here in Exhibit 79. Is that correct?
No,
Okay.
I didn't know the status of what Todd McMurtry was doing with CNN. He told me in general terms but he did not tell me until he finally reached an agreement with CNN. So I was speculating that it could be closer to July 31st, but I didn't know it.
But if we look back at exhibit 408, 405,
Wait a second, 405?
it's the loose one that I just handed you.
Oh, okay.
On April 28th, more than 2 months before, you said you knew that the agreement was unenforceable.
What agreement? Point me to what you're asking me.
Didn't you say on April 28th in your email to your son that the
And to Mark Stevens.
agreement was unenforceable 2 months before you wrote this, talking about, oh, soon we'll get the money and be able to disperse?
I don't see what you're talking about. I talked about, in that email, I was talking about Sharif Azell and Rick Miller in relationship to the DeVita, Halifax, and Lindsay cases. I don't see any reference whatsoever to the Salmon case. So your statement is wrong and misrepresents Exhibit 405.
So Exhibit 79 is written on 4/29. The day before is Exhibit 405. And you were writing to your son saying the agreement is unenforceable the day before you wrote this email saying, well, we'll wait till July 31st.
That's just a lie. I wrote him on April the 28th at 3:18 p.m. did not address Sandman. You've read it. It talks about DeVita, Halifax, and Lindsay, and Sharif Azell and Rick. What I wrote the day before, what was the other exhibit number? Well, what I wrote on April the 29th with respect to what I wrote Wade, Greenberg, and Wilson and copied Todd McMurtry was about the Sandman settlement, where I said Todd has been exclusively handling and negotiating this aspect of the case. You're trying to intermingle my communication on Sandman with separate communications about Halifax, DeVita, and Lindsay.
Okay,
That's
well,
not,
read
that
along
is,
with me on this. The same problem exists for the recent agreement coerced from me by Taylor, Jonathan, and Nicole. Did I read that correctly?
you did. The same problem exists. I
So
didn't.
a day before you wrote them and said, wait 2 more months to July 31st, you had already concluded that the agreement was unenforceable.
No, in fact, that you just brought out where I was asking Joey Burby to give me an answer. It had been raised with me at the very end of April, as I've testified consistently, and it's shown by these documents, by Joey and Chris about the problem that may exist with Rule 1.5. I didn't have an answer from them. I wanted to get an answer.
All right, let's
And
look
so-
over
and
at
so-
volume
and so-
2, Your Honor.
And
Going on. I mean,
Yeah, at that point, I think he's
Just
been
before.
responded to the question. All right, Mr. Beal.
let's look over in volume 2. So we're going out of volume 1 and into volume 2. Do you see Exhibit 274?
.274 Center State,
Yes.
I do see it.
Does this appear to be a bank account statement
It's a bank account statement of
from
IOLTA account.
August 2020 for your IOLTA account?
It is my L. Linwood PC IOLTA account, which is a trust account, escrow account, that lawyers are required to have, and it's dated 8/2/2020.
And does this appear to reflect the money that came into you from, 274? That came into you from the Washington Post settlement into your IOLTA account, account number 0790?
I don't know. I mean, it's redacted. It shows that there was a payment. There was some payment with respect to somebody, John Olesko, Tarsus Medical Group, refund of retainer. And then below that, it says WTCR, assume that means wire transfer credit, Todd McMurtry. Interest earned, interest will be transferred on 8/3/20, but I don't have, it's, the other part of it is redacted. So I don't know. It may be, it may not be. I wouldn't be able to answer you definitively under oath until I see what's you've redacted.
No, I think that's CNN. That's CNN. So you got to keep looking. The March payments, where you took Carboni and Lindsay for some reason. Thank you. So let's look over at Exhibit 275. Does that appear to be your August statement from Center State Bank for your operating account ending in 0808?
This is in fact a true and correct copy of my Bill Linwood PC operating account. Statement date 8/2/2020.
Your Honor, at this time, we would move the redacted Exhibit 275 into evidence.
Objections.
And does this on page 2 under miscellaneous debits show on 7/30 LLW attorney's fees Sandman WP XX 0808?
Yes, I don't know.
That shows
I don't
that
know
you
what-
were
I don't know
moving
what
the attorney's fees from
don't-
the Sandman Washington Post matter from your
Okay.
operating account to your personal account on 7/30/2020. Is that correct?
I'm assuming Salmon WP does refer to Washington Post, and I would think that it does. Hold on one second.
And for the purposes of the record, 275 is admitted.
Thank you, Your Honor.
I'd have to go back and refresh myself because the Salmon reference is under a miscellaneous debit, not a deposit.
But it'd be fair to say that this document refreshes your recollection that you transferred the Washington Post money from your IOLTA to your operating, from your operating into your personal account on or about July 30th, 2020. Is that correct?
I don't know. It shows that was done on miscellaneous debit from my operating account. Doesn't say what I did with it, but I can tell you what I did with it if you just ask me.
You did move those funds to your personal account on or about July 30th.
I would expect that what happened is that I received my share of the Washington Post fee from Todd McMurtry. That was a fee owed to L. Linwood PC. It would have been my normal practice for him to put that into my escrow account, and then I would disperse from the escrow account. And here, the fee was the fee of L. Linwood PC. And so I put it in my personal account. Doesn't matter.
Okay.
Put it wherever I want to. It was my money. It was L. Linwood PC's money. That doesn't mean I didn't have the money to pay them if Nicholas had signed the agreement. I was ready to pay them.
And that was the
Money, the
Washington
money was
Post.
always, the money was
funds.
always available
Okay,
to pay them if Nicholas did not object to the fee division.
let's look over at exhibit, 284. And does this appear to be, an August statement, checking account statement for Center State Bank, for your IOLTA account?
Yes.
Thank-
8/31/2020.
All right, and at this time, Your Honor, we would move, well, let's do both of them at the same time. Let's look over at 285. Does this appear to be the same time period, same bank, but your operating account?
Yes, well, no, say that again. This is an IOLTA account statement. And it shows a debit related to something, DD account. It shows a deposit, WT, I'm assuming wire transfer credit from Todd McMurtry on 8/3.
And that would be
It's
the
not-
CNN,
It's not,
the Sandman versus CNN settlement coming in about 5 days after the Sandman versus Washington Post fees. Is that right?
I don't know. I can't tell from this. What I do know is that from what I've learned, that the Washington Post deal was made shortly before July the 24th. I think it was confirmed or finalized in terms of being an agreement with Kevin Bain, their attorney, I believe on July the 24th, or within a day or two of that. Whether the money from CNN came first or whether the money from Washington Post came first, I'm not able to tell from these documents, but they would have come at just right around the same time.
And I believe you've stated in this case, L. Linwood PC's share of the Washington Post settlement proceeds was wire transferred from Hemmer DeFrank Wessels P. LLC's escrow account
What are you reading from?
into the L. Linwood PC Center State Bank IOLTA account on July 30th, 2020. Do you remember?
I don't know
that?
what you're reading from.
Mr. Wood, let me hand you your sworn interrogatory responses in this case.
I'm sure I told the truth in my interrogatory answers.
406 or 407.
406.
Thank you. Let me hand you what's been marked Exhibit 406 for identification purposes.
Thank you.
Yes.
Were you tendering 284 and 285?
Yes, Your Honor. At this time, we would tender Exhibit 284 and 285.
Any objection?
No objections to 284 and 285.
Submitted.
Your Honor, at this time, we would tender Mr. Wood's interrogatory responses as Exhibit 406.
Well, what,
Do you have any
this
objections?
goes, this interrogatory response goes well
Let's-
beyond.
Yeah, let's see if it actually, what you do with it, and I'll go from there.
Okay.
You can,
Retender if it's appropriate.
you can put it in.
Okay, well, then we'll say 406 is admitted.
Thank you. And read along with me in the response to interrogatory number 1. L. Linwood PC's share of the Washington Post settlement proceeds was wire transferred from Hemmer DeFrank Wessels PLLC escrow account into the L. Linwood PC Center State Bank IOLTA account on July 30th, 2020. Amount confidential. On the same day, the CNN settlement proceeds were transferred to the L. Linwood PC Center State Bank operating account and used for payment of L. Linwood PC's expenses and for Mr. Wood's partner's draw. Next paragraph, L. Linwood PC's share of the CNN settlement proceeds was wire transferred from Hemmer DeFrank Wessels PLLC's escrow account into the L. Linwood PC Center State Bank IOLTA account on August 3rd, 2020, amount confidential. On August 4th, the CNN settlement proceeds were transferred to the L. Linwood PC Center State Bank operating account to reimburse L. Linwood PC for expenses incurred over the case. Mr. Wood's partner draw from settlement proceeds was transferred to his personal checking account on the same day. Did I read that correctly?
You did read that correctly, and that refreshes me
Okay.
to better understand these statements you put in front of me. Those statements in 406 that you just read are absolutely true. I had the money. I could have put the money back into my IOLTA account or my operating account and paid them if they had ultimately provided what Nicholas asked for, and then he had consented. I had the money to pay them. Nobody was hiding money.
Okay.
I could have put it right back into my law firm
I got
and paid him, but they never got his consent.
repeating them. All right. I've got two more bank account statements, and then I promise we're done with bank account statements. So let's try and knock these guys out together. Exhibit 283 and 284.
284 has already been admitted.
It's just 283 by itself. All right. It's just 283. Does
No,
this
I hate to
appear-
slouch, but my back when I sit up, I just don't want anybody to think I'm rude when I have to slouch, but it takes some of the pressure off my back.
Noted. Mr. Beal?
does this appear to be your March Center State IOLTA account
What, I'm sorry, what number?
283? Does this appear to be your March IOLTA account statement?
Yes,
And is an IOLTA account another name for an escrow account or trust account?
yes, the bar calls it an IOLTA, but it's in effect a trust or escrow account.
Right. And that's where you put client money that you may have an interest in or other people may have an interest in, and then you pay it out to your operating account or somebody else's operating account as required. Is that right?
Yes, it's an IOLTA account, not a trust or escrow account, because the state bar requires the lawyer to have an IOLTA account so that any interest on funds in that IOLTA account are paid to the state bar, which they then use, I think, well, I don't know what they use it for, but interest in an IOLTA account under state bar rules is paid by the bank to the State Bar of Georgia. That's
Got it.
the reason for the IOLTA account requirement.
Thank you. And it stands for interest on lawyer's trust account.
Sounds like you're right on the money on that one.
Okay. And so would it be fair to say that this exhibit, well, I would move to tender exhibit 83, 283.
It's admitted.
Well, this has some reference to monies in the Carboni case.
Right. And that's what I'm going to ask you
Probably
about.
should be redacted, but that's okay.
Objection.
It's admitted.
Thank you. And Mr. Wood, when you look at it, does that show that the Carboni and Lindsay money was received by you and paid out to Stacy Godfrey Evans LLC and to yourself on or about February 26th, 2020?
It shows that doesn't show what, I don't know. Because of the redactions, it's hard for me to figure out what is going on.
Well,
here.
I can take
Well, let me just
you
tell you,
through it,
I
but in general terms,
I
do you
would have
remember
paid-
at the end of February?
I would have paid the clients the net proceeds. Looks like Stacy had expended some expenses while she was with Wargo and French. And it looks like I paid those expenses to Wargo and French. And then I paid to Stacy Godfrey Evans LLC her share of the fee that we had agreed upon when I associated her to work with me on the case.
Okay. And may I approach, Your Honor?
Yeah.
I just, can you blow up that for me right there, that entry on 426. I'm going to direct your attention to 426.
Okay.
Is that where the line item says
I think you meant 226. not
226, sorry,
426.
February 26, attorney's fees payment to LLW Lindsay or LINDS. And then it's got account numbers listed there.
Yes, I agree with you.
Okay, so you took all of the 42,750 referenced in the settlement agreement on the Lindsay case on or about February 26th into your personal account. Is that correct?
I'm not sure it shows that here, but that's likely what I did because the money belonged to L. Linwood PC. I had the right to draw it out from my own earnings. And I had agreed subsequently to pay them from those cases, and I had the money available to put back in to pay them if Nicholas Salmon had signed the agreement. But with respect to the Carboni case, I did not have to reimburse them from that case because the Carboni and the Lindsay case, the fees that I agreed to pay them did not exceed the $285,000 that they had agreed to pay me. So when Lindsay settled and when it was consummated and Carboni was consummated, the L. Linwood PC share of those cases totaled something around $150,000. And what the amount I agreed to pay Wade, Grunberg, and Wilson, I would have deducted per the agreement of March 17th. I would have deducted from the $285,000 that they owed me. And that was in the agreement. They understood what I was doing and they agreed to it. Nothing was done nefarious here at all. It was all in the open.
So it's your testimony here today that somehow you signed the settlement agreement on March 17th, promising to pay them a portion of Lindsay and Carboni, and somehow you communicated to them that you had already taken that money and it was not going to be paid to them.
That's not what I said at all, and that's not accurate. You just
Okay, so it would
you
be
just make it up.
it would be fair to say they had no idea you had already taken that money when they signed the contract entitling them to receive that money. Is that right?
I don't know when I told them the funds were received. They were aware of the settlements. They were aware of the amounts that were owed to L. Linwood PC in both of those cases. And we agreed on March the 17th that they would receive a certain amount from those cases. They knew on March the 17th, if not before, but when they signed the agreement, that I would be able to apply the monies I received in Carboni and Lindsay toward the $285,000 that they had agreed to pay me in terms of what they owed the landlord on their share of the lease. That's simple.
Okay,
and to
so
the
let's
point.
look over at Exhibit 262. Now, I believe this one's in evidence. And does this appear to be my transmittal letter to your lawyer at the time, Chris Marquardt, saying, here is a check for $13,309.69, excuse me, $13,449.69 for your share of that class action case you testified about, the Grogan's case? No, DirecTV was. Okay.
What's the question?
So did you receive this check mailed from me in December of 2020 for $13,449 regarding your share of the Grogan, your share of the, was it Grogan? Grogan versus Aaron's litigation.
So if my recollection is right, and I think it's confirmed by the March 17th agreement, I agreed that Taylor or Wade, Grunberg, and Wilson would receive 80% of the Grogan fee. That was a case that Taylor had brought to L. Linwood PC. I gave him 80% of it.
Right.
And it looks like this is my 20%, which is $13,000.
Right.
And I'm sitting here today, and do I recall receiving the check? No. Did I likely receive it? Of course.
Okay.
I don't know what I did with it. I would have
Okay.
done one of two things. I know there was a check sent to me at some point in time that I never negotiated, but I likely would have negotiated this check because that amount of money was still owed to me, plus to cover the $285,000 that they agreed could be deducted from what I agreed to pay them, so that the landlord could receive the $285,000 so that they would have a buyout on the lease, which they signed on.
So the answer to my question is yes, you got that check.
I don't have any recollection that I did not get it. I assume I did get it.
And you said, I think,
I don't think Joy
in
would
that
have
narrative that you likely would have cashed it. And I'll represent to you
Oh.
that it was indeed cashed.
Then thank you for the representation. I would have cashed it. I would have deposited it likely into my L. Linwood PC
I
account,
think you asked the
because
question.
it was money received out of their share, money received by the 80% I gave them. And I had the right under the agreement to apply that money to the $285,000.
Mr. Wood, you said that three
they owe-
times. We understand.
I don't
We
think
got
you-
it.
I don't think you do.
All right. The question was whether the check was cashed. You responded to that question. Next question.
And did you at any time, through your lawyers or otherwise, inquire whether the plaintiffs had gotten some kind of special consent from the client to share these fees when they were no longer in your firm?
I don't know if they raised that question with their client or not.
Okay, let's look over
Now
at
I know-
Exhibit
now I-
263.
Now I know that if they didn't, they should have.
Right. And does this appear to be my July 9th, 2021 letter to you remitting expenses from another case?
You know what case this is on? Maybe it would be easier. Was this a case that was covered in the March 17th
Yes, is
agreement?
this the Cordova versus DirecTV case?
Cordoba was the case that Taylor had when he left his firm in Marietta and joined as an associate at L. Linwood. And at that time, I agreed to give him 80% of the fee and 20% to me. That split, I think, was confirmed in the March 17th agreement.
And you accepted that check in the amount of $35,704. Is that correct?
Yes, and applied it to what they owed me so that I could pay their share of the $285,000 that they owed the landlord for the buyout.
Right. But you never inquired at any time, hey, did you get special consent for the division of this? You grabbed that fee off that contingency case and cashed it. Is that correct?
I didn't grab a fee and I didn't cash it. I likely deposited it,
Okay.
but it would have been the responsibility of Wade, Grunberg, and Wilson that they had received the consent of the client. It was Taylor's case. I didn't have any reason. It wasn't raised that they didn't have consent. They sent the money. I would have assumed that they had gotten consent.
And if we look over at Defendant's Exhibit 69, never mind. save some time and cut that out. Let's look over at Plaintiff's Exhibit 270.
Okay.
Does this appear to be your letter to Weinberg, Wheeler, Hudgens, Gunn, and Dial Law Firm on November 2nd, 2016?
Is Bonnie Wilson's Taylor's mother? Refresh.
Tell me the best of your recollection.
Well, I mean, I think Bonnie Wilson is Taylor's mother.
Bonnie, can you stand up for us? That's Bonnie Wilson.
That's Taylor's mother. Yes.
Okay.
I sent this letter to David Dial at Weinberg, Wheeler, Hudgens, Gunn, and Dial because Taylor asked me if I would help him represent his mother in some type of a dispute with her former employer, Weinberg, Wheeler, Hudgens, Gunn, and Dial. And I agreed to help him and her. And I sent this letter.
Okay.
I don't know if I wrote it. Taylor may have written it. I may have just signed it.
Your Honor, at this time, we would offer Exhibit 270, Plaintiff's Exhibit 270 into evidence.
Objections.
270 submitted.
And if we look at the third paragraph on the first page, the facts underlying this dispute are simple. WWHGD hired Bonnie and agreed to pay her 20% of actual collections on all work originated by Bonnie and performed by others. It's hard to oversimplify this issue. Bonnie originated the work, others performed it, and WWHGD made actual collections but refused to pay Bonnie 20% of those collections. Bonnie earned these payments the moment she originated the work. Did I read that correctly?
Yes, and that refreshes my recollection that this letter was actually drafted and written by Taylor, and he asked me to send it out under my signature because I knew lawyers at Weinberg, Wheeler, Hudgens, Gunn, and Dial, and I think he felt like the letter being signed by me would have more impact on them in terms of their reaction than it would signed by him, Bonnie's son. So I agreed to help them.
Okay. And so in representing a client in dealings with another law firm here in Atlanta to collect a substantial amount of money that she had earned, in your opinion, you wrote this letter, correct? Yes or no?
I'm trying to look at it, if you're gonna give me a second. I don't know what the amount of money at issue was, number one.
Okay. Well, let's look at page 2,
Let me-
paragraph.
So this letter, I'm right. This letter was written, drafted by Taylor Wilson. And I agreed to sign it. Because I see here where it makes reference to Rule 1.5E, he says does not apply to this matter. The question, as I recall,
Your Honor, this in
Yeah,
response to
we got to stick to question and answer here. So,
well, I need a question. I'm trying to answer it.
well, let's wait for a question then. Here it comes.
Throw it at me. Here it comes.
This letter is approximately 5 pages long. Is that right?
The signature line is on page 5.
Yeah. So you were successful in collecting money on behalf of Bonnie for her legal fees that you contended she earned at Weinberg, Wheeler, Hudgens, Gunn, and Dial. Is that correct?
As I recall, she was asserting a claim for fees.
Objection, Your Honor.
That's not responsive.
I don't-
Were you successful in getting fees? And if there's anything relevant to that point, you can make it.
I was successful, and based on what Taylor presented to me, I thought she should be successful because her agreement was based on actual fees received while she was employed at that law firm.
Okay.
That ain't anything like what we're dealing with here, but the
Objection,
answer is
Your Honor.
yes.
That's just his
I think
narrative.
she got it.
All right. You can take.
All right, let's look
I
at
was
the
kinda-
first
right.
full paragraph on page 2. Rule 1.5E does not apply to this matter. It does not apply on its face, and none of its policy rationales were meant to deal with this situation. Quote, a division of a fee between lawyers who are not in the same firm, underline, may be made only if, ellipses, end quote. Bonnie was a lawyer in the same firm when she originated the originated work. And this rule, therefore, has no bearing on these facts. There are several policy rationales for Rule 1.5E, and all of them are intended to protect the client from padded fees. The rule is simply not intended to govern the division of fees between lawyers within the same firm, partners, associates of counsel, or otherwise. It was not intended to shield a law firm from abiding by the terms of its compensation packages with its own lawyers. Did I read that correctly?
You did, and I think it's very,
Thank you,
I
Your
think
Honor.
it's
I
very
mean, that's a
significant
yes or no
what Taylor
question.
said there.
It's a yes or
And
no.
it supports the
All right.
position we take here.
And then the next paragraph, the commentary to Rule 1.5E confirms that the rule does not govern the division of fees between lawyers who are or were in the same firm. This is true whether the lawyer was in the firm at the time the case was originated, but not at the time it was resolved, and where the lawyer was not in the firm at the time the case was originated, but was at the time it resolved. Comment 8 expressly provides that, quote, paragraph E does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm, period, end quote. Bonnie was associated with WWHGD when she performed work satisfying her compensation agreement with WWHGD and entitling her to payment. The work done for her origination, the work done was her origination of the originated work. The event triggering payment to Bonnie was the collection of fees on the originated work. Did I read that correctly?
You did, is there a question other than did you read it correctly? Because it's not,
That's my question. Did I read it correctly?
you did.
And the date of the letter is November 2nd, 2016. Is that correct?
It is, and it was dealing with,
Objection, Your Honor.
Yeah, you can take that up on redirect.
Right.
would you make a note?
So as far back as 2016, you were aware. Strike that question. Let's go to the last page of that. Is that your signature? Sincerely, L. Lynn Wood. That's my question. Is that your signature?
Says sincerely, L. Lynn Wood, and I signed it Lynn, because I knew David Dow. He was a
Good.
friend.
Thanks. So as far back as 2016, you knew that Rule 1.5 could not relate to the division of fees for lawyers who were previously associated in a firm.
Yes.
Isn't that correct?
No,
You didn't know?
no,
And this
Wait a
5-page
second,
letter
may I have the right to
does not
explain the answer?
refresh your recollection
May I have the right to
that
explain the
you
answer,
were
Judge?
intimately
Response to this.
involved.
I can't get, I start to answer it and then he starts another question. I have the right under law
I understand
to
that.
explain my answer
I
and I'd like
understand
to
that.
have it.
He's asking
Record.
whether this letter refreshes your recollection. You can go from there and explain.
And the answer is yes and no. It refreshes my recollection that I signed this letter trying to help Taylor in the dispute that his mother had with respect to her prior employment with Long Weinberg and Long Weinberg, they changed the name. It used to be Long Weinberg, Ansel and Wheeler. I believe Taylor wrote this letter. I didn't do any research on it. Taylor would have done it. So Taylor knew about 1.5. And it refreshes my recollection in that Taylor's mother was in that firm at the time she made an agreement regarding how she was going to be compensated on monies that she had generated cases on and the monies that were actually received. That's totally different from 1.5 and what Joey Burby and Chris Marquardt told me in terms of how it applied to this case. Two different factual
Now
situations.
it's going way
Well,
off.
we just reached it. There we go.
All right.
Now let's keep going.
So when you say Taylor Wilson was aware of it, he was aware that Rule 1.5 would never have applied to this situation that we're here today.
No,
Isn't that correct?
No, absolutely. If he looked at 1.5, he would have known that it did apply because he was not part in my firm at the time the agreement to divide fees was made. So he knew better. He knew that he was not he was not in my firm at the time the agreement was made to split the fee on March the 17th. So he had actual knowledge that our position is right.
Does the phrase for work previously done mean anything at all to you?
What does it
For
mean?
work
Help me out. What does it mean?
Previously done? We just
You
read
just-
it's comment 8 to Rule 1.5.
You've cherry.
It's been all
Okay.
over this case.
Mr. Wheeler's like,
Here's what, here.
it's a long question. I don't even know. if we
I can
get
try
into
to
that.
handle it, Judge.
My
Here's
question is
what?
are you aware that comment 8, as you just read from your own hand in 2016, states that the rule does not apply or regulate the division of fees between lawyers who are or were previously associated in a law firm? Does that phrase previously associated ring a bell at all? Or are we just being Freemasons to demand it?
I know you're a Freemason, so I don't know why you're demanding it, but you are a Freemason.
All right, let's focus on the 1.5
Well, he just
aspects of the
brought it
question.
up.
I know, but I'm directing you. Let's
True
focus
Bill
on
is a
the
Freemason.
1.5 aspects of the question.
So if I understand the question, and I did not do the research, but from what Joey Burby and Chris Marquardt told me in terms of Rule 1.5, that the question is whether the parties were in the same firm at the time the agreement to share fees was made. On March the 17th of 2020, by their own admission, Wade, Grunberg, and Wilson were not in the firm of L. Linwood PC. They had in fact been terminated and had terminated themselves on February the 14th. So I now know what Rule 1.5 says, thanks to Joy and Chris and my ability to look at it. What Taylor came up with here does not at all, in fact, it's consistent with the rule itself. The question of the applicability of the comment, that's an issue of law, not an issue of fact.
Previously
from there,
associated
Mr.
in
Beal?
a firm
Mr. Beal, checking in, you're at 2:15. How much longer do you believe you have?
is my last thing,
All right.
last hurrah.
Then could we get a break, Judge?
Do
You're last.
you remember the pleading filed at Exhibit 407?
Oh, goodness.
Just in general, I'm not going to
I-
get specifics.
I
I'm
don't-
looking only at the signature lines.
I don't think I've ever seen this exhibit before, this pleading. And I'm not on the signature line. This appears to be something done by Todd McMurtry in the federal court case in Kentucky where Nicholas's case was pending against CNN. And you'll note that on page 3, while Todd McMurtry does a /S, which is confirming a signature, my name is listed L. Lynn Wood Pro Hoc Vici, because I wasn't a member of that court, and it does not contain a signature line. I never saw this document. This was done by Todd about the question of what the status was. Judge Bertelsmann wanted to know, I'm sure, what was going on with the case since he had granted our motion on reconsideration on the motion to dismiss order he had previously filed.
And this is the document that shows that the agreement was that Julie Salmon was appointed guardianship on April 13th.
I knew nothing about her being
Okay.
appointed. The document says what it says. I don't deny what it says. I'm telling you, I did not get it, and was not aware that she had been appointed guardian. But so what? It ended up being resolved where Nicholas didn't need a guardian because it was resolved when he was 18.
All right, Your Honor, at this time, we would introduce Exhibit 407.
Any objection to 407?
I thought we had your last two wrong a minute ago.
Did too. Any objection to 407?
Hang on. No objection.
407 is admitted.
Thank you. Mr. Wood, I've handed you with what's been marked 408. Does this appear to be a kind of routine pleading filed in federal court in the Eastern District of Kentucky, Northern Division, on behalf of Nicholas Salmon?
It's a request for oral argument. Is it routine? I don't think it's routine for a
Okay.
party to move for a court to reconsider an order it had just entered. So
Right.
it was out of the ordinary, but clearly,
It's
It's
a
an
pleading.
or-
That's all. I'm
clearly-
trying to get.
clearly it's a pleading requesting oral argument.
Your Honor, at this time, we would move Exhibit 408 into evidence.
Objection to 408.
All right, let's look over at
Well, I
page
didn't,
2.
I didn't hear him.
Oh.
Is there an objection to 408?
No objection.
Submitted.
I'll look over at page 2, and you've got the signature block there. And it says L. Lynn Wood PC at the top. Is that correct?
Yes, and
And
it's,
then you've
well, it
got
says him,
three,
you know, actually,
identified
actually,
underneath. You've got L. Lynn
You
Wood.
can wait for a response to the question. You'll have time to respond, which I need to
if I
say.
may, he asked me, at the top line, it's two firms, L. Lynn Wood PC, Hemmer DeFrank Weasels P LLC.
Right, and under the Linwood, you have 3 lawyers listed.
Yes.
Or excuse me, 4. L. Linwood, Nicole Jennings Wade, G. Taylor Wilson, and Jonathan D. Grunberg. Is that correct?
Yes, they had associated with L. Lynn Wood PC to help me on this file under a fee sharing agreement, which
Okay.
unfortunately we had not reached at the time.
All right,
We
we're
had
beyond,
not-
we're beyond the question there. Anything else, Mr. Beal?
And each one of these has the same email domain, linwoodlaw.com.
It would have
Is that
been,
correct?
yes, it would have been routine for us to list them under a signature block like this on any pleading where they had agreed on a case-by-case basis to work with me on a file.
So all of the website that you put out and all of these representations to federal and state court were truthful and accurate as a lawyer and member of the bar. Is that correct?
As a lawyer, as a member of the bar, as an honest human being, they were my partners on a case-by-case basis. They were my partners in an office sharing arrangement. They were my partners under a lease that we agreed together. They were not my partners in terms of having any equity or ownership of my law firm. That has been explained to you a lot of times. I don't think you get it, but that's okay. I don't mind doing it one more time. I told the truth. They were my partners in an office sharing arrangement. I associated their PCs to work with mine, give them an opportunity to make some money.
Okay, now we're going back over ground we've already covered. You've
So
made your
all
position
of those representations, partners, the images that we saw on the website, all of the pleadings that were filed, all of those representations were true and accurate. Is that correct?
They were true that they were my partners in an office sharing arrangement. They were my partners on a case-by-case basis, and they were my partners in a lease agreement. They were not my partners in my firm. They had no ownership interest. They had no involvement in my firm.
And so nowhere in any of these representations have you ever said office sharing partner ever. And in fact, the first time you ever did that was in this case when you had to pay them $847,000, right?
Hold on one second. Number one, I didn't have to pay them $847,000. They owed me $265,000. So it was like $647,000 net to them. But your question is, I called them partners. They wanted to be recognized as partners to help them have esteem in the community where they might get business.
And
And
it wasn't
I agreed to
dishonest,
it
what you
because
did.
they were my partners in an office sharing arrangement. I partnered up with some of them at times to assist me in cases on a case-by-case basis. And we had a partnership on the office lease. They were not partners in my firm, and they've admitted that on March the 17th, they were not in any way affiliated with my firm. They left on February the 14th.
All right, we've heard that
done.
now several times, and I think this also has been covered already. So I think the cross-examination we're wrapping it up. Is that right, Mr. Beal? All right, that's over. We're going to take 5 to 10 members of the jury, and then we're going to come back and we're going to conclude this testimony before I excuse you for lunch. And again, that'll be an extended lunch break from there. All right?
So is my crossover?
It is. And we'll take it up once
And I may
let the
push-
jury step out,
It
and
may
then we'll
take me a little
talk.
longer than 10 minutes.
Well, let's talk about it.
Okay.
Okay, I need to cover some things before we go on. Feel free to step down.
Are all these documents new? Have they ever been identified in the pretrial order?
No,
No, it's just,
that was up to 309, but
yeah, so all this stuff, they've had it in since the pretrial order. May I step down, Your Honor?
You may.
Thank you. Don't keep me too long. I gotta go.
All right, we're taking, I know, this is very quick. We're taking at least about 10 minutes here. You're asking for longer. Is there any particular reason we need more time? Okay, that's all I'm asking for. As to redirect and the issues that we left off yesterday, based on the bullet points you've been provided, I'm going to reduce the time to 20 minutes. You can use that how you feel, but I will still entertain objections that are, if it's unnecessarily cumulative. So,
Now, but there are areas that I'll have to cover that are not in the bullet list based on the examination I just underwent. So it could be few more and it may take a little longer.
I believe that with targeted questions, and I'll allow you to lead if you need to, that we can do that in 20 minutes, especially when you've already had.
Give us a little flexibility because they brought up a lot of documents today on my cross that they've never identified in the pretrial order. And so those may require some explanation. I tried to explain them when I was testifying, nobody would let me.
Well,
have the
I
right
think
to-
there are some things that you could provide further explanation about, but I do think we heard a lot in your responses as to some of them. I'll say this, I'm going to give you 20 minutes and then we'll reflect at the end because that may not, you may have already covered it and you may not have used that 20 minutes wisely. Mr. Exum?
20 minutes.
He's raising his hand.
One sec, sorry. So if I understand, is 20 minutes is for the totality of the redirect?
That's right.
Okay, so there's not like a bifurcated.
Nope.
So you cut my direct off. I thought I was going to be allowed now to give the finishing of my direct and then would be allowed to do redirect. I never finished my direct testimony.
I understand.
Now I don't have a chance. Now I'm getting limited time, not only to finish what I wasn't allowed to finish the other day, but now I've got to go back and rebut what was brought up on cross-examination. I think, Your Honor, could we compromise and give us 30 minutes?
We're going to start at 20, Mr. Wood, because and I'll make these other findings. The direct itself, I mean, I found it in large part, it was not an effective use of time in many portions. I thought it was meandering. I thought it was not responsive to a lot of the questions. And again, I think you've been given ample opportunity to present your direct. You'd had 2 hours and 15 minutes. And I do also believe part of this is a sanction for the conduct that we've already addressed. We don't need to go back over that at this point. So we're going to start with 20 and we'll see where we go from there. Let's be back, as you promised, as soon as you're available.
Thank you, Your Honor.
Okay. But come with me. I got an idea. Michael, I want to talk to you. You grab my.
Are you guys on a break? Yeah. Or how long? It is. 10 minutes? We should wait for the lady to get back to take the comments for the intern. Yes.
Time up, I guess. Judges stop their time. For the red, it's cross-examined. They didn't stop it. But it's gonna be an hour, it's fast. He said you only need but 1 hour. You're passing out. It's here, 2 hours. Yeah, he said he did like an hour, he did that time. I said, no.
Question pertaining to the last exhibit. What was 474? I didn't catch it.
47 was a Tennessee filing for the probate court,
Okay.
and 408.
Thank you.
408 was
Thank you.
if it's helpful. So this is the part.
Oh, okay. Okay. No, no problem.
Come to order.
I'm so sorry. Trying to shut that on you.
Your Honor, can I address one matter with you, Mr. Exum, real quick?
Sure, we're on the record, I believe.
We don't need,
We're not?
no, we,
Okay.
Your Honor, some of the statements that Mr. Wood said at the end of his long speech this morning, I took that as him inviting some of his online followers to come here. And they've been posting online. I'm sorry, I'm a little pregnant, I'm hormonal. But I just asked that we increase security again. If we could do that just for safety purposes. I don't think that anything's gonna happen, but to the extent that it was some sort of invitation to come to the courthouse for people to do things, I'd really appreciate it.
Can I address that somehow?
Well, how would you like to address that, Mr. Exum?
First of all, I want to make it clear that anyone following this, Mr. Wood does not condone any type of physical violence or threats or anything like that. So stop it. To the extent you're doing that, you think you're helping him, you're not. Quit, okay? I don't want any more of this. I don't feel responsible in any way for this, but that's it.
All right, Ms. Brown, I appreciate you bringing that to my attention, and I'm going to be I'll be working with the sheriff's office to see what we need to do. In addition, if you feel like we need to arrange your entry or exit from the building in a different way, we can explore that as well. Because I agree with you that I think the phrasing that he used could be interpreted that way.
Thank you, Your Honor.
So Deputy Scott, can you come here?
You checking to see how his. Yeah. Sorry.
He's walking in there.
Justin. Yes.
Thank you, Judge.
All right.
Thank you, Judge.
Understood, Mr. Wood. So to close that loop, Ms. Brown, again, we've got options. If you're requesting maybe an escort, we don't know where you're parked, we can arrange that. You can let us know. We'll do that offline. We can also have, you don't have to exit through the normal places in the building. You can let us know your preference there. All right. All right. To that end, I believe we should be resuming here with redirect. So I think Mr. Wood, should we take the stand? And if we could bring in the jury, Deputy Scott, whenever you're ready.
Okay.
Can I give these back to Melinda? Melinda, do you want these documents back?
Could have, if we could clear the stand of any extra exhibits here.
Yes, sir.
Do you want any of our
Thank you.
binders up there?
Actually I do, because I
Hold on.
well, I want the, let me make sure I have that. One letter, here it is. No,
I may need,
One
John may
from-
need them. John, do you need any of these exhibits that they put in today?
Right now.
I think,
let's leave them
we'll
up there in case. I'll put them on the floor. I'll come
yeah,
with them.
yeah, put them here. Yeah, thank you.
That's it. What's the exhibit number was the letter from Bonnie or Lynn on behalf of Bonnie Wilson?
270
270,
in
okay.
volume 2.
All right, thanks. I thought that was right.
Ready?
Yes, Your Honor.
Thank you, Deputy Scott. All right, defense may commence with redirect.
Thank you, Your Honor. In the big binder, would you please turn your attention to, I believe, exhibit 60. uh,
What exhibit?
Hold off for now.
Lee, hang it on.
Go to D5 and I believe it's D5.
Okay,
Are we again,
can you refresh me on what D5 is?
actually D21, excuse me. It's the letter from, I think it's already in evidence. It's a letter from Jeremy Granello to Joy Burby. Email.
Yeah.
I don't have it in this folder here.
That's the new one.
That's there.
Yeah.
Fine.
Thank you. All right.
That water for me.
Yes, it is.
All right, yeah. What's the clock? Okay, yeah, go ahead.
All right. Can you read me? First of all, does this look like an email from your former counsel or the lawyer of your former landlord to your former counsel Joey Burby?
Yes, that's exactly what it is, dated June the 29th of 2020.
And can you read?
Mm-mm.
And it's can you follow me to where it says he sent?
Starting on what page?
Just the very first page. That's it. Go back to the first page.
Where are you pointing me to?
Right there.
Okay, thank you. He sent me emails emphatically agreeing with my legal assertion that his former partners would also be liable under the lease as a result of the express representations that all of the parties made in executing the lease, which was the basis for their request that they be removed and released from the lease.
Thank you. And was he referring to the plaintiffs?
Yes, what he was saying, what this was telling us is that at the initial time before the March 17th agreement, the landlord had asserted that Wade, Grunberg, and Wilson were in fact parties to the agreement, the lease, and that he was not going to let them off. And I had told him I thought that was right, and he agreed with me. And then we arranged for them to be indemnified by virtue of the agreement where they would pay me the $285,000 that they owed the landlord.
Thank you. I'd like to show you this.
Judge, we're trying to find documents. That's not going to count against my 20 minutes, is it?
I don't know why you couldn't be able to find documents.
I think we're all doing the best we can. I just want to make sure I don't get cut because we're trying to find something.
Use your time as effectively as you can.
Yeah.
Mr. Wood, does this look like the operating agreement? And this,
Here it is.
right,
That's the operating agreement of Grunberg and Wilson LLC, dated May 1, 2018, the effective date.
and is this the Grunberg and Wilson LLC that was in a partnership on a case-by-case fee sharing agreement, receiving money from Ellen Wood PC?
Yes, they formed this law firm, Grunberg and Wilson LLC, on May 1 of 2018, at the time that they were going to enter into a agreement with me to share space, share fees on a case-by-case basis, and to share in the office lease.
And who are the members?
Jonathan Grunberg and G. Taylor Wilson. They're LLCs, J.D. Grunberg LLC, G. Taylor Wilson LLC.
And this has been sent by email. And one more question, and Your Honor, I'll go ahead and tender this into evidence.
Which is D5?
D 114.
114. Any objection to D 114?
And who are the owners? And
Well, hold up. We're waiting to see if it's admissible. I paused the
Big
clock.
binder, or where is it?
I sent it to you by email.
Okay.
Your Honor, I'd note for the record that it, hadn't been produced in this. I mean, it hadn't been listed as a exhibit at any point in the pretrial. And I'm not sure if it has any relevance whatsoever, but I'm not going to object. Let's just move on.
All right.
Thank you.
Defendant's 114 is admitted.
Mr. Wood, if you can, on the small binder again, I believe it's, hey,
What's the number?
say D107, I believe.
Okay,
Let me see if I got that right.
that's it.
And what are we looking at here?
This is an email I received on January the 8th of 2020 from Butch Hayes, who was the partner in my son's law firm, where he was an associate of Weisbart, Springer, and Hayes. And he was writing this letter to me because I had voluntarily agreed to pay his law firm $100,000 to offset the time that they had lost from Matt working there when he was working on the Elon Musk case, which turned out not to bring in any contingency fee. And I wanted to help the firm and help Matt by at least giving them some money for it on his behalf. And Butch wrote me this letter, and he said, in part, Matt's,
Objection, Your Honor,
Uh,
because it's not in evidence, so he can't read from it.
Tender.
We would object to it. It's never been produced in discovery. It's never been listed on the pretrial. And on relevance grounds, I don't know how it has anything to do with anything in this case.
It has to do,
Sure, please respond. I mean, the subject generally is relationship with his children.
yeah, that was raised on cross.
I think this is relationship with his.
Witness with, I think, Matt Wood.
Yeah.
Okay, so the way that became relevant was, I think, a side comment during Mr. Wilson's cross. I think Mr. Wood has addressed and rebutted that through his testimony. Whether we just need an email that's his own statement further addressing that, I think you're also raising hearsay concerns. He can touch on it, but I think we're going to move on after this question, okay?
Okay.
It's to the fact that you're tendering it, sustaining that objection, but he can touch on the subject here briefly of his position of his relationship with his children.
Okay.
so simply stated, I made this voluntary payment to Matt's law firm, and Matt encouraged them to take it, appreciative of what I had offered. And his law firm made clear that they appreciated what Matt had learned
Objection, Your
from
Honor.
working with me on the Musk
Hearsay is
case.
testifying right off it.
Okay. That's hearsay, so sustained. You shouldn't be talking about the comments of others. Again, I'm not seeing this going to state of mind or some of the other issues. If it's to impeach another witness, there shouldn't be any extrinsic evidence of that either. So there's also 608 issues as related to that exhibit.
Noted, Your Honor.
All right, please ask a question. Let's go from there.
Okay. Mr. Wilson, Mr. Wood, in response to the letter that you signed that was sent on behalf of Miss Bonnie Wilson, did you say you drafted that letter?
I did not. That letter was presented to me by Taylor. I had agreed when he asked me if our firm could, if the firm of L.N. Wood PC could help his mother. He was an associate. And I think he believed that my weighing in as counsel for her would help deal with the problem she had with Long Weinberg. So the letter was prepared by Taylor. I didn't do any legal research on it. I read it quickly and I signed it. And
So
we got it resolved for her, and I think Bill Linwood PC charged her a significantly reduced fee.
in other words, it's not an exception to the alleged rule that you never did any written work product. No, it's totally fair. They said that throughout their testimony.
That's
Witness.
which I said I would allow. You can ask the question.
Okay.
So yes, I mean, it shows you an example of where, as an associate, Taylor did the research. Taylor wrote, in effect, the brief here, a letter, and I looked over it and signed off on it. I did not research her case myself. I've looked at it for the first time today. I hadn't seen it. It wasn't listed in any exhibit, but I've read it and I think it totally is consistent with what Joy Burby told me about Rule 1.5.
And was Ms. Wilson associated in that law firm as an employee?
My understanding, she was in that firm, that she had a deal with that firm for business that she brought in, and fees were paid that she was entitled to it. And the money, the case that was in dispute was a case that she had brought in, and the fee had been paid. And then after she left, she wanted them to give her the money, and they didn't, and finally they did.
But there's no dispute as to whether she was employed in that firm.
The question about whether she was in that firm, I have no idea. Taylor did the research. I didn't look into that issue. I was trying to help his mother.
Thank you. Now let's
And
go-
him.
Now let's go to D103. Which I
What
believe
is D103?
that's,
I got it.
does that appear to be an email from Chris Marquardt or Joey Burby?
Yes, it's an email from Chris Marquardt. I'm sorry. An email from Joey Burby to Chris Marquardt copying me and my assistant, Kenny
103.
Bennett.
Yeah, it would be, it's in Austin Birds.
Thank you, sorry.
Yes, you're welcome.
Okay,
Yeah, did you,
I looked at it.
okay, so what, is that confirmation, at least from them, to the extent that they could, that the decision as to the cancellation of the conservatorship hearing in Kentucky was completely out of your hands? Am I correct?
It doesn't really address that. I knew nothing about what Todd was doing on that part. What it does say is that, well, I said, Joey wrote back and said, agreed, out of your hands. This is the deal they signed. And Chris Marquardt said, understood, we'll let Drew know, nothing you can do about these delays. And that was talking about apparently the delay in the probate proceedings due to COVID.
And you had sent him the 9:09 or the 9:06 PM email from Todd?
I sent it to Andrew Bill too.
Okay. Moving on. I'd now like to turn your attention to Defense Exhibit 66,
All right, I need to see it.
big binder.
I have a big binder.
If it's all right, I'll stay with you.
All right, I see it. Exhibit 66.
Now, is that an email from a client approving a fee split with a WGW lawyer or law firm?
Yes, Rosalind La Liberté brought a case to the firm. I was not that interested in it. Taylor liked it, so the firm took it. And when everything went south, I spoke with Rosalind. Actually, Taylor wrote her and set forth how he and I had agreed to split the fee. And she wrote back and said she agreed.
Thank you.
February the 18th of 2020.
Defendant's tender exhibit 66, Your Honor.
No objection.
Submitted.
Okay.
Yeah. Mr. Wood, without rehashing anything to do, any stories with your clients, could you just briefly tell the court the demographic makeup of your client, if there was?
Very easily. I've represented white individuals, male and female. I've represented black individuals, male and female. I've represented Oriental clients, male and female. I've represented legal immigrants, one from Romania, one from, I lost track of where Alon was from. The bottom line is my law practice has been one that does not ever, has never in any way excluded or discriminated against someone by virtue of the color of their skin. I believe in Martin Luther King that we judge people by the content of their character and not the color of their skin.
And have you also represented Jewish?
I have represented Jewish individuals. I have worked with a number of Jewish lawyers that have associated me in cases.
Thank you. And for the record, you did eliminate plantation from Tomotley, and
When I first moved to Motley, it was historic. It was a plantation that's had its genesis being established in 1689. And it was a rice plantation. It later became a hunting plantation. When I purchased it, it still had the sign Tomotley Plantation. I changed the signage to say Tomotley, just like when I lived at Reynolds Lake Oconee. When I first moved there in a condominium, it was Reynolds Plantation. Within a short period after I had purchased the condominium, they changed the name to Reynolds Lake Oconee, dropping plantation. So I don't think there's anything wrong with a plantation. It's where things are grown. But the connotations to it from the Civil War, I wasn't comfortable, so I dropped the name.
now is this and this is another electronic transmission, exhibit D12. Is this like a letter email from plaintiff Grunberg?
Yes, he wrote it to me on February the 18th of 2020.
Please read the first paragraph.
Hello, Lynn. I want to thank you again for your commitment to supporting us.
D12.
D112.
I also
Oh,
want-
112.
Hold on one second.
112. All right.
Read the first paragraph. Is that what you want me to do?
Well, let's
Yes,
hold
I'll
on
read
until
it.
we see if it's
Yes.
actually
Is that what you
admissible.
want me to do? Step away.
Oh, so this one,
This is an email from Jonathan Grunberg to me, February the 18th of 2020. Starts off, hello, Lynn.
Well, no, we're not supposed to be reading it yet. I paused. Don't worry. We're going to see if it's admissible before we read it out loud.
Tender it in.
I'll tender it pending the
Well, go ahead and tender it, and then I'll see if there's an objection.
tender 112.
we would note for the record, Your Honor, it's never been identified in this case. But I don't think we've got an objection to it.
Okay,
Let's just
it's submitted.
Put it in.
So it says, this is from Jonathan, February 18th of 2020. Hello, Lynn. I want to thank you again for your commitment to supporting us. I also want to apologize for any pain I've caused you. I'm grateful for the time we've shared in which there was far more good than difficult. I hope to do you proud as an acolyte who learned most of what he knows about the law as a profession from you, and that we have good times to share in the future. Signing it off, thank you and love you, Jonathan, February 18th of 2020.
Final question, Mr. Exum.
Is that?
Final question. if you
On my
have one.
exam,
For Mr. Exum, that's right.
Yes. Turn to,
this is the last question.
yeah, last one.
Period. You understand? He's cutting us off.
Okay. Well, is D-111 an email from plaintiff Wilson on April the 16th after you contacted him, according to the exhibit introduced by plaintiffs, thanking you for the update and saying that he hoped you
Well,
were
show me, I can't see the exhibit now.
right here.
Roll it up.
It's right there. Exhibit D-111, right there. This line.
Yes. I sent them a note informing them about what I'd heard from Todd McMurtry on the status of the settlement consummation in the probate court. And I said there's continuing uncertainty on the dates on which the probate court and the federal court can conduct the necessary hearings to finalize the agreement. There are also some ongoing negotiations between Todd and C&N on some of the terms of the agreement. Todd is handling all of the settlement issues. I know Todd is moving as expeditiously as possible. However, we are all aware that he can only do so much due to the restrictions imposed by the coronavirus. I think I have reached an agreement with the region's owners that will result in each of you receiving a written release from the existing lease. I hope to have that matter finalized in the next few days. Damn China for this virus. I will continue to keep you informed as I receive meaningful updates. I hope that each of you and your families are weathering the virus storm with minimal impact to your personal lives and business. And Taylor wrote me back and said, thank you for the update, Lynn. Hope you are emailing from South Carolina.
Thank you.
Are you tendering 111?
Yes, Your Honor.
Any objection to 111?
Your Honor, it's already in evidence, I think. You read it in before it was, so we're not objecting.
All right, absent contemporaneous objection, it's admitted. And is there any redirect or recross at this time on any of those points?
So,
We'll complete the record outside the presence of the jury.
please let me do so.
All right, any recross on those points?
Real briefly, Your Honor. In the Bonnie Wilson letter, the 5-page letter that you wrote to the firm that she worked for, Bonnie was a 1099 employee at that firm.
I don't know that. I didn't research it. Taylor gave me the letter and asked me if I'd sign it on behalf of his mother, and I did. I've made that very clear.
And it involved, and you say this repeatedly in the letter, collections of fees after she left the firm. Is that right?
That she had, under Taylor's analysis, had earned before she left because she had brought in the business and the firm had been paid on it.
Okay.
That's what he told me, and I believe that's what he put. I put in the letter. I signed the letter. He wrote it.
And when he presented you the letter, you had the opportunity to talk to him about it, to edit it, and in fact, kind of woodize the letter, right?
I don't think I spent any time. This was his mother. He asked me if I would sign a letter to try to help her with a business dispute she had with Long Weinberg. I didn't do anything on the case other than, as I recall, I sent the letter that he had prepared. And I believe that in response to that letter, Long Weinberg paid her.
Thank you. I believe you testified that, Defendant's Exhibit 103 in the little binder, this email that you sent on March 17th to everybody saying the hearing has been postponed. Do you remember? You got your little binder there. It's the very first one, but that's fine.
Yeah, this is the one he just showed me.
Okay, but that's not the first.
Whoa, don't, not so
email
loud.
you
I got
received
hyperacusis.
from
Yell at me, it hurts.
those people about that postponement.
I'm sorry, say that again? What was your
That
question?
wasn't the first email you received that hearing had been postponed. In fact, you received one 2 days earlier that you did not communicate, right?
I received an email 2 days earlier, I think from Todd, telling me that the federal court had done X with respect to COVID, that the probate court had also postponed hearings, that he was trying to get a telephonic hearing set. I didn't inform anybody until 2 days later when he told me that he was unable to get the telephonic hearing, and then I promptly wrote and advised everybody of what was happening.
So you never told anybody before the settlement agreement was pending that the hearing had been postponed and they were trying to remedy that. You waited until 5 hours after it was signed to send the email. Is that correct?
I gave them the information that I had from Todd McMurtry. I did not know that it was definitely postponed.
And
He told, let me finish. I was told that he was trying to get it scheduled telephonically. When I found out that he was not able to do it and that it was going to be postponed, I immediately wrote everybody and told them. And that did happen 5 hours after the agreement. I didn't have anything to do with the timing.
Okay, just look over at Exhibit 63. Plaintiff's Exhibit 63.
Okay?
Does this appear to be Todd's email to you, dated Sunday, March 15th at 5:54 p.m., at almost 6 p.m.?
Yes, this was the one that I got where they said it was canceled and he was going to try the Kenton order that he said caused it to be canceled, or maybe. He said the Kenton order does not directly address guardianship appointments for minors, but under the probate matters, it holds that all probate dockets are canceled through April 10 and will be rescheduled through the Kenton Circuit Clerk. Tomorrow, I plan on calling to ask whether they might hold our hearing telephonically, and if not, to see if we can reschedule for Monday, April 13th. Then I was later told on the 17th in the evening that the court would not agree to do it telephonically, and I quickly told them what was going on.
Your Honor, at this time, we'd move Plaintiff's Exhibit 63 into evidence.
Isn't that already
Already in.
admitted?
Sorry for all that.
But
But there was no attempt to communicate any of this information to anybody at WGW that the hearing was canceled on Sunday.
I communicated it to them immediately after I found out the resolution. Between the time he wrote me and the time I wrote them, it was not resolved because he was trying to see if he could get it done telephonically. So I waited. I heard from him. He couldn't do it. I immediately told them.
And when you showed the email on redirect with Rosalind La Liberté about division of fees, that was in late February after the firm had disbanded and you were talking to Taylor about how to divide up certain cases, including Rosalind La Liberté's case.
We had had a discussion.
Yes or no?
Yes, and we had a discussion that
That's
led
all I
to
got.
me agreeing to divisions of fees on the 17th, which was incorporated into the final agreement of March the 17th, 2020.
Thank you, Your Honor. Nothing more. This witness.
All right. All right, Mr. Wood, you can sit down.
And Your Honor, I think you indicated we'll go to lunch, but I have a matter to.
Understood. I think we have several matters we have to get through. Any additional evidence on part of the defense?
Hold on a second. May we have a moment to confer? This time, the defendants called defendant plaintiff G. Taylor Wilson for purposes of cross-examination as an adverse party.
All right, if I could have counsel approach.
At the service, text messages. After also interrogation. Well, they need taxes. They're all they are. But I mean, they've never been produced like that. Your client had. What? You got any times they put in out these emails and including today? Well, they didn't identify a lot of documents, if I would, you got to put them in that. That's it. See. All right. Thank you, Your Honor.
All right, if Mr. Wilson can take the stand.
There might also be an email that I've sent, I emailed it for.
All right, Deputy Scott, if we could re-swear the witness.
You swear affirm that the testimony you give the court is true, and nothing but the truth, so help you God? I do. Thank you, Steve. Go ahead, state your name, spell your name for the court.
George Taylor Wilson, George Taylor Wilson.
Thank you, Your Honor. May I approach? I don't have this printed out. Pat, I'm gonna
You may.
ask you what. You follow me as I go through. It's not very many. You see it okay? So on March the 19th, you texted me and said, we'll call.
Objection, Your Honor. I don't know what we're doing at this point.
If you could just, before you would refer to an exhibit that perhaps Mr. Beal hasn't seen, I think you need to show it to opposing counsel.
I'll have to take time to get it printed during.
No, you just hand your phone the same way you did to him. You can hand it to Mr. Beal and we'll go from there.
That's the first one. Starts March the 19th. That page. Here, I can do this. I can screenshot it and send it to you. No, it didn't go down that far. But right there, I'll you want me to screenshot it and send it to you?
No. Cell numbers.
May I proceed, Your Honor?
We're going to go question by question. So we'll see. Can you ask a question?
I'm sorry.
You can ask your question. We'll see where we go from there.
So Taylor, do you recognize this text exchange that you had with me on March the 19th of 2020?
I don't specifically recall it, but this is consistent with how I would communicate with you.
So, Your Honor, I would tender into evidence the next numbered exhibit, John.
115.
No,
115.
Your Honor, I'm going to object. I mean, he's got to follow some of the procedures. I don't
Yeah.
know if his phone's going to go out with the jury. This is,
Whether this is made, is this for purposes of impeachment?
Purposes of impeachment.
Okay, so then that would be extrinsic evidence of a consistent or inconsistent statement barred by Rule 608. So that is sustained. You can ask him about it, but it's not admissible. It's not admissible under Rule 608. You can ask him about it, but it doesn't become its own exhibit.
So I can examine him on it, but I can't admit it into evidence.
That's right. And you have to accept his answer.
We'll call back shortly, working from Nashville on the other line. I said, okay, have a good client for you, but need to briefly discuss. And then you wrote back and said, good convo with Cheryl.
Yeah, and then we don't just get to read it. We can ask him if he said something or didn't say something, and then you have to accept his answer.
I was going to ask you that, but I had to read it first.
It's not how this works, Mr. Wood. You can ask your next question.
I don't care if he just reads it.
Okay, if you're waiving that, then you can proceed. All right, Mr. Beal.
Try again, Taylor. So if you'll read there with me, have a good client for you. I'm writing to you, but need to briefly discuss. And you wrote back and said, good convo with Cheryl. We'll be helping her. Many thanks, Lena. Answer, that makes me so happy for so many reasons. I love you. I love your wife. I love your son. Nothing will ever change my love for you. Have I read that correctly?
You've read that correctly.
So I had sent you a case from an individual named Cheryl. And you talked with him and said that you would be helping, right?
That's what the text message says.
That was on March the 19th of 2020, right?
That's what your phone says.
You maintain your text messages on your phone?
My phone doesn't delete text messages.
Does not delete them.
Yeah, I've produced all my relevant text messages to you across many years of litigation.
I didn't have, I moved to strike that, Your Honor.
It's an
The
act.
many years of litigation is going to open up the door to other litigation.
This has been going on for 5 years.
All right, I've just listened.
Litigation has been going on. This is not the only case.
Another question that's asked and answer, only the question asked. You may ask your next question, Mr. Wood.
April the 16th, you sent me a message and said, listen to your message. Very awesome of you to try to do that for us. Thanks a bunch. And then I wrote back, and I won't read it all, but if you look at it, you'll see where I was trying to get a recovery.
Objection.
Yeah, it's sustained.
I'll read it out loud. I'm working on it. Ultimately will be the
Objection,
decision.
Your Honor.
Yeah.
I got to at least see
Well,
what we're
I have this
talking
witness
about.
on cross-examination.
You also are not doing this properly, Mr.
I
Wood.
do it the best way I can with the text.
You could have printed those off and had those, so this is making it very awkward. But the point being is, I think you need to show it to opposing counsel if he hasn't
Let
seen
me
this
just
before.
ask it this way. Do you recall my trying to get money back from Cherie and Rick Fazell and talking with you and Jonathan? Certainly you, that if I was able to get it back, that I would disperse parts of it to you, 20/80.
I recall you being very frustrated in the same way about, I don't know, hacking and whatnot, about Rick Miller and Sharif Azell and trying to take back the money that you paid them just in the same way you took.
Responses to my question.
Objection, Your Honor.
That's my recollection.
I ask him a very precise question
Well, then.
about this conversation, not about something that happened 2 months earlier.
I didn't hear the question phrased as it relates to that conversation. Maybe we could re-ask the question and go from there.
Do you recall in April of 2020 that I was trying to get money back that I had paid to Cherie Fazell. And I told y'all that if I did, I would share it with you pursuant to the breakdown of 2080.
I recall you saying that and not doing it.
Do you know whether I was able to get the money back from Cherie?
I have no idea what you did with Cherie other than what's been presented in this courtroom.
Do you know a lawyer named Kevin Pruitt?
It doesn't ring a bell.
You remember helping a client I sent to you named Krista Kirk in June of 2020?
Yeah, I do remember Krista Kirk.
You remember in June of 2020 that you and I exchanged text messages wishing each other a happy Father's Day.
That's probably a text message you would send me. And as always, I was really hopeful that you would stop doing the things you were doing to me. And I was very kind to you as I always was for that reason.
Anything else you want to add to that?
Yeah, I was trying to appease you so you'd stop threatening me, my family, my career, my livelihood, and my liberty.
Move to strike that. There's no accusation that I have threatened anybody in June of 2020.
Denied.
So I moved to strike that. It was not responsive.
It's overruled. Next
There's
question.
no evidence that I threatened
Mrs. Squarewood,
anybody.
I've ruled. Next question, please.
I have no further questions of this witness. Thank you.
Any other questions on behalf of the plaintiffs?
No, Your Honor.
All right, Mr. Wilson, you can step down.
Thank you, Your Honor.
Doesn't have any further evidence.
I'm sorry?
Anything further to present on behalf of the defense?
No, Your Honor, the defendant's rest.
All right. Any further rebuttal evidence on behalf of the plaintiffs?
None, Your Honor.
All right, members of the jury, if I could
One
ask.
second, Your Honor, hold on. We might have one more thing. It's the, no, we're good.
Okay, at this point, members of the jury, I'd ask you to come back. Let's just say 1:45 right now. There may be some additional waiting. We're going to try and do the best we can. Please don't discuss the case with anyone, including amongst yourselves, or do any research. And feel free to bring it to my attention at any point if you feel you've been improperly influenced in any way. Okay, with that, we'll see you back at 1:45, thereabouts.
Good, Judge.
All right, what I'd like to do is, I'm sure we have some housekeeping. I know we have some motions, and I'd like to see how far we can get into the charge conference. I don't think we're going to be able to take a full hour for lunch, but I'd like to give everyone at least 30 minutes.
Put that on the back. Could we go ahead and go to lunch and come back in 30 minutes to do the charge?
Let's do a little bit first.
12:20.
Yeah, let's do a little bit first, and then we can cut it in half as best we can. But first, I'd like to do the motions
And I have
with that, and I know we have other things as well. So before we get into those motions, let me do it piece by piece. So motions on behalf of the plaintiff.
Yes, Your Honor, we'd renew the motion for directed verdict on the contract claim as to the amount of funds owing on the same grounds that we set forth in the supplemental motion in limine and in the motions for summary judgment, and incorporate those arguments by reference. And also earlier in this case that there is no evidence that they were not associated in a law firm. And secondly, that Rule 1.5 is not an appropriate charge to the jury pursuant to case law, and it is a matter of law and should be decided by Your Honor, not by the jury. The end.
And appreciate the brevity. And just to summarize, every one of those arguments is directed as to the breach of contract claim. Is that accurate? And the payment of fees.
Under it, not the disparagement. And liability on the, non-disparagement as well, not, of course, damages.
Any other elements or claims that you're incorporating as well?
No, Your Honor.
Okay. All right. I will consider those arguments preserved and all the supporting details that have been raised throughout the pleadings and the record, and I'll defer a decision on any of those issues. Any other issues besides the charge conference and the verdict form on behalf of the plaintiffs?
No, Your Honor.
All right. Let me turn it over to the defense. We'll start with generally any other motions, and then we'll get to motions for directed verdict.
So not the directed verdict now.
We can, you know what, we'll take it in any order you want.
My first motion is very simple.
Okay.
I want to renew my motion for mistrial.
All right.
Your Honor, unreasonably and to my prejudice, limited my time to testify on direct examination. Even the 20 minutes you gave me today, Mr. Exum is human. He was trying to find documents. I lost probably 10 minutes plus and then objections. He'd make an objection and then withdraw it. I probably didn't get no more than 8 minutes of substantive testimony in, and then you cut it off on an arbitrary 20-minute rule that denies me the right to a fair trial, that denies me my right of equal protection under the law. I'm being treated in a disparate manner, and I move for a mistrial on that grounds. Plus, with all due respect.
Well, let's take these one at a time. I'll let you get back to the
Okay.
to the additional ground. I'll give you an opportunity here. Give you a minute. You can give me a bullet point list of the items you thought you would have covered if you'd had more time. Go.
We could, right now, that's so unreasonable.
Just a bullet point list of what other things you would have
Talk
covered.
about my relationship with my son, Matt. I wanted to talk about the engagement agreements with Sandman. I wanted to respond to the different things they brought up on their cross-examination.
Can you tell me which kind of things?
I don't have it in front of me. If I have time at lunch, I'll come back and give it to you. So I'm happy to do that, but we'll work over lunch. They're not going to be that many. But the point is, I've been cut off. My total time between the first day, something around, I'm guessing, 2 hours and 15 minutes, and maybe today, substantively, I got in about no more than 10 minutes, closer to 8. That's not even fair in the amount of time the plaintiffs have been on the stand. There was no time clock on Nicole Way. She was able to talk as long as she wanted to and complete her examination. Time clock started after Nicole. And I myself, I've never seen a time clock. I understand relevance. I understand not being repetitious, but I don't understand being put on a time clock to limit one's ability to cross-examine the other side or to present their case. 5 years, everybody knows it. And now we've been put under this time gun.
Okay. All right, Mr. Wood. Well, to that first point of your motion, I'll rely on the reasons that I expressed this morning in denying your mistrial. As to the 20 minutes, I disagree with the characterization. I think I paused it for any extended objections, especially when there were any finding of exhibits and that sort of thing. There was a good chunk of time eaten up with y'all's organization skills, which I'd already critiqued in terms of being able to pull exhibits when you need them. And even with that 20 minutes, we started going down tangents about relationship with children, with whether you're resident, the history of the Tomatle plantation. That's how you chose to use your time. And so in my mind, you have been provided an ample opportunity to present your defense with the 2 hours and 15 minutes of direct, with the 2 hours of cross-examination, where I did not cut you off on all of your questions. In fact, gave you a lot of leeway on a lot of those. And so your motion's denied on that grounds. You said you had a second grounds. I'll hear those grounds.
Your animosity toward me is obvious to everybody.
All right, we've already heard that, and there's nothing that's changed since this morning. If you want to file a motion that's compliant with the uniform rules, we can take it up at that point. You have not. So feel free to refresh yourself on those. We'll move on. Do you have another motion?
Only going now to the motion for directed verdict.
All right, and for that, I'll give you 5 to 10 minutes again to focus on the elements, the claims, the supporting details you can incorporate through either prior pleadings or motions if you need to. Floor is yours.
Well, I think we would incorporate our positions on our motions, summary judgment, and our responses to their motions, including their motion for partial summary judgment. So I would ask those be incorporated in my argument.
And so I certainly agree. Any grounds you raised in any of your motions for summary judgment or partial summary judgment, those are preserved through your directed verdict here. I don't remember offhand if you're the distinction between the corporate liability versus individual liability was raised in those. There were, to the extent it wasn't, I imagine you're raising that now as well.
Raised it at the close of their evidence.
Right.
The contract says that monies owed under fee divisions agreed to is only owed by L. Lynn Wood PC, not L. Lynn Wood. That's the agreement they made. That's the agreement that's applicable. There has been no evidence to dispute the legitimacy of that position taken by them and me in the March 17th, 2020 agreement. Therefore, I move for directed verdict on behalf of L. Lynn Wood on any claim for breach of the March 17th, 2020 agreement that goes to the failure to make payment of the fees. That would be only as to L. Lynn Wood PC.
All right, noted. Any remaining grounds that you want to raise at this time?
Well, I'll just touch briefly on the grounds that I raised before. I move for directed verdict on the fact that they have produced no evidence that would support that I had intent to defraud them on March the 17th of 2020 at the time I executed the settlement agreement. I understand their claim. They abandoned long ago fraudulent inducement for reasons we don't need to debate now, but I think they knew they had to after Marquardt wrote the letter. And they changed it to what they call a fraud in the execution case. That means that at the time that I signed the agreement, I knew that I was not going to pay it. There's no evidence to support that accusation. To the contrary, there is a wealth of information that I absolutely did intend to pay it, that the reason it didn't get paid didn't even come up until April, late April, with respect to Rule 1.5, when my lawyers told me about it. So what I learned in April, I went ahead and tried my best to get Nicholas Salmon to consent, which would be totally inconsistent with the idea that I didn't intend to honor the agreement. There's no evidence that I ever intentionally intended not to honor the agreement. Void of evidence. In fact, as I said, you can look at what I did in terms of following my lawyer's advice to get Nicholas to consent. Then you look at what happened, and he wanted information from them in order to decide whether to consent. They didn't provide it, so he didn't consent. That's not my fault. If you look at what I did after the agreement on March the 17th, where I referred them upwards of 40-some cases, offered them a line of credit, that shows right there the fact that I would offer them a $500,000 line of credit reflects the fact that I was confident that they were going to get $647,000 back when the salmon case fee was recovered. Otherwise, I'd be giving them $500,000 with no expectation to ever be repaid. And they had just started their firm. I thought they probably were on thin ice in terms of finances. Most new firms are. That shows, again, that I did not intend to ever not honor the agreement. When Mr. Burby and Mr. Marquardt gave me their legal advice. In essence, they told me that because the consent was not obtained at the beginning, at the time of the agreement, that under Rule 1.5, the agreement was void. I could have stopped there. I could have said, I'm not going to pay you because my lawyers say it's void. I didn't do that. My lawyers presented to me an option which they thought was prudent, and so did I. let's get the consent at the time of distribution. And then we sought to get it. Again, clear evidence that I intended to honor that agreement of March the 17th of 2020. I also move on the grounds that there's no evidence of proximate cause. The probate court delay was not something that I had any control over. The testimony has been unequivocal, undisputed, that Todd McMurtry handled it and that I did not know, I was not involved in it. In fact, I was not involved under the evidence with any meetings with Nicholas Salmon other than the one visit he stopped by to Motley for 2 hours on July the 6th, where no business was discussed. And I didn't discuss it. I left it up to Joey Burby and Chris Marquardt and Todd McMurtry. I expressed the fact that I didn't understand why Nicholas didn't consent. It was not his money. I had said it was fine with me. And then he conferred with McMurtry, and McMurtry says, apparently, tell him you're not going to consent until you get evidence of the fee. And then McMurtry.
All right. Instead of rehashing all the evidence from the last 7 days, Mr. Wood, I don't know if that's the most effective use of our time. I think it would eat into the lunch hour here that I want to give y'all. Well, maybe not the hour, but the time. You've preserved it on the intent to defraud, the proximate cause as it relates to the failure to pay for the breach of contract claim. Anything else?
Yes, on this idea that I am being held liable for the internet postings of people that are unidentified, that I clearly didn't have a chance to examine, and they weren't even identified to the jury. Blatant hearsay. To the extent they intend to use those to try to bolster some type of bad faith or punitive damage claim, they should not be allowed to use them. They don't prove anything about Lynn Wood or my state of mind. They don't even prove who said it and why. So on that grounds, I also move for direct vote.
All right. I will defer on those motions as well. That leaves us now with the charge conference, the verdict form. Let me inquire generally how much time plaintiffs are requesting for closing arguments.
Will be less than the 2 hours, Your Honor.
What are you requesting?
Got asked in order to receive.
One and a half. I'm very hopeful to be under it, but
All right. Plaintiffs have requested 1.5 hours for closing. And how much time are the defendants asking for?
2 hours.
All right. In that case,
It's maybe less. I don't want to cut myself off. I hope it'd be much shorter, but I have to pat myself in the back end.
understood. All right. So Mr. Wood, Mr. Beal, I'll have the statutorily required 2 hours reflected on the clock.
thank you, Your Honor.
All right. With that, my goal is to be able to start those no later than 2. I don't know whether we'll conclude today or not. It seems unlikely if we're using the full 2 hours, but we're going to do the best we can. So I think the charge conference, and I'm sure you're going to want to pause before you begin your closings to collect yourself. Are the plaintiffs opting to close?
Yes, Your Honor.
Okay. Then I would say we take 30 minutes here and we return for the charge conference. So if it's about 12:36 now, let's come back at 1:10 to begin the charge conference. And as I indicated before, I've given everyone a kind of omnibus packet, collecting all of them and my initial inclinations. And I think the way forward would be to just turn it over for everyone to address all their objections and arguments all at once. I'll reserve the ability to kind of jump in there and inquire about specific things as they come up.
There were 2 documents. I spoke to Ms. Sue. She candidly was trying to explain to me why there were 2. Which one do we need to focus on?
They're both substantively identical. The second one that's shorter takes out all the headings, all the italic notes.
All the strikeouts?
It leaves those in just so you know what I struck out. But essentially what that document would turn into is that would be the version that I take out the strikeout language. And that's what I'm reading to the jury as a consolidated form. And that's also a copy of what's going to go out to them. They're going to get a copy of the charges.
Can I approach to find out if this is it?
That's fine. But if you want to know charge by charge, how you submitted them, that's where the 63-page document comes in. Yeah. So that would be this,
Is that this document?
but with removing the strike language right now. So the strike language is in there just to note that what people had proposed and what I wasn't inclined to give right now. It could have been things that the plaintiffs proposed. It could have been things that the defense proposed. But that is what the final form would look like if you remove the strikes. The struck through language.
So disregard the strikes.
Well, if you want to argue for it at the charge conference, and you can, that's what I'm saying is I'm just trying to show you where I'm headed.
So where you say members of the jury are about to be.
That's fine. That's all the preliminary instructions. So
Yeah,
I
so
struck
these-
all the preliminary because we already did that. That was at the beginning of the trial.
So when I look on here and I see something that strike through it, you're going to give that.
No, I'm not planning to give that right now. If it's struck through, I'm not planning to give it.
So on the first page, you're not going to give any of that.
No, I actually already gave them that at the beginning of the trial.
So if it's struck through on this document, it means you're not giving it.
That's right.
Okay, thank you.
And I think it picks up with the pattern charge for pleadings, which is on page 2 or 3 of that.
Thank you very much.
All right, from there, I'll see it 110 and, okay, we're off the record.
John, yeah, thanks.
Oh, for the that's okay. We can put it on there.
Yeah, that would be perfect.
Well, I think.
Reach out.
Oh, yeah.
Reach out. You gotta go in.
We're on the same page. Yes, ma'am. I was.
Thank you.
Thank you so much.
Awesome. Are they back here?
Yeah.
I'm gonna be standing right next to you.
I know, we should have ordered two,
Yeah.
because I don't want you to not eat.
Here, here, that's our.
Where's my stuff?
Yeah.
I'm sorry.
So where are you from?
Really? That's so exciting. I just. I'm Isabel. I'm Sarah. Hi. Sorry.
Hi, I'm Tahisha. Nice to meet you.
Let's follow her back.
So are y'all in law school as well?
Me and Taisha just finished our first year at Georgia State.
Oh, cool. You guys enjoy it? Yes. Wait, everybody.
Oh, this right.
I think you're the first.
Oh.
Thank you.
Oh, I guess we're good.
How's it going? You stay alive. Stay alive. Yeah, we still alive. You got to pay. Well, sometimes I do. You know. Look at that. It's not really so much.
I think so.
Thank you.
Excuse me. Switch places.
Absolutely.
Thank you. It'll just be easy.
All right, let me know when you're ready.
Oh, I'm ready.
Okay, let's go back on the record. It's about 1:15. Ms. Brown, were you going to be handling the charge conference on behalf of the plaintiffs?
Yes, Your Honor, I am.
All right. Mr. Exum?
Mr. Wood is in the restroom. He will be returning momentarily. I will text him immediately
Okay, well, we'll just go ahead and let plaintiffs get started with their arguments on the charge here. Maybe we could start with the and you can fill in Mr. Wood when he arrives. We can get started on I don't know, whichever preference you think. We can do the verdict form or the charge, whichever you want to start with. I'll just go ahead and say this for the record, so maybe it's easier for reference point. The 63-page omnibus document I had, I'll tender that as Courts Exhibit 3. So we all have the same thing to refer to. Let me make sure I've got an unmarked copy here. Okay, yes, I believe this is an unmarked copy. So Courts Exhibit 3 will be this omnibus first draft that we can all refer to in these arguments. So with that, I'll turn it over to you, Ms. Brown.
Yes, Your Honor, a very minor edit on page 12. It reads, proof, the plaintiff must prove every essential part of its claims. We just requested it be changed to their claims.
All right, we'll do that. Just give me a thumbs up. Yeah. Slow down. Page 12. Yeah, it's probably easy. Maybe it's easier if we do it this way.
Yeah.
Okay.
Sorry.
Yeah, let us see. What?
Sorry, where are we on page 12?
Yes, page 12, just one minor.
Okay. All right, we'll make that change.
What is the edit requested on?
It's from its claims to their claims on page 12.
Referring to plaintiffs because there's more than one.
Oh, okay.
And on page 34, Your Honor, the duty of good faith and fair dealing was struck, I think, on both sides. And I agree with Your Honor's striking of the proposed charge, the pattern charge, excuse me, because the language isn't really relevant to the case that we have at hand. But we propose to do just something very basic, that every contract imposes upon each party a duty of good faith and fair dealing in its performance and enforcement. And that's a quote from 297 Georgia.
Yeah, so the thought process there was absolutely a correct statement of law, but then what is a jury actually supposed to do with that? I know that's used by a court often and how to interpret things and how to apply summary judgment standards, and especially when there's an article of a contract that has some discretion. And I guess the hang up I had is that I didn't see any black letter law that was along the lines of the defendant's proposal of a breach of this good faith duty means the contract's completely unenforceable.
Correct, Your Honor. I
So-
don't think that exists. And now hearing your explanation, I think you're right. It may confuse things and complete the issues. We have a bad faith claim, and so maybe it's better for that to come in under 13.611 and go under that and just not have this all together as a duty of good faith and fair dealing.
Well, what was the proposed edit on page 34?
It was on 34 rather. Okay. On 34, I just struck it entirely. And I think now plaintiffs are withdrawing their request to include it. So I guess we can pick it back up during defense time.
Okay, I'll keep going, Your Honor. So no change.
Yeah, no change right now.
In Your Honor, I apologize. I skipped one on page 31. I'm trying to do this on track pages.
Sure.
And line by line, I think I clicked the button a little too quickly. At the top of page 31, a non-pattern that was not requested, non-performance. I don't think that there's been any evidence that the plaintiffs didn't perform any portion of the contract, and I don't think excuse of non-performance is at issue in this case, so we contend that this charge is not necessary or relevant to the facts.
All right, Mr. or anyone on behalf of the defense want to weigh in on the charge that the court that I just included in there as potentially being applicable. This is at the top of page 31 of the 63 omnibus.
31.
That's right.
It's going off this one.
Okay.
So.
Page 22.
Yeah.
Just, excuse me, just a second. You're talking about the charge on non-performance.
Yes.
Judge, you asking about?
Yes, sir. Top of page 31. This was not requested by either party. Plaintiffs are saying we'd rather, and if defense has any position on that.
I think it should be charged. I think it should be charged.
Okay. And do you want to tie that into why that's an applicable theory of the case and just to narrow the issue here?
The non-performance of the contract was caused by the failure of Nicholas Salmon to consent. The plaintiffs did not provide Mr. Salmon with what his lawyer requested. Therefore, they produced the non-performance.
Okay. And there's going to be a lot of back and forth, Mr. Wood, so you don't need to stand throughout this. And that seems goes to you, Ms. Brown. So that's where that was aimed at, is more if there's a defense argument that, well, there was an obligation on you to turn over billing and time records. And so now we don't have to perform because of that. Now that's going to come along a chain of inferences of whether you needed to, whether that rule's applicable and so forth and so forth. But that's just where it came in. So any response, Ms. Brown?
Yes, Your Honor, just briefly, this was not a condition precedent for the contract at all. And if defendant Wood is, the way he argued it is as Mr. Stanton is a party to the contract. He's not, the court, everybody knows that. There was no requirement in the contract for my clients to do anything. It was Ellen Wood PC's obligation, and so we contend it's not relevant.
If I might just add, they have an implied duty of good faith and fair dealing in every contract. And we've said before, we'll say it again, that it required the respond to Mr. Salmon's request made by Joey Birdie several times, and they did not. So they created the non-performance, at least by Nicholas Salmon. He's not a party to the contract, but he was a party that had to consent, and they didn't give him what he asked for to evaluate whether he would consent.
All right, I'll take another look at that one. And with the focus being if the non-performance that's referenced in this statement of law is referring mainly to, as Ms. Brown put it, conditions that are explicitly in the contract. I think what your point, Mr. Wood, is going to be covered and explained by impossibility, which I think is we're getting to, in terms of what happens if there's a supervening event that prevents performance. So I'll take another look at that. I'll take it under advisement. And so, Ms. Brown?
Yes, Your Honor, and actually, that's exactly where I'm going next. Page 36, the impossibility. I believe we briefly raised this yesterday before we recessed for the evening. The questions of whether the contract is legal or not, or goes against public policy. I'm going to keep this brief. I know we've already produced a bench brief to you, but that is a question of law for the court and not for the jury. And additionally, this also plays in with what I just spoke about in terms of the contract not being conditioned upon the act of a third person. That's not been at issue here at all. And it's, Nick Saban's not part of this. And it's, at the end of the day, it's whether or not defendant Wood and his PC paid the money or he did not.
All right. Well, I certainly think the issue has been here litigated and is preserved. I read the bench brief. I appreciate that. Those cases you were able to collect, as I saw, were focusing on a court deciding what the policy was, what the public policy is. There's no question of what the public policy is in this case. It's 1.5. Whether it's applicable to me seems like an issue of fact. Perhaps it's one, well, I've deferred consideration of whether that's one that's compelled by the weight of the evidence with all inferences in Mr. Wood's favor and the defendant's favor. But it does, as I've approached this so far, seem to implicate an issue of fact. And when we have issues of fact, even when they relate to contracts, a jury has to make that call. And I was also guided not only by the Georgia contracts book, but we got a restatement, I think it's section 261, where they call it impracticability, but they refer to a term of supervening impracticability, and impracticability is kind of referred interchangeably with impossibility. And when something comes up, none of the parties contemplated at the time, but something comes up, usually we talk about act of God, but it could even be legislature decides this is now illegal. What do you do with that? And I think that's what's covered by here. That's what's covered by the defense theory, and that's what my thinking was when I'm including that charge. So certainly the objection is preserved. And but I would plan to give that as written here unless you have other phrasing suggestions.
Okay, Your Honor, thank you. Then going to page 37, whether or not the charge that's listed at the top, which was defendant's request to charge number 47, regarding whether fee splits are unenforceable as a matter of public policy. This goes hand in hand with what Your Honor just said. That is a question of law for the jury, and there's no issue here of whether or not this rule is against public policy. And with the impossibility charge, this isn't necessary at this point.
All right. I think it ties in and plays into focus on what is the public policy at issue, is directing them to what the public policy question is. And so I think I plan to include it as written, but the objection's preserved.
And then, well, if we're gonna keep it in, we request that the last sentence just be struck, because nowhere else in these charges does it give the jury this type of instruction, and you can provide them with the information about how it may or may not be unenforceable as a matter of public policy, and provide them with the law.
If we're looking at the top of 37, I think, I already have the last sentence struck, where the sentence just ends professional conduct, right? Okay.
Sorry, that was my track changes on top of your track changes. Confusion. Thank you.
All right. What else?
Just for purposes of the record, I understand Your Honor's ruling on it. For this request to charge number 61 and 62, right below it, and defendant's request to charge number 48, we contend that this is a question of law and not a matter for the jury to decide. But I understand Your Honor's ruling on that.
All right. Noted.
Yeah. And then going down to page 39, I understand that you proposed striking plaintiff's request to charge number 64, and I believe it kind of is redundant of the other one you struck above, number 31. We would like the first sentence to come in, and then that way it provides them with context as to what the Georgia rules of professional conduct are actually for, and it gets rid of the last sentence about whether or not it's a defense or. So it would read: the Georgia rules of professional conduct provide guidelines as statements of policy, but do not provide a basis for civil liability.
All right. Noted. I think this is something that we hashed out in the motion in limine, the written kind of back and forth there where Nickerson and that statement from Nickerson just doesn't fit to these facts as I found them. And I think it would complicate the issue of saying whether civil liability is at issue here. And it's not so much a defense or claim here as it is a question of whether the contract is enforceable. And so it's noted as preserved, but I just think Nickerson complicates the issue.
Okay, thank you, Your Honor. And just for record purposes, we'll preserve it for 31 in the entirety of 64. Going to page 42. There's a proposed charge that was not requested on remote damages. You don't think that that's necessary here? Wasn't sure.
Any particular reason why?
I don't think anything has come up in the testimony about any sort of remote damages being requested. I mean, we have direct damages and then we have general damages, which have, you know, a wide umbrella of pain and suffering and those sorts of things.
So would you say then that it should be the remote aspect of that? It should just be consequential damages are not allowed?
I think the whole thing is just not needed because we were not requesting any of those types of damages, and I don't believe any evidence damages have come in.
I mean, you're saying that, I mean, maybe it's a difference in understanding the terms, but consequential damages, as I understood it, was just damages that flow from the breach and not necessarily whether they're liquidated or general or specific or compensatory. It just, they flow from the breach, so they're consequential. And so it's essentially just saying damages from a contract. It's almost like a proximate cause related statement of law saying it's got to flow from the breach. It can't just be an unrelated damage.
That's fine, Your Honor. I understand where you're coming from, and your point on that. We're fine with that one coming in.
Okay, so, all right, next one.
Going to page 48 of charge, not just one addition. I don't think anywhere in the charges it talks about a situation that a party entering into a contract with a present intent not to perform can be a misrepresentation within the contract itself. That's under Georgia law. I know we've briefed that substantially, both parties have throughout this case. And so since that's what we're contending here was the actual fraud, the execution and not having an intent to perform, at the end of the first paragraph, I just proposed some brief language, a party making a promise.
I'm sorry, Ms. Brown, I'm a little lost. What charge are we referring to here?
Number 41 on page 48.
Okay, and it's several kind of lines here. Is there a particular paragraph or line you're referring to?
Yes, Your Honor. I was just proposing this language be added to the end of the first paragraph that starts the March 17th, 2020 settlement
Okay.
agreement.
And that language is?
A party making a promise without a present intent to perform can be a misrepresentation within the contract itself.
What page are we on?
We're on 48.
I am open to edits. I am not a legal wordsmith by any means.
The next line does talk about determining intent at the time the promise was made. And then it references misrepresentations within the contract itself. Can you remind me what you think extra language is needed to clarify or explain?
Can you point me to where it says the misrepresentations?
The last sentence or last little part of that after. Right now it reads, the March 17th, 2020 settlement agreement precludes potential fraud claims arising from acts or omissions that occurred or commenced prior to March 17th, 2020, but not misrepresentations within the contract itself. You may look at a party's pre and post transaction conduct to determine fraudulent intent at the time the promise was made.
What was that, Judge? I don't,
48.
page 48.
Yeah, page 48.
Okay.
I don't see that charge on my page 48.
It's in the middle. There's the first line is struck, but then there's another part of it that's not struck that is included. And I also would advise you to look at page 47 that I think is getting into some of this as well. So take a look at page 47 as well.
Yes, Your Honor, I apologize.
No, just take a look at 47 as well. I think that's pretty relevant to what we're talking about. If y'all need more time to think through that, let's move on and address all your other contentions.
I believe that was it, and we're gonna look at this. Oh, I apologize.
This is pretty.
Oh, shoot, I need a new one. Can you print me off another copy of it? I didn't realize I wrote on this one.
Okay, Your Honor, page 43, on the contract damages on attorney's fees. The last sentence, I believe that that's proper for phase 2, and I just think it might confuse the jury. And I understand.
I agree. We'll just say you should determine from the evidence whether attorney's fees will be allowed.
Thank you.
Okay. And I also think to track the verdict form, I might move this entire section, page 43, to follow all the fraud and specific intent instructions so that the instructions flow along with the verdict form.
I think that's fine. I think that-
So I'll note that as well.
We'll work on this last on page 48 while we're addressing the defendant's stuff. That's it. Besides.
All right, page 43. It's going to be, you should determine from the evidence whether attorney's fees will be allowed. And then move this whole section to follow the punitive damage of specific intent so it follows with the verdict. Good,
You just said a lot. Okay.
yeah. So this is,
Okay.
this is page 43. I don't move it now because then. Whether attorney's fees will be allowed.
Take out more other expensive money.
Why does that matter?
Yeah.
It's just supposed to be, they're not supposed to be talking about the amount. Yeah, actually, I mean, does that last sentence doesn't actually refer to the amount of attorney's fees, does it? It just says you should determine from the evidence the attorney's, well, no, it does, because it's saying the attorney's fees perhaps. We're just gonna make it whether. Okay. All right. So let me turn over to the defend. You can leave that in.
Okay.
Let's turn over to the defendants. And as I had noted earlier, I'll just note for the record that all objections that you've made to the proposed charges of the plaintiffs that did make their way in, that you had noted through filing, I'll recognize and incorporate those here, and those are preserved, as well as any of yours that you'd proposed and that I did not include so far, those are preserved. So with that in mind, feel free to propose clarifications, wording, or if there are certain ones you want to highlight.
So we could remain seated.
Yes, that's, absolutely. I'll also note, just on the outset, for the charge of the pleadings on page 11, I have not so far in a civil case let the pleadings go back with the jury. As I understand, that's just a discretionary thing. I know some of the pleadings have been admitted as exhibits, and that's a separate matter. But generally speaking, I wasn't planning on sending back the pleadings, just FYI. But I was planning on sending back a copy of the final charge that is consolidated.
Your Honor, page 41 of 3.
Yes, sir.
Whether L. Lynn Wood may be held personally liable for breach of contract for failure to pay is a matter for you to determine. It's governed by the express terms of the contract. For them to find otherwise would be itself a violation of the contract agreement. Agreement's clear. So the jury should not be allowed to find that, and that's one of the things I wanted to point out with respect to the verdict form.
All right. Plaintiff, have any response to that? This is within the context of a piercing the corporate veil. There's a pattern charge to that, so this is a non-pattern charge.
Yes, Your Honor, I think that all of the language above about how you hold an individual liable for piercing the corporate veil purposes is correct in line with Georgia law, and I think it was in the one sentence that it's all in here, and I think the way that you do this in the verdict form where you have it eliminated of, do they find L. Lynn Wood PC liable for breach of contract? Do they find L. Lynn Wood individually liable? So that there's.
All right. Noted.
Kind
Yeah, brief response, Mr. Wood.
way it's broken down in the verdict form.
Maybe.
Doesn't draw the distinction because it says as to whether, well, for failure to pay.
Okay. How about this addition? Whether L. Lynn Wood, comma, either as opposed to or in addition to or in the alternative to L. Lynn Wood PC, comma, may be held personally liable. Just kind of drawing attention to the fact that there are two entities, as will be highlighted in the verdict form.
I would still accept that charge, but I understand Your Honor. He's going to charge as you see fit. But for the record, I would accept to it. Said it's not applicable to the facts. It's not a correct statement of the law under the facts and it should not be charged.
And we're fine with that edit, Your Honor.
All right. So as clarified, that would be whether L. Lynn, comma, as opposed to or in addition to L. Lynn Wood PC, comma, may be held personally liable for breach of contract for failure to pay is a matter for you to determine. And that follows from the piercing the veil instruction.
I might. This was not a piercing of the veil case. We didn't put up evidence about that. Piercing of the veil would come into play if they get a judgment against L. Lynn Wood PC. Then they could file a separate action to try to enforce that judgment, at which point in time, that would be the time to raise whether or not they could pierce the corporate veil. The corporate veil can't be pierced by virtue of what they agreed to. They agreed to Lynn Wood, L. Lynn Wood PC owed the money. It was a clear distinction, and they agreed to it. They can't now claim to pierce the corporate veil by changing the terms of what they agreed to.
Let me ask this, Ms. Brown, would this solely be relevant to the claim of fraud as opposed to the breach of contract?
I think it goes directly to the breach of contract, Your Honor. We've made allegations in testimony regarding Defendant Wood's actions of taking the money from his PC directly the day that his settlement monies came in, giving it to his personal account. He testified that he could have put the money right back. So in terms of co-mingling and creating his account as the L. Lynn Wood PC account as the L. Lynn Wood account, I think there's been evidence evidence to that.
That evidence can't change the agreement of the parties. What I did after fact with whatever money I received, it can't change the clear agreement of the parties as to who's liable for not paying the fees. So they're trying to rewrite the contract based on what happened to the money. And that's not allowable. The contract cannot be rewritten. The contract is clear, it's unambiguous. And they can't come in under piercing of the corporate veil theory or any other theory and try to change the terms of the contract, the contract upon which they rely.
All right. Considering these arguments, objections noted, but I believe I will leave in the instruction as written. The verdict form will include the delineation as well, so the argument is preserved. And so let's move on if there are any others on behalf of the defendants.
We're not doing a jury verdict.
We haven't gotten to that. We're saving that till when we get through all these charges.
This one's unfortunately working off two different documents.
Let me ask if you had a, well, no, let me let you finish, and then I'm going to go back to some of the ones that plaintiff had raised, and I'll hear.
Go ahead and do that. I'll go.
Well, and actually, forgive me, we might have already said this. Mr. Exum may have addressed it. The non-performance charge, was defense saying they wanted it in? Or no, Mr. Wood said he wanted it in. That was a court's. Okay. All right. Well, let me one then. I talked about interest yesterday. This is on page 42. Do we still think interest is a charge we're putting in here on behalf of the plaintiffs?
Yes, Your Honor.
Okay. Any position on the defendants?
Yes, Your Honor. There was no liquidated demand. And so without a liquidated demand, pre-judgment interest is not allowed.
All right. The charge does refer to liquidated demands, Ms. Brown.
Contract damages at issue is absolutely a liquidated amount, Your Honor. We have testimony.
The failure to pay one, not the rest of it.
Correct. And of course, we would be asking, Your Honor, on the back end to do the statutory interest calculation on a non-disparagement damages award. And so I think because of the way you set up the verdict form and those being separate line items for them to decide, it's really easy to say, okay, the breach of contract for failure to pay settlement, the fee splits for all the settlements, that's liquidated, and we can easily on the back end add the interest to that. There not be any confusion as to the non-disparagement.
All right. Well, I agree that one aspect of the liquidated demand relating to the failure to pay is a precise figure that would be.
But they would not be entitled to find interest on any other element of damage.
And so we can clarify that.
In our record we've taken exception to the charge.
Amount of damage, I think we could clarify exactly what we mean by what is the liquidated demand here. So we could say all liquidated demands, which here would be the failure to pay. Okay.
Again, if the court is going to allow that, that would only be allowed as to L. Linwood PC, not Linwood. And so we would urge the court in charging to be cognizant of the fact that we don't want any confusion that they may think interest applies to whatever they find. And again, urge that L. Linwood cannot be held liable under the clear terms of the agreement for not paying monies himself, and certainly therefore not paying interest on those monies. L. Linwood PC can be.
Okay. All right. On just focusing on the interest clause here, the language I would propose adding would be all liquidated demands, comma, which here could include the failure to pay sums owed by the settlement agreement, comma. Whether by agreement or otherwise, the sum to be paid is fixed and certain, bear interest from the time the party shall become liable and bound to pay them.
Your Honor, we're fine with those edits. We're also fine if the parties just want to take this out because I believe it's a legal thing that the court does on the back end as a matter of law because it's provided for under statute.
Okay, so now the plaintiffs are withdrawing this charge, and so does the defense sticking to their position to withdraw it as well? Just
Withdraw it. They withdraw it. I don't have a position.
okay,
Made my record, but they're withdrawing it.
so it'll come out entirely. All right, contract interest is out. There was one more I would just wanted to draw attention to. This would have been at the top of page 39. I think I had it italicized. This is one, a plaintiff's requested charge is from a Georgia State Bar advisory opinion. And the defendants had objected not so much as to this being an incorrect statement of law, but just saying that there were other things that should come along with it. I wanted to clarify whether the defendants are saying that comes out entirely or whether they're just saying it needed more context, because that was the form of the objection in the motions.
We're on plaintiff's request number 63.
That's right.
We obviously have accepted it.
I don't know.
Oh, I thought you made reference to our,
You'd filed an objection, but it wasn't to, I didn't read that objection as saying strike it entirely. It said add more.
well, I mean, I'll address it after they address it, okay?
I think they just want it in as is. I'm more just saying, do you agree with this sentence?
I think it's an incomplete statement of the law. I don't think it's adjusted to the facts of this case. And left without further instruction on the law, it doesn't give them the basis for determining what it means to be part of one firm and another. And advisory opinion, I don't believe it's the law.
I mean, that's all I wanted to clarify is that you're saying it should stay out altogether. And
Yeah, it interjects far too much speculation.
and I will I guess sustain that. Objections preserved, but when we're getting into advisory opinions that don't have the stamp of approval from an appellate court, I would get a little hesitant on that, especially when it's in probably that sentence is found in a greater context that implicates a lot of other issues that may not be at play here. That's all I think that I wanted to point out. So now I'd put it back to the defendants whether there are any more charges that they wanted to discuss. Everything's been preserved, but were there any wordings or phrases or clarifications that you were wanting to address?
Your Honor, bear with me 1 second. Again, unfortunately, we're working off CESA copies and so.
All right, while he's taking a look at that, why don't I bounce back to the plaintiffs?
Yes,
You
Your
said you
Honor.
wanted to come back to one.
Yes, going back to page 48 for the
Okay.
charge on
We can.
fraud.
Can't keep up with her and do this too.
Okay, well, we'll come back to yours because yours, I just want to take things as they're ready. So on 48,
I appreciate Your Honor pointing out the charge above about the misrepresentation of the contract. I think that helps streamline this. This first paragraph that's been edited slightly that starts the March 17th, 2020 agreement. I think it's a little confusing in the sense that it wraps up any act or omission that occurred prior to the March 17th, 2020 agreement when the charge of fraud is in relation to any statements not within the contract itself. And so the language that was struck previously based on pre-contractual representations not in the contract, I think is more in line with Georgia law on this issue and in line with the type of fraud claim we are asserting here.
If I might ask, what instruction number is this?
They are talking about 48.
Instruction number.
It's the language here that begins the second paragraph, essentially, the March 17th settlement agreement.
So it would read, the March 17th, 2020 settlement agreement precludes potential fraud claims based on pre-contractual representations not in the contract, but not misrepresentations within the contract itself.
I'm not clear what, you've got certain parts of that struck. So the March 17th, 2020 settlement agreement precludes potential fraud claims arising from acts or omissions that occurred or commenced prior to March 17, 2020. I agree that's correct. But not apply in effect to misrepresentations within the contract itself. I understand that they're taking the position that there are misrepresentations within the contract itself. So I think that charge is fine. As written.
Okay. I think when taken together as a whole, I think it's accurate. It's tailored to the facts, but not excessively so. I think it's a correct statement of law. I think it provides some clarity the juries may need because there's arguments about this merger clause and just exactly what does the settlement agreement allow a claim for and what it does not. I see it bringing clarity here. So unless you have anything additional, I would say I'll leave it as written in 48.
Okay, Your Honor, thank you. In the next sentence, then I think for clarity purposes, if we could, at the end, it says promise was made, change that to the time the settlement was made. So it would read.
Okay.
You may look.
Understood. All right. So instead of promise was made, it would say the settlement was made.
Settlement or settlement agreement.
Settlement agreement.
Settlement agreement it is. Anything, I think that finishes up plaintiff's concerns. And so back towards the catch-all, any other things we need to highlight on behalf of the defendants before we turn to the verdict form? Back to you.
On page 37, request number 48. Combination, I guess, of two. We would take exception to the definition of the term firm or law firm. Ooh, looks like it's being cited from a committee comment. And it is slanted. It gives you one example of what happens if somebody's sharing space and occasionally consulting versus if they present themselves to the public in a way that suggests they are a firm. Conduct themselves as a firm. We believe that Rule 14, the Rule 1.5 makes clear that if the parties are not in the same firm at the time of the agreement, we could have had our own legitimate partnership prior to March 17. We didn't, but let's assume that we did. That partnership agreement terminated on February the 14th when I terminated it and they also terminated it. So there was no relationship at all as of March the 17th. And therefore, whatever existed before that in terms of our relationships is irrelevant. The question is, did we have any relationship on March 17th? The answer is no. They were in no way connected with my firm. I was in no way connected with their firm. So Rule 1.5 applies on its face. And you can't go back and take the past and turn it into the present. The relationship ended on February the 14th mutually. And that was a month and 3 days before the agreement was executed on March the 17th. So we don't believe that charge accurately sets forth the law. We do not think it is tailored to the facts in the case, and we don't think it applies. I think it's a misstatement of the law to try to have the jury go back and reconstruct what the relationship was when the facts are undisputed, both from my evidence and their admissions, that as of the 17th of March, there was no relationship, period.
All right. I would clarify something with this paragraph, though. I think it needs to better track the comment here. I think it's largely based on it, but I want to make the wording even closer. And so there's a sentence that starts with however,
Yes, Your Honor.
and I think I would change that to be what actually is written in the comment. So instead of that sentence where it says however, it would be the terms of any formal agreement between associated lawyers are relevant in determining whether they are a firm, as is the fact that they have mutual access to information concerning the clients they serve.
And there was no mutual access to client information as of March the 17th. So we're left with the undisputed fact that that rule, that even that comment does not apply here. The relationship had ended. They had no mutual access to client information. We weren't conducting ourselves as a firm on March the 17th to the public or otherwise. That ended February the 14th, a month and 3 days before the agreement.
All right. I believe that what's reflected on 37 with these changes is going to be almost a verbatim statement of the comments to the rules of professional conduct, specifically Rule 1.0 Comment 2 and Rule 1.5 Comment 8. Those comments are approved along with the rules themselves by the Supreme Court. I think they're all implicated here. And so I think they're an accurate statement of the public policy here. And I'll give that as written in the comments.
And for the record, we accept to it, there's no evidence to support that charge being given.
All right.
I apologize. Can you read what the change is again? It's a little difficult to.
I'm going to give you a final version of this. We're going to step out and take 10 before we would start closings. And you'll get that omnibus version again. But essentially, it's just going to be that however sentence is going to be the sentence from the actual comment, which is the terms of any formal agreement.
The however sentence is in the.
Oh, there's two of them. Well,
However they present themselves.
okay.
We don't think,
The terms of the formal agreement coming after that.
Okay.
All
All right. I'm just going to give you the whole comment.
we don't believe that the one of however 1.5 does not prohibit or regulate fees in the future for work done. That's not applicable to the facts. It's an incomplete statement of the law. And it flows from the incorrect charge on law firm or law firm. In other words, if our firms divided, as we know they did, and they were totally separate as of March the 15th, 17th, if the plaintiffs were contending that they were owed a fee prior to the date that the agreement, that the relationship ended, then we could argue over whether that applies. But here, the fee was not earned. The fee was contingent. LN Wood PC was not entitled to the fee until the money was actually paid by CNN and delivered to Lynn Wood. The contingency was always, the fee was always contingent upon receipt of the settlement proceeds by Lynn Wood.
All right.
That contingency occurred after the 14th of February. It occurred after March the 17th. it occurred in June, by the 24th. That's when the money was actually paid. And
All right, so I'll note the objection, and I think it's been preserved, but I'm going to give the comment to the rule as noted. I'll have that exact language to you in the final version.
Thank you.
Are there additional things to be raised by the defense as relates to the charge?
respecting on page 41, Vale Pearson. Again, for the reasons I've set forth.
I don't want to hear the same reasons again. If you've got new reasons or new ground.
Sorry, I didn't know we'd covered this one.
We did because we talked about 41 already.
Yes.
Okay, and I accepted to it.
Absolutely.
All right, thank you.
Absolutely.
Record will reflect. I agree with Your Honor's charge on remote or consequential damages. Remote damages are not a full.
They've already said they want it in, and so there's no objection to it.
Okay.
No, they're saying it's in. You don't want it in?
No, I believe that it should be in just like you have it.
Okay, it's in.
I understood, Your Honor, on this, back to this issue of impossibility or impracticability. You have in 62.2 on page 50. Looking at the question of foreseeability. And it looks like you've got it in here. So what you're actually, in part, jury could find that Mr. Sandman's refusal to consent was a superseding, intervening, independent cause, thereby relieving the defendants from liability. Am I right?
From the contract being enforceable. That's right.
And you've got that charge in here.
That's right.
Thank you.
Okay, then hearing nothing else, let's turn to the verdict form, and I'll start with the plaintiffs.
I know we went back and forth a little bit yesterday before we recessed, Your Honor, about the organization. And I believe we're good on the organization. That's our final decision. We like the way that Your Honor organized it after having some time to think about it. In terms of 1A, we request that for nominal damages just be taken out and just have a line item for them to insert what damages they want to award there.
Any preference from the defense?
I think that's correct. I don't think nominal damages are applicable.
Well, there's a charge for it. And
Contending that they have damage. I mean, I haven't heard any damage proven.
which then could implicate nominal damages.
Right, but they're taking nominal out.
Well, they're asking that the line item be taken out.
Yeah, so they're not asking for the jury to find an amount for nominal damages.
Oh, maybe let me clarify this. Are you saying the word "or" gets taken out, or that any reference to nominal damages in here?
Both, Your Honor, to taking out nominal damages and or altogether.
Damage for failure to pay. That's not. It wouldn't be damages for failure to pay.
There's
It's more
the breach of the non-disparagement comes later, if that's what you're getting at in
No,
number
I'm-
2.
I'm looking at where you're talking about coming off of the verdict form, part 1, which is breach of contract,
Correct.
damages for failure to pay. It has to be more precise than that.
What would you propose?
Consequential damages found from the breach.
Okay, so we want to make that,
Have a failure to pay, and under a certain set of facts, there's no damage. So what I'm saying is either they've got provable damage, which I believe they do not under the evidence, actual damage, or they're going to be asking for nominal damage. But they can't have both. And the way they do it, well, by just saying damages for failure to pay, that opens the door to both of those or more. I mean, the damages are defined
Why
by
don't
law.
we just
The
put
damages are,
damages?
excuse me, the damages are defined by law. It's not just give me the damages for failure to pay. What kind of damage? Special damage, consequential damage, actual damage, or if none of those, nominal damage. So it needs more specificity.
so you like the division of damages in one, I had that as kind of a lump all category, any and all damages in one category, but if you haven't found any of that, you're going to be instructed you could still find nominal damages, and those are separated.
Where's the one on?
You're still referring to the bottom of page 1?
Yes.
That's right.
Yeah, I was looking for where you had the,
Okay,
they're not entitled just damage, they're entitled to consequential damage, meaning what they can show actually occurred as a result
Okay.
of the breach. I know they're contending that they didn't get paid. That's the amount of money they thought they should be paid. But beyond that, there are no other damages that are allowed by law.
all right, noted. And so let me keep going in order. Plaintiffs, what other issues or things you want to raise about the verdict form?
And 1B, the suggestion that we proposed yesterday, that the language be changed to that the plaintiffs
Yeah.
were previously associated in the same firm to track the language.
Well, that would track the language of the comment, but not necessarily the rule, right? So
Okay,
you'll be able to use it, but I think I'm going to track the comment itself. Or not the comment, the rule rather.
that's it, Your Honor. Thank you.
Okay. I mean, I do think there is value to delineating between that nominal damages is this other category, and it could preserve issues that may come up later. So
Your Honor.
they're going to be instructed on both. So otherwise, I'm not hearing anything else then on the verdict form.
I've got one more.
Oh, I'm turning it over to you.
Okay, well, I've already taken my position.
Right. And I'm gonna keep that separate. Damages and nominal damages are going to remain
Yeah, I've already-
separate.
So I'm looking at 1B. If you were found in favor of the defendants, did you find that the plaintiffs and defendants were previously in the same firm? That is not the standard. Nicole and I were in the same firm previously when we were together at Powell Goldstein and Brian Cave, and we were both equity partners. So the answer would be yes. That's not the issue. The issue is whether we were in the same firm
Ellen
at the
Wood.
time the agreement was executed.
Okay. I will add Ellen Wood PC to make sure we're referring to the exact firm.
Fine, we're fine with that, Your Honor.
But I disagree with you as to the time frame and this finding.
As long as it's noted that
Yeah.
I believe the law is that it's determined at the time of the execution. And so I would accept the charge as not being a proper statement of the law, not being conformed to the facts of the case.
So then that special verdict finding would be that the plaintiffs and defendants were previously in the same law firm, comma, Ellen Wood PC.
That's fine with the plaintiffs, Your Honor.
All right.
At the time of the March 17th
Right.
agreement, that's the key.
Noted for the record, but I don't plan to give that extra component.
We believe that's the law, so we take exception to your failure to do that or state that.
Anything else in the verdict form?
We object to number 4. We don't believe there's been any evidence that defendants have been stubbornly litigious.
No, that's taken the form of a directed verdict. So we're past that point. That's taken the form of a directed verdict. Right now, I'm just saying the form of the verdict.
Well, that form, that verdict does not conform to the evidence. Stubbornly litigiousness, you can disagree on the law, you can disagree on the facts. That doesn't make you stubbornly litigious.
All right, well, I plan to include question 4. Anything else with the verdict
So
form?
we've accepted to it, and I guess that takes us to the end, don't we? So thank you.
All right, well, let me consolidate all that. We're going to print everyone
15
copies. And yeah, we're going to, let's get back and I'll be checking in with the jury, bring them in around 2:30 because the plaintiffs are going to be kicking it off. And we go from there. Go ahead and get your multimedia set up if you
Yes,
have
Your
that.
Honor, we will.
All right.
Thank you.
In recess until 2:30. Deputy Scott, if you can let them know, we'll be started at 2:30. That's right.
Yeah.
Could have done that one without you, JG. About 15 minutes for show time.
C, yes, I have C. Christina has some sort of attempt. Oh, yes, C. What happens? You just.
Choose to mirror or extend from the view.
Do you know how long trains proposals going to be? Because I didn't say it.
Right. I heard it mentioned the statutory requirement.
Yeah. It's just. Yeah, it's not. Can we try a different input on there?
I'm sure it's 3, but. I'll have to.
Jonathan. We'll get your copy of the managers. It says it is on. Mine's connected and it says it's mirroring, but it's just not. The TV isn't seeing it. Where's Christina? Maybe if I plug in.
Here, let me see that. And go grab my computer. Oh, sorry. Oh, yeah, can we use Christina's computer for it? Okay, so.
No, that's one cord.
Definitively. This is, that's 3, that's definitively 3, so that's.
Well, I did. That's not true. I did. It's just how it uses myself. Stay working.
What is this called? Is this called a MacBook? Is it called a MacBook? Which one? Why? Why won't a MacBook mirror on an LG TV? Christina, can you give her your computer?
I need my computer, I'm doing the exhibits.
Oh, you're doing the exhibits?
Yeah.
Okay. Shoot. Okay. Guess I'll try to use her computer for my stuff. This won't mirror with a. It won't mirror on a MacBook. It's my brother,
Let me
my
see this.
computer. It's definitely 3.
I know, but this is different. I just.
Okay, that one works.
This is mine.
That's, so you can use Michael's, we'll just drop it on that with a, we'll have to use a.
What's
Mine
going on?
works.
Okay, what do we have? Do we have it
We
on
have to
there?
get a dongle. Well, we gotta get a dongle. Christina, you're.
I have dongles. What do you need? What
Can
kind
I
of?
sign into?
The USB. You got a USB?
Yeah.
Okay.
To USB.
It's gonna take a long time to download. it.
USB-C?
Can I just sign in
USB-C.
on my
Yeah.
SharePoint on your thing, on mine?
Yeah.
Let's just sign into our thing on his. It's gonna.
This internet's really slow, John.
Oh, thumb drive. No, I do not have it.
Here.
I'm sorry.
It's okay.
You have a thumb drive?
Try it.
Thank you.
Try it. What, we can't have your computer?
You're not gonna want to use my computer because it's not a Mac.
You could do it.
Well, Nicole.
Nicole, it's final?
Yeah. Well, this is gonna be, I guess.
Just in case. Alex and suspenders logging on his computer. If not, last picture from user.
Log on.
Just want to make sure you.
Wow.
Yes, I am. Still time for me to lose my notes one more time.
You didn't lose it. I might add. They were safe and secure at home.
In the wrong location.
It's huge. It's not moving. It's huge stuff.
What's going on? What do we need now?
This one just slow. I wonder where this might also be.
That's why I said let's use.
I wonder where the one that Christina has.
Why can't we just hook up your laptop? It's only
That's the last stage we can have on here.
Yeah, we can use the purpose. We can use.
Here, can you unplug that in this hole? Plug that. Get out so I can plug the computer.
This, are you closing?
Oh, thank God, no. I know you'd love that.
No. I think it might be an advantage for him. But. March 17th.
Yeah.
Excuse me. Hey, Brian.
Locked your phone before you today.
Is that volume one?
That's theirs.
It's ours. It's our record.
Oh, okay.
Yeah.
No, it's those notes.
Oh, that's, I picked up the notes yesterday. And I had them just kind of scrounge, ran them in my briefcase bags.
Right.
I don't, okay. Yeah, I don't think he did. Okay, I have that as a note. And then like 2 other exhibits, but I'll check with you after. I do, I put in red highlight which ones was questionable, and then the ones that today were introduced, I have those in black. Yeah, I can, yeah, definitely.
This is the unredacted settlement.
What?
That's the unredacted settlement agreement. It's from the.
Might be muted.
The ones that I was questioning that were probably already admitted, but I have the other ones in black that were introduced today, but we'll go through. Yeah, no problem. No worries. Yeah.
Get my Bible. Here.
Need a certain. You need a certain doctor, or you got it? You and I both.
Oh, this is fine too. Which HDMI is that on? Oh, cool. This is 3.
Let them know.
HDMI 3?
Yeah. You got the.
I got it. Thanks, man.
I have no idea.
Jonathan Grunberg.
There it is.
I think we're okay.
Yes.
Mac, you, oh yeah, mine was set really fast. So you get slow. And slow down?
Yes. So turn it on, hold on. No, what? There we go.
I have a 3-minute preamble. Where I'm gonna do some things before you get the first one.
I'll leave it there to
Good.
tell me.
So I'm gonna mention hatred and stuff, but just in a second, so don't think that's.
I'm gonna
I'll look at you,
just
but
look at
go to page 2, you'll see.
just look at all.
You want these pointers to be super slow?
Not super slow, but just medium slow. Whatever this guy is like insane.
Try it now. It's right here.
Let's see.
Right there.
Just surprising because I thought that was gonna be long. I think this is gonna be short.
Yeah. Okay, how is it now? What?
I know this is. Jonathan and Bloomberg, use soft Jonathan and Bloomberg, use Jonathan and Bloomberg.
Okay, got it. Check. But he's doing. All right. Is he gonna give me charges for?
I do, yeah. Staying them together, it's gonna be a blast.
No problem. It's all good.
Right is the time it is right now.
So with the blue number, that's like,
It counts down from 2 hours.
okay. And so then if you have a or Jeff on. Yeah, so.
Sure, yeah.
I thought I wanted a red one. All right, here's one.
He's the guy we had
The
before.
first,
Okay.
yeah.
Thank you.
Yeah. No, yeah, no, you're fine. That's me. I was just making sure we're on it, but I already had a proceedings.
Don't tell me to.
Both of them orders.
All right, we're back on the record. We're
Oh, you're saying.
printing off the final copy of the charges now. I do have a couple copies of verdict forms if anyone wants their own. Feel free. And I don't want to make anyone start though before we would have that final copy unless they want to. So up to you, Mr. Beal. Unless you're ready to dive in.
I don't know why I was.
I'll just give this one to the court reporter, Madam Court. Of course, exhibit.
Very cool.
Just one copy of the verdict form. Yeah, I'll keep this one. You want to get going, Mr. Beal? You want to wait on that final copy? It's up to you.
You want to see it before I.
I don't think it impacts your closing, but what he's gonna read. But I can do it while.
Well, let me ask one quick question, Your Honor.
Oh, no, they're correct. I know the first one is, the second one,
I think it is because it was only in. Yes.
yes. Close enough to go.
That's not.
Then I think we're ready to rock, Your Honor.
All right, and we're all good up here. Is this
I
being
think
controlled
so.
through Zoom or we're gonna have someone sitting up there again?
Ms. Wade's going to sit up there because she's the only one that knows how to.
Okay, all right. That's, yeah, well, yeah, let's let the jury come in first. All right, any reason we can't proceed with the plaintiff's first closing on behalf of the defendants? All right, if we can bring in the jury.
You pass out the final charge, I'm sorry.
We're printing it right now. Okay. And I'll note that the consolidated final charge that I'll give and also give to the jury will be marked as Court's Exhibit 4 and tendered. Final charge.
That final charge on.
That is, and you should have your own
Before
copy.
the jury comes out, can we just make sure?
Yeah,
that-
take it.
That what we
Take it.
said.
You should have your own version. Did we give you one?
No,
We're
you're
putting the
right.
rest.
Oh, okay. Yeah, take a look at that.
I just emailed.
Hold on one second, sir. Got it.
Maybe we can.
That is correct. Yeah, we didn't say this. So we're fine. And I think this is acceptable.
I think we're good, Your Honor.
Sports copy, give that. That's the court's.
Yeah, that'll be court's copy. Thank you.
Thank you so much. We appreciate you guys. doing all that.
All right.
Mr. Hook, your copy.
Ma'am,
there.
I'll give you this one too. There you go. All right, and then you can just knock on the door so he knows.
Back. Speak up. Put it on there.
Thank you, Deputy Scott. Members of the jury, thank you for your patience. We are now ready to begin closing arguments in this case. The plaintiff, because they have the burden of proof, goes first, and they also have the right to open and conclude closing arguments. I'll remind you at the outset that closing arguments are not evidence, and the evidence presented is as you recall it. And with that, Mr. Beal, you may proceed when ready.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. We've been through a lot together. I apologize for the tremendous volume of details and facts. It's been a long case, and there's been a lot of emotion in this case. And I apologize to the extent that you're sick of this case. That's my fault. To the extent that there's too much emotion, I take responsibility. That has nothing to do with the problems. What I like to do in a closing is go back to the opening and see what we've proven and what we haven't proven, what we promised and what we delivered. And at the end of my closing, I said, thank you. I said, thank you for everything that you have done and the tremendous patience that you're going to have to show as you go through this. And that's a tremendous patience I've seen and we've all seen. And I said, it's an awesome responsibility that you have. And that's not awesome like, gosh, this is great. Awesome as in it is huge. Because ladies and gentlemen, only you can bring justice. The judge makes rulings. The judge controls the case. The judge controls what evidence comes in. All of those are important things, but only you bring justice. Only you, through your verdict, can speak truth Thank you. All fraud cases are by their very nature subtle. They generally involve a lot of facts, a lot of documents, and they can be tiresome and confusing. And this case is similar in one sense. But in this case, we have a unique pattern. We have what my late law partner was able to write into the law, what's called a convincing mosaic. And it was a case that Ed was working on back when that law became a convincing mosaic, was a very different type of case. But what he was talking about is that all the facts fit a pattern. They tell one unified story. They show one plan. They follow one path. And that's what we have here. And beyond that, we're blessed in this case in that we have hard evidence. Usually a fraud case is, speculation, innuendo. You have to make guesswork, but here we have the defendant's own words. We have the defendant's own words, and you'll hear them. You've heard them, excuse me. They show his hatred of the plaintiffs. And it's more than just he cursed at him, he lost his temper at some point. This is a systemic pattern of hatred. And why is hatred important in this case? Because he hated them enough to extort them. Not just that he got mad at them, but he hated them enough to extort them. And he hated them enough to commit fraud. And that is what happened here. And then we have the defendant's own words of his plan. He's waived his attorney-client privilege with Alston and Byrd so that he could hide behind their opinion. And clearly, he sets out his plan, because when he's saying something nice to the plaintiffs, you're going to see the evidence of what he was saying behind their backs to try to hurt them and break this deal. And then you're going to see the defendant's own actions. You heard his testimony. I took all that money. I took all the other money. And you saw the bar rule about holding the money in escrow when there's a dispute. And it was clear. So we've got his words. We've got his plan. And then we've got his execution. And so this is a convincing mosaic, ladies and gentlemen. What did the defendants put forth? Speeches. A lot of speeches. Speeches about the defendant, how great he is, how great a trial lawyer he is, how he's a man of God, couldn't have done any of this. We have direct evidence. We have his words, his actions, the actions of his lawyers. That's what we rely on. That's what we ask you to judge the plaintiffs on, not some talk about how great they are and how you ought to overlook the facts. And you'll notice, ladies and gentlemen, that the majority of the defendant's evidence was just about himself. And it was about the good old days. It wasn't about this event. It was about his success and how much money he's made. That's all great. But we're here about the facts of this case. He asked you to look at what people thought of him years ago. We ask you to look at the mountain of evidence that we have put on here today. Burden of proof. You heard the judge instruct you about burden of proof. Burden of proof, in this case, the plaintiffs accept that. They have to prove their case that it is more likely than not. What does that mean? There's an old speech. Imagine, if you will, the scales of justice. And they're equal. Somebody puts a feather on one side and it tilts a little. That is all that is required. But here, all the evidence is on one side. And I don't say that lightly. Had enough emotion to last a lifetime. So let's just go through what we ask you to review. Go ahead.
Jonathan Grunberg, you sorry, slimy piece of shit. How do you look at those babies? That's how serious it is, you little fucker. You look in the mirror and you're gonna see a Chilean Jewish fucking crook. Let me tell you something, you little snotty ass son of a bitch. Don't write me back and tell me you're taking care of your son. Your son's looking at the eyes of a damn low-life, cheating, lying, probably criminal defendant. You're lucky I'm not with you right now, Taylor. Because I do to you what I do to my son, and I will beat your ass with a switch till you couldn't sit down for 20 fucking years. Taylor Wilson, listen carefully to me, young man. This is the last time you're going to hear my voice until I cross-examine under oath your sorry-ass lying motherfucking bastard. You are going to hell, and God is going to condemn you. You'll rot in hell before you'll ever get a dime from me, young man. You're going to pay out of the nose, and you're going to lose your license to practice law. I'll see you next time, and you are under fucking oath.
All right. The judge will charge you in this case that Rule 1.5 only applies to a division of fee between lawyers who are not in the same firm. Does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm. What does that mean? Associated in a law firm. Well, first of all, the key here is were previously associated in a law firm. The defendant doesn't want you to hear that. And his lawyers charging $900 an hour, $875 an hour, and charging them almost $1 million, didn't want to talk about it. When they were previously associated in a law firm. And what does associated in a law firm mean? You'll not be charged on the specifics of what that means because there isn't a clear law on what associated in a law firm means. However, I anticipate that the judge will charge you that you may use your common sense and you are charged to give words their plain and customary meaning in usage. In other words, you don't have to put your common sense aside. You apply some technical law, but you use your common sense and you give words their plain and unambiguous meaning. Associated in a law firm, go back for me, I'm sorry. Associated in a law firm is a broad term. Why did the State Bar of Georgia create a rule that used these words? I submit to you, ladies and gentlemen, because they wanted it to be broad. It's the State Bar of Georgia. It's lawyers who are specially chosen to regulate other lawyers. These fellas know how to write, okay? They know how to worry about language. That's kind of their strong point, all right? And when they said associated in a law firm, they wanted it to be as broad as possible. And they achieved that goal. And using your common sense, we believe that there will never be any evidence to the contrary in this case. And I'm not running from any facts, but I'm saying all the facts support the idea that they're part of that firm. There's no requirement that the lawyers be partners, although he referred to them constantly as partners, or associates, or owners, or independent contractors. All permissible under this. How do I know that? Am I just talking out of my hat? Well, let's look at what the State Bar of Georgia tells us. Rule 1.0, law firm denotes a lawyer, lawyers in a private firm, blah, blah, blah. That's the definition. You heard Joey sit up here and say, well, I think when they said the word in, that means you had to own the firm. That is not in the law. The judge will not charge you in that. And I submit to you, ladies and gentlemen, that violates your common sense. That's like when Bill Clinton said, it depends on what the definition of is. What? Come on. In means ownership. It says, are you in a firm? It means you own the firm. And the State Bar of Georgia couldn't take the time to say own. Ladies and gentlemen, that is not credible. These were lawyers that were paid by Mr. Wood to create an excuse. Whether two or more lawyers constitute a firm within paragraph E can depend on the specific facts. For example, two practitioners who share space and occasionally consult or assist each other ordinarily would not be regarded as constituting a firm. However, if they present themselves to the public in a way that suggests they are a firm, or conduct themselves as a firm, such as maintaining mutual access to client information, they should be regarded as a firm. So this means State Bar of Georgia said there's two tests. How do you hold yourself out to the public? And how do you protect client confidences? Are they limited to just one lawyer? Or are they shared with all the lawyers? Why? Because it's a clear ethical violation. If one of you hired me, I can speak with Ms. Brown and say, all right, well, I'm working on this case, but I can't share it with Judge McAfee. I can't walk down the hall and find a buddy of mine in another firm and say, hey, I want to talk about a confidential case. I can't do that. Why? Because he could be on the other side. Judge McAfee could be sitting in judgment on you in a civil or criminal action in the future. I got to keep it confidential. So those are the two tests. What did Lynn's own lawyers tell him? They quoted this that is virtually identical. And then elsewhere in the report, it's Exhibit 95. Elsewhere, this comes from page 9 of Exhibit 95. They quoted it to him, and it still didn't slow him down. Why? I submit to you, ladies and gentlemen, they were paid to create an excuse. They then said in another section, as comment 8 suggests, Rule 1.5e may not even apply to work done when lawyers were previously associated in a law firm. Of course, they cite something other than the actual Georgia law, but the reality is they knew what the truth was and they knew what Lynn wanted, so they were struggling to find an excuse, thinking they were going to capitulate and I was going to roll over and he was going to pay them nothing or a very small amount of money. And this was all a smokescreen to say, woo, big firm, going to chase you. You better run away. And to them, oh, it's going to cost you a lot of money. You better run away. It didn't happen that way. Not with these three. So let's talk a little bit about the chronology. Nicole becomes a non-equity partner. Advertised as such, you saw the contract. I think it's Exhibit 16. The happy camper email, or as Mr. Wood would insist, the unhappy camper, is from 2018. And he says your LLCs will each be non-equity partners in L. Lynn Wood PC. And what happens after that? Jonathan and Taylor become non-equity partners of L. Lynn Wood PC, and they're publicized. How do you hold yourself out to the community? Exhibit 6 is how you do that. And throughout this time period, all the pleadings are being signed by them as members of the firm, part of the firm. And then you saw at the very end, you saw Exhibit 18. and you saw at the very end, Exhibit 406, I think it is, all of the pleadings that they submitted to the court showed that they're members of the firm. On the website, who are the attorneys? All listed as partners with combined years of experience. These are not office sharing. And it is offensive that that even is implied now as a defense when none of this ever references any of that. This would be an ethical violation, ladies and gentlemen, if it weren't true. The state bar would have brought charges against them. You can't hold yourself out as something that you're not. This is what it says on the website. I can't create a website and say, come hire me, and put a picture of Brad Pitt and say, oh, it's Drew Beal. That is unprofessional, it's unethical. It has to be a picture of me. We saw all of the pleadings that were filed, and in each case, they sign as members of the firm in federal court, ladies and gentlemen. And what happened when Stacey Evans left Wood, Hernacki, and Evans? And why did she do that? She, as defendant finally admitted, she wanted to run for governor. She was a very charismatic, popular lawyer, and she made a run for Democratic candidate for governor of the state of Georgia, and she didn't even make it through the primaries, but that was her dream. And so she stopped the practice of law and she was phasing out. And during the time she was phasing out, she was in a separate firm. How did she sign everything? As her own law firm. Because she wasn't a part of L.N. Wood. The opposite of what these three did. Wood, Hernacki, and Evans had three partners. And you will see this exhibit, but I can't remember off the top of my head what it is. I apologize. But interestingly, all three of them are LLCs or PCs. And Mr. Wood sat up here and said, I never once said that because they were an LLC or a PC, they weren't part of my firm. But now because they have an LLC, oh, they're not part of my firm. You saw all of those rules. Not one of them says you have to own the firm. Not one of them says you can't be an LLC. Not one of those rules says you can't be an independent contractor. In fact, the bar rule specifically refers to it could include independent contractors. This was a made-up defense, ladies and gentlemen. Go back before we move on. But there we go. Separate LLCs. Oh, you did. We did cover that. Sorry. There is nothing that requires written partnership agreements. Nothing. Now, certainly that would be admissible in the case if it did exist. But I'll represent to you, Your Honor, ladies and gentlemen, that there are many partnerships all throughout the state of Georgia which have no written partnership agreement, and they are very much in a partnership. In fact, the Georgia Bar has determined that approximately 40% of all small partnerships in Georgia have no written agreement. Does that mean they're not partnerships? No, it does not. There is no defense because Rule 1.5 cannot apply because they were clearly associated in a law firm. Ladies and gentlemen, the numbers. Breach of contract. For the Carboni case, approximately $55,000. For Sharon Lindsay, $34,200. For Nicholas Sandman versus CNN, $843,000. For Nicholas Sandman, Washington Post, $101,250. And the total is $1,034,199. Why is there no deduction here for rental payment? Because the entire purpose as reflected in Exhibit 102, was to get a release in exchange for making the payment. And no payment, no release was ever obtained because they specifically wrote back, and you saw that in Exhibit 103A. They wrote back to the lawyers and said, don't give them a release, parenthesis, although you have agreed to do so. Don't do it. And they did this in July, 3 days before they rejected the whole deal. 3 days. And you have to ask yourself, ladies and gentlemen, why did they do that if it was not an intent to harm the plaintiffs? All right, now we get to the next phase. What is fraud? Fraud is a promise made without a present intent to perform. Excuse me. A promise made without a present intent to perform is a misrepresentation of a material fact and is sufficient to support a cause of action for fraud. Actionable fraud can exist where a promise as to future events is made with a present intent not to perform, or where the promisor knows that the future event will not take place. Ladies and gentlemen, I anticipate that the judge will charge you that this is the exact definition of fraud, or where the promisor knows that the future event will not take place. Let's look at the evidence of fraud. Lynn never intended to comply with the March 17th settlement agreement. He never intended to pay them the money he agreed to pay, and he never intended to abide by the non-disparagement. And how do we know that? His own words, his conduct, his dealings with his own lawyers and with Todd McMurtry and with Nick Sandman. Sandman settlement settles in early January, late December 2019-20 timeframe while they're all working at the firm. Taylor Wilson begins drafting the settlement documents. Ellen Wood attempts to rebrand Ellen Wood PC to Wood, Wilson, Grunberg, and Wade. But then things get terrible immediately after that. He says,
watch what happened with Sam and Tree. I'll show you what I think of what you done to me.
and this is February 10th. Watch what happens to the Sandman fee.
Business as usual is back now being business as usual. Keep doing what you're doing on the cases you're doing. I don't need your hours in case, I never have. No reason to do it now except in billable cases.
I don't need your hours in any case. I never have. The defendant is admitting that he has instructed them, don't keep a record of your hours. And that's another way he defends this case. Oh, hey, you had a separate LLC and you don't have contemporaneous time records of all the work that you did. And we would contend, ladies and gentlemen, that's a fraud. If I tell you not to do something, don't worry about it. And then I come back later and say, hey, well, you didn't do that, so I'm not going to pay you. Imagine if I hired somebody to put a roof on my house and they get out there and they work in the hot sun. We agree it's going to be $10,000. They get up there and they say, well, Mr. Beal, we have these gray shingles. And I know you were talking about the brown shingles. And I go, that's fine. That's fine. Just put up the gray ones. That's fine. Go ahead and do that. They get up there in the hot sun. They rip off all those old shingles. They put up all those new gray ones. And then at the end, I said, I'm not going to pay you for that because you put up gray ones and we talked about brown ones. That would be a type of fraud. I promised them that I would pay. I promised them that the gray shingles were just fine. All the while knowing I was going to insist on brown. If I'd said it up front, he switches them, refunds them at the hardware store, gets the right color, puts them up. And how about a line of credit? How about I hire that same guy and he puts up the right color shingles and everything's fine. He goes, okay, Drew, you owe me 10 grand. And I say, no, I'm not going to pay you 10 grand. I'll tell you what, I'll give you a loan of 15. How about that? How much money has that roofing contractor made? It's made zero. In fact, he's paid me interest. He gets 15 grand, but he has to pay every penny of that back plus interest. He didn't get paid for the roof. I get a free roof, plus I get a little interest. Now let's talk about the smoking gun emails. Couple important things. Number one, ladies and gentlemen, 2 of them are written on February 22nd. 1 of them is written on March 4th. We'll get to that one last. February 22nd. On February 17th, he enters into that agreement with Taylor Wilson. Okay, we're going to split all these cases up. We're going to do this. But what does he testify to that you saw the videotape deposition? I was just playing with them. I wasn't inclined to give them any of that money. I was just testing them to see how greedy they were. So he enters into the February 17th agreement, deliberately knowing that he's not going to perform. And that's not a cause of action in this case, but it shows a pattern and practice of fraud. And then these emails, interestingly, they don't show up in this case until Mr. Grunberg has some kind of a conversation with that woman, Nikki Baker, who's a lawyer out in Nevada. And they happen to be talking, and she says, how are things going? I know you left Lynn. They're talking. And she discloses that she's got these. They were never produced in discovery in this case. Even though a lawyer has an ethical duty of truthfulness to respond to discovery and produce documents that are called for, they were hidden. And you'll see.
John, your arm may approach. Mr. Fields.
Let me make sure actually can put this here.
Mr. Fields, why? The documents from Nikki Baker were produced in she searched our emails. She did not search on the file of Nikki Baker, and she missed it. And you did miss it. But this idea that they didn't get it, it's just a lie. Satisfy the court at the time that we have not intentionally given anything.
So without weighing into, what did or did not happen, what evidence was actually produced to dive into this? I don't think it came up on cross or direct.
Well, we did file a motion to strike as answer based on the fact that that didn't happen, and they all produced to the court, and the evidence around whether or not we did.
And we did, and we did.
Let them
Well, they got 2 wrong. I don't know why Marjorie didn't produce it. I'm responsible for him. I know why we didn't produce it. They moved to strike. Court denied it because we had it on the affidavit. It's from the affidavit of Kimmy Hartman.
Crossed.
Thank you, Judge.
All right, you can proceed, Mr. Beal.
So as I was saying, this was what the intent was immediately before he entered into the settlement agreement on March 17th. Which I will believe will bring this foolishness to an abrupt and unhappy ending for Taylor, Jonathan, and Nicole. If they realize they're not going to receive $843,750 for the Sandman case, they will have no ability to finance their frivolous claims regarding the fees in CNN and the remaining office lease liability. Odd statement. He says, if I keep their money, they won't be able to afford to sue me. And they'll still owe me for the office lease liability. It's clear intent, and I know this is hard to grasp, but it's a clear intent to try to destroy the three plaintiffs. Why? It's up. Your guess is as good as mine. Because they had the courage to stand up to him, because they had the courage to leave, because they had the courage to go out on their own and start being successful, although that hadn't fully happened here. I don't know where all the hatred came from. And you know, I'm a guy that wants to give you an explanation as often as possible, but I other than having the courage to stand up to him and the courage to leave, that's all I can surmise. I need for you and Ted and Julie, Sandman parents, to state in writing they too will not and shall not agree to any fees due to my PC to be divided with any other lawyers except on quantum merit, he means quantum merit basis. And what was he going to do there? He was going to say, I am the sole arbiter of how much you deserve. And we've seen all the emails where he said $100,000, that's all you're ever going to get. And he was going to keep the money. After you heard the testimony about the money that was flowing through Mr. Wood's firm, and he was going to go out of his way to keep this relatively small amount of money from these plaintiffs. In combination, our efforts on Saturday will deliver a knockout punch to Taylor, Jonathan, and Nicole. That's why I said there's got to be a deliberate intent to harm them. He doesn't say, I'm not going to pay him because whatever, and get angry about it. He says it's going to deliver a knockout punch, unhappy ending, deliberate attempt to harm them for some reason. Game, set, match. They're over and dismissed and destroyed, and I feel good about it. Quantum merit is all these greedy lawyers will get despite my coerced agreement to pay them 50% of the fee. My coerced agreement. Ladies and gentlemen, ask yourselves, did you hear any evidence that anybody coerced the defendant into entering into any of these agreements? That they interfered with his relationship with his kids? All you heard was the defendant himself say, my kids are scared of me and will not speak to me. Are scared.
Objection, Your Honor. I
to me.
never said that. My children are not scared of me. I've got letters.
All right,
from my
Mr.
children.
Wood, understood.
That's just improper. He's lying about my children.
Okay. Jury will call the evidence on this issue as presented. You can proceed, Mr. Beal.
Then Lynn emails to Todd McMurtry again, 48. I'm prepared to offer fees on a quantum merit basis only for Carboni and Lindsay. Those are two people that were in the settlement agreement. Lynn's voicemail to Taylor. This is the last time you're going to hear my voice until I cross-examine under oath your sorry ass MF bastard. This is Exhibit 97. But the interesting thing is, when does this happen? This happens right before the settlement agreement is entered into. And then this is all March 4th. So the third smoking gun email is sent on March 4th, the same day he hires Alston and Bird. And he says, oh, I was just hiring them to help me work this out. And Chris said, I wanted to lower the temperature. But this is what he was doing at that time. He was building a plan where he could destroy the plaintiffs. He wasn't hiring an independent firm because he really wanted an independent help in resolving this. He had already told us in Exhibit 48 exactly what he was going to do, which is destroy the plaintiffs. Alston and Bird was a cover, very expensive cover, but it was a cover. This is what his intent was. So then we've got on March 13th, the Sandman hearing is delayed. Okay, he gets notice on the 13th, which is the Friday. The settlement agreement gets signed the 17th, the following Tuesday. That same day, he sends the plaintiffs this non-negotiable term sheet with a 24-hour deadline. Why? Because he just learned how easy this was going to be. Sandman hearing got delayed because of COVID restrictions. So they could wait till he was 18, pressure the heck out of this young man, get him to agree to anything, and completely cheat the plaintiffs. Same day. Coincidence? I submit not. So then how does he edit the settlement agreement? He tells us what his plan is right here. He says, the fee split for legal work, only Lynn Wood's PC shall pay. It's a single member PC. He controls it. He owns it. It is totally beholden to him. Every single thing that happens in that PC is done by him. He controls it. It's not a corporation. He doesn't go to a board of directors, doesn't go to a partner, doesn't go to friends, doesn't go to anybody. A PC is Lynn Wood. So he changes this and says, have never been law partners in L. Linwood PC. But you know, ladies and gentlemen, according to comment 8 and rule 1.0, is this relevant? It is not. No one cares. But have worked with Linwood by agreement on a case-by-case basis while sharing office space. And they said, oh no. And I said, we're not going to take that language. So what was agreed to is they don't have an ownership interest, but have worked as lawyers of L. Linwood PC since 2018. Nobody knew what Lynn was up to, why these strange things were happening, but we do now. So the final settlement agreement is signed March 17th. And the same day he sends the email out to his kids saying these false accusers have held their feet to the fire. Why did he draft in the non-disparagement clause in order to induce them to sign it? Because he wouldn't be saying anything bad about them. But that very night, he did just that. And then he says, please note their admissions today. They've never been my law partners. He's already trying to build a record with family and friends. The settlement agreement is executed at 5 or 6 and handed to Joey in the lobby of his building. And then Lynn sends this email to his family and to Todd McMurtry with the false accusers. Same day. All right. What other evidence of fraud do we have? Well, at or about the time he enters into the March agreement, he drains the bank account of the Lindsay and Carboni matters. So they enter into a contract, says you get 30-something thousand on this and 50,000 on that, 80,000, 90,000 to be shared with the 3 of them. But little did they know that money was gone. It was already gone. He entered into the agreement. He had already taken that money. It was in his personal account. He had an ethical duty to keep it in the Hideout account. Plaintiffs foolishly thought that he was following the ethical rules. That money was in his personal account by then. It was going to South Carolina. That money wasn't sticking around. We've also got, all right, let's talk about Alston and Bird and advice of counsel. I anticipate the judge will charge you as follows. So this is kind of confusing. Why am I bringing this up? Because you heard the Defendants say all the time, advice of counsel, I relied on advice of counsel. Advice of counsel is not a get out of jail free card. It is not a defense in this case. It relates only to your state of mind. That's all. Why? Well, just think how crazy it would be if you didn't have that. So, you know, I steal somebody's money. And then I go to a lawyer and I say, well, I happen to have this bunch of money. Do you think it'd be okay if I went to a country that does not have an extradition treaty with the United States and spent my money? Well, the lawyer's going to say, well, treaty, you can do anything you want to with that money. So then I run away and I say, oh, you can't touch me because I'm working under advice of counsel. My counsel advised me to rob that bank. My counsel advised me to keep all this money that was wrongful. And so you can't touch me. Advice of counsel is never and never has been a complete defense. Lawyers would be judge, jury, and executioner all rolled into one. They are not, and that is not the law. Instead, I anticipate that the judge will charge you that a party may not be relieved from liability for breach of contract on the ground that the party acted under the advice of the party's counsel. Be guided by the law from the judge, not statements from the defendant that it ain't my fault. As it relates to a claim for fraud, an assertion by defendants that they acted in reliance on the advice of counsel is a factor which may be considered along with all other circumstances relevant to the issues of defendant's state of mind. I anticipate the judge will charge you verbatim on that. And why is that important? Well, it shows state of mind and it can show good faith. But what was his relationship like with Alston and Bird? First, he says, I never knew about Rule 1.5. Alston and Bird told me about it. But as you'll see in Exhibit 83 and Exhibit 85, he admits that he talked to Todd about it. He admits that Todd knew about it and that Todd said, he admits that he and Todd discussed it and that Todd spoke with the Sandmans and got their agreement. He puts it in his own writing, Exhibit 83, Exhibit 85. And he thought he was speaking confidentially to his lawyer. And he didn't realize when he waived his privilege that all this stuff was coming out, because it shows that he did know about it. And then we see in May, Joey, as we develop the strategy for dealing with him, he wasn't trying to get a deal in May. He was trying to get a deal to destroy, a plan to destroy whatever agreement he had made. I recall Todd and I looking at an issue at some point, Exhibit 83. Oh, that one's 85, sorry. I recall finding this some time ago. I have a recollection Todd told me. Oh gosh, I'm just now thinking of it. But perhaps even more important, he says in Exhibit 85, I think what we should do is stay silent about it. Does that sound like somebody who's trying to get an agreement to work out? I say we say stay silent and then spring it on him. All right. And what does he tell Alston and Bird to get this good faith defense that he's trying to build? Well, they were occasionally held out to be employees or partners and occasionally working on cases. We've heard all the evidence, uncontroverted, that it was the exact opposite of that. He also told his lawyers they had their own separate law firms. Well, that's just not true. That's just not true, ladies and gentlemen. They had LLCs. You saw it on all these others. I've got a PC. That doesn't mean I have a separate law firm from my firm. It's been the same all throughout the state of Georgia. Every day, WGW is listed as partners on L. Linwood PC's website, worked only for the PC, signed all the pleadings, used the same domain name, and perhaps most importantly, and I skipped over this and I apologize, they had access to all L. Linwood PC client files. Remember Rule 1.0. How do you protect client confidences? They had one server, they dumped everything on it, and everybody had access to it. Why? Because they're all part of the same firm. Exactly like in my firm. If Ms. Brown brings in some business, she puts it on the server. If I bring it in something, I put it on the server. If she says, hey, Drew, I need your help on the Jones case, go look it up and tell me what you think. I just go to one server. Why? Because we're sharing client confidences, because we are in one firm. Lynn told the courts that they were his partners. He announced them as partners in the daily report. On the state bar directory, they're listed as lawyers of L. Linwood PC. He told them to form the LLCs so that he could just pay them lump sums. Whoops. Go ahead. And what was Lynn doing with Todd during this time? Well, you'll see, and it's Exhibit 308. There we go. Exhibit 308 toward the back of the binders. And these are all the phone calls between Lynn and Todd during this time period. It's constant. Remember Todd's testimony? He was blowing up my phone, calling them crazy, saying he wanted to get out of the deal. Texts. You'll see those at the same exhibit. Let's listen to what evidence we have directly from the man who also represented Nick Sandman. Did you come away with a belief as to what Lynn's desires were regarding fee splits in the Sandman versus CNN case based on your conversations with Alston and Bird?
I do not believe that anything that Alston and Bird did gave me an indication as to what Lynn's desires were.
But you had a belief based on your communications directly with Lynn.
I did.
And was that he did not want to share fees on that case with WGW except on a quantum merit basis?
Objection form. I don't know that he was as specific as saying quantum merit, but in that July 2020 timeframe, based upon my conversations with Lynn, I took that he did not want Nick to approve that settlement, and he didn't want to share fees with WGW.
And you were keenly aware of the amount of written product they did because you were working with them on every phase of this case.
In my opinion, as an attorney, separated from my role as a lawyer, I thought that their fee would have been fine. I mean, you could make an argument one way or the other and say 800,000 is too much or it's not enough. So if you had called me as an expert witness to review the work done on the case, I would have found that their fee request was reasonable.
What did Lynn say to you in July of 2020 that made you think he still did not want Nick to consent to a fee division with WGW?
So from the time of the call with Alston and Bird up until July 24th, I probably had 3 or 4 phone calls from Lynn where he was basically unhinged and screaming, I'm being screwed, WGW screwing me, and he was really, as Mr. Wilson knows, off the reservation, crazy. And so we had to deal with that, and that's what he told me. So I knew that he was looking for a different solution. He was trying to blow things up. So that's what he told me.
Did you? Okay, fine. You don't need to go. We look at Exhibit 84 from May 26th. Candidly, if we explain the fee dispute and resolution to Nicholas, I do not think he will agree to payments to WGW in excess of quantum merit. He is a very principled young man. I have had no discussions with him on this subject. Think about that, ladies and gentlemen. You do not have to suspend your common sense, and the judge will charge you that you alone are the judges of a witness's credibility. And you must think about what a 17-year-old boy would say. And you heard his testimony. He didn't even know what the definition of quantum merit was. Lynn had already put the fix in. That's how he thought that Nick wasn't going to consent. Because he had put the fix in. No 17-year-old boy is going to care when you fill up his pockets in a way that he may not have to work. Certainly not for a long time. Not as hard as the rest of us. And he's going to worry about how his lawyer spends his money. I mean, can you imagine a 17-year-old kid saying, thanks for this huge, life-changing amount of money. But I want to tell you there, Mr. 70-year-old trial lawyer, you are not allowed to spend any of that money on fancy cars or a new suit or anything like that. I want you to take it all to Charles Schwab and invest it wisely right now. I mean, it's absurd to think that young man would have had any such statement unless he was convinced through Todd acting at Lynn's behest to make sure he was going to say that. And how do we know that? Chris drafts up the letter with Joey to welch on the deal, to terminate the deal, say we're not going to pay you the day before he turns 18. They were so sure that he was going to do whatever Todd had gotten him to say. And as you know, Todd is no longer in this suit. He has resolved all claims in this case. But it was a day before he turns 18. And when we asked Chris about it, he was like, well, we were just, anticipating. And so we were drafting. It was all done ahead of time. And then the letter comes out. And oddly, the letter has 3 or 4 huge mistakes. And it's Exhibit 106. And you'll see it. 106. It never says anything about associated in a law firm. Ever. 0. Zip. It never mentions that. It talks about client consent. There is no requirement for client consent. The only statement is that the client not object to the participation of the lawyers. And you heard Nick Sandman state, I did not object to the participation. Yes, I knew they were working. Yes, I appreciated it. But I wanted to see contemporaneous time records. He did not object. There is no requirement for consent. And we'll get to those time records in just a second. Next, he says that, let's see if I can find, the clients in the Carboni and Lindsay cases have consented. You heard Sharon Lindsay get up here. She's this one right there. And she said, nobody called me. I never consented. And by the way, who the heck is Cherie Fazell? I've never seen her. I've never heard her. And you heard that Lynn testified she never did any work on this case and was never part of this. But she got her fee. That was okay with Lynn. And lastly, we see that Chris somehow says some of these agreements are void. The other provisions in the agreement remain valid. And you'll see in his own report that the entire agreement rises or falls together. You can't pick out 1 or 2 clauses and flush the others. And he admitted up here on the stand, yeah, that violates our own legal conclusions. Why? Because he was in a rush to get it out the door, collect some more money from Lynn, give him an excuse, and stop this deal. Todd agrees that Nick did not ask for time records. Let's hear it. His own words.
We know from you that this Lynn's whole position that Nick or his parents or whoever required our timesheets or contemporaneous time records is just not true. It didn't happen. Nick didn't require it. But we know that Lynn similarly did not keep any timesheets. Right. We know from you that this Lynn's whole position that Nick or his parents or whoever required our timesheets or contemporaneous time records is just not true. It didn't happen because they didn't require it. I'm not the one to know that Lynn similarly did not keep any timesheets. That's what I wrote in the email in that question he asked when the bill was presented. So if you give me anything, I'm just going to throw it back at you and say, okay, if this is quantum error, that's to be determined, but we have no objection to receiving a fee, but we can't make a decision as to whether or not it's quantum error or not. I don't want to make that decision under any circumstance. I'm not inclined to get into a wedding because it's just going to get me sued or, worse.
Lynn told them not to keep records of their time. He admitted they did not keep up with their hours and can only reconstruct them after the fact. He was going to use that as an excuse not to pay them. That is not required under the contract. It's not required under the law. You will not hear the judge charge you on any of that. It was another made up defense by Mr. Wood. And he says, their claim is only worth zero because they can't legitimately construct their hours. Now, it was just something that he had built in from the beginning. Don't, put those shingles up there. I won't complain about the color. And then once they go up, I ain't paying you.
I'm not,
All right. Same day that Lynn breaches the settlement agreement, he writes to his kids and he says, I'm going to hold these false accusers' feet to the fire. He immediately breaches. Why? Because that was his plan. They were not my law partners. He is building it in. And he says the day before, the problem exists. Over here, we have a referral. He's making referrals. He's making this line of credit offer, but here's what he's doing at exactly the same time. So he's signing the settlement agreement over here. He's offering the line of credit the next day, but behind the scenes over here, he's writing to his kids saying, they're not my law partners and they're false accusers. In April, over here, he's saying, on the 29th, I'll keep you posted as to any further developments about when this hearing of when Nick was going to be allowed to get the money. And he refers clients. But at the same time, he's writing and saying the same problem exists for the agreement coerced from me by Taylor, Jonathan, and Nicole. So he's saying something nice to keep the plaintiffs dumb and happy while taking affirmative steps to destroy the contract. The same thing goes on in May. He refers potential clients. He couldn't have taken a client. He didn't have a law firm. He had nobody working with him. He had one paralegal, and that was it. And then Alston and Bird is working through the month to void the settlement agreement. He has strategy call with Joey Burby about potential arguments that settlement agreement is void. Could it be any clearer that Joey's job was to void the agreement? He doesn't say to look at the settlement agreement and talk about whatever. He never called me. He never said, hey, Drew, you represent the plaintiff, so we've got a problem. Why don't we call it something else and you can get the full amount under it? Why don't you meet with Nick, with us? We'll all sit in a room and just none of that. Ask yourselves, ladies and gentlemen, during this time period, Lynn Wood was Nick Sandman's attorney. He was representing him. He had just won 2 cases for him, and he had 2 more, one against NBC and one against somebody else. And I can't remember who it is. but that was his client. Do you mean to tell me he couldn't call him up and talk to him? He couldn't get his parents on the phone, say, we got a roundtable this issue about fees. You don't care, do you? How I spend this? He never did any of that. Ultimately, when he presents the new fee agreement, it doesn't allow him to share fees so that he can say, well, sorry, I couldn't do it. We got referring clients over here. Emails to Alston, don't keep me in suspense. Is it enforceable or unenforceable? And this is in June. And so throughout this, he's demonstrating that he knew this was an issue and he knew it was unenforceable. If we proceed as planned, sorry, we need to make sure no one takes any steps. The present WGW agreement may also be unenforceable. And ask yourself, ladies and gentlemen, y'all aren't lawyers, I understand that. Would you think that any lawyer anywhere could pay $10 million to a semi-retired lawyer who didn't work on the case and didn't have any involvement at all, didn't work at your firm? The notion that you need to hire a law firm to figure out whether there's a problem with Sharif Fazell, I submit to you, ladies and gentlemen, don't surrender your common sense by paying Sharif a lot of money. He got a lot of big cases, including the DeVita case. We talked about a $20 million fee to him.
Excuse me, sorry, I hate to interrupt.
Mr. Bill, if you could approach so he can make his record.
Very quick.
Sherry. Correct. The testimony.
Mr. Bill, you can proceed.
Thank you. All right, next. Lynn meets with the Sandman at Tomotley in early July. Nicholas says it was all day. Lynn says it was just a couple hours. But wouldn't that have been an excellent time? You're out at his, not his plantation, it's the Tomotley, whatever. And they're there for at least several hours. You wouldn't bring up, let's resolve this issue in April. But remember, he says, I never talked to him. Why on earth wouldn't he talk to his own client unless this was a plan to keep his fingerprints off it so that he wouldn't get blamed for blowing it up? He could say, well, I didn't talk to him, so it must have been something he dreamt up on his own. No, he made Todd talk to him, and Todd convinced him that Lynn wants this done this way. Next. And then there's some allegation that Nick entered and signed an affidavit for Lynn's lawyer saying what he felt 6 months before. But you heard his testimony. He didn't draft it. His lawyer didn't draft it. Lynn's lawyer drafted it. And it will not be something that you'll be reviewing in the jury room. And so makes it clear Lynn played no part, and gee, I understood Lynn wanted this done, but we know what happened. Todd said, this is what you have to do. And Lynn's lawyers drafted up the affidavit saying this, and he signed it. And I would contend, I would submit to you, ladies and gentlemen, that once this kid got paid, he was agreeable to signing just about anything they put in front of him. And then we see the attorney-client privilege. Did Lynn ever tell you that he didn't want you to consent? No, you can't ask that. Did Todd ever tell you? No, you can't answer that. So we are prevented from getting the ultimate answer. You have to use your common sense. What is disparagement? That statements, and I anticipate the judge will charge you, that statements are disparaging when they express a low opinion of someone or tend to detract or discredit a person regardless of whether the statements are true or false. Detract from that or discredit a person. And let's just go through some of the key examples. You'll see about 50 of them in the 200s. And just wait till Nicole Wade's being fired will be made public. Every lie shall be revealed. More statements about the good things he did and how ungrateful they were. So why does my enemy hate me? I hate pedophilia and human trafficking. He has the picture of Jonathan's child, and this is the hair from and it's been cut back. I know my enemies in lawfare and why they are my enemies. Do you have eyes to see and ears to hear? And then as soon as he posts this picture of Jonathan's kids coming out of the shower covered in, or out of the tub covered in bubbles and playing with the towel, he then posts this about pedophilia. We see some of the attacks on Nicole. She's under investigation by the State Bar of Georgia. Simply false. He filed some crazy claim and it was dismissed. This is intended to discredit. Nicole Wade and her law partners are preparing to sue me in a frivolous lawsuit. Expose them. Extort money from me. Disgusted by what you learn. Greed and false allegations. What are the damages for fraud? If you believe from a preponderance of the evidence that the plaintiffs are entitled to recover, you should award to the plaintiff such sums as you believe are reasonable and just in this case. So it's a very loose, broad definition, and it is up to you. General damages for a fraud claim may include monetary losses, pain and suffering, and damage to reputation. We anticipate the judge will charge you. That is the measurement of the legal standard for damages. Pain and suffering includes mental suffering. If you find that the plaintiff's pain and suffering will continue into the future, you should award damages for such future pain and suffering as you believe the plaintiffs will endure. In making such award, your standard should be the enlightened conscience of impartial jurors. The enlightened conscience of impartial jurors. We'll go through it. You will see a verdict form as to whether the defendants breached the contract with the plaintiffs for failure to pay. We, the jury, find in favor of plaintiffs as to defendant L. Lynn Wood, find in favor of the plaintiffs as to L. Lynn Wood PC. And this is for breach of contract for the failure to pay. And we submit to you, ladies and gentlemen, that it was a deliberate and intentional act, that no such Rule 1.5 applies. There is no other defense. All of that was deliberately made up, and it didn't work. You will see the law associated in a firm. Okay? The amount of damages for failure to pay, we contend, ladies and gentlemen, is $1,034,199.99. As to whether the defendants breached the non-disparagement clause, we, the jury, find in favor of the plaintiffs. If you have found in favor of the plaintiffs, proceed to answer question 2A. If not, proceed to question 3. So in question 2A, damages for disparagement. And we'll talk more about this when I get a chance to address you again. But the damages for disparagement are in the enlightened conscience of the jury. And we'll talk more about how to quantify that. Oh, I'm sorry. Can you go back to the last one? Nominal damages. There's a small number there. Nominal damages are a placeholder amount that you can allege, that you can determine, apply in situations where there has not been a clear demonstration of actual damages. As to the allegations of fraud against the defendants, we, the jury, find in favor of the plaintiffs. If you find in favor of the plaintiffs, proceed to answer questions 3A, B, C, and 4. Financial loss, the fraud damages, the lease that they had to get when they thought they were going to get paid, and they never would have entered into that lease but for the agreement to pay them their share of the Sandman, Lindsay, and Carboni fees. Pain and suffering is here in 3A, damage to reputation and total damages. We'll talk more about those. The plaintiffs must prove that the defendant's action showed at the final questions relate to punitive damages. And I anticipate the judge will charge you that punitive damages are those damages which are designed to punish the defendant, not to compensate the plaintiffs. And plaintiffs must prove that the defendant's action showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care which would raise the presumption of conscious indifference to consequences. And we're going to talk more about this when I come back. But suffice it to say, punitive damages or where there is a deliberate attempt, where there is fraud, misconduct, malice, wantonness, or oppression. And you will determine the amount of punitive damages separately. Then there's a last question about punitives. If you find that the defendants acted with a specific intent to cause harm, and we'll talk more about that as well. And you would just say yes or no. Bad faith. Bad faith in this case are expenses of litigation which arise if the defendants have acted in bad faith or have been stubbornly litigious or have caused plaintiffs unnecessary trouble and expense. Bad faith arises out of transaction upon which the complaint is based and refers to a time period up to or prior to when the lawsuit was filed. Stubborn litigiousness and causing the opposing party unnecessary trouble and expense refers to forcing either the party to file a lawsuit when there is no bona fide, forcing either party to file a lawsuit. And we would ask that when you find this amount, it allows us to be awarded the attorney's fees for the defendant's bad faith. Lynn, I got your message. I just got up and I'm taking care of James, his son, right now. Thanks. I just listened to your second message. Again, I've done nothing at all that you have described and know nothing about it. Please don't contact me right now. Fuck you. You're going to jail. February 14th. You've heard this. Almighty God told me to get you back to where you belong, broke and essentially homeless. Real briefly, ladies and gentlemen, you got to ask yourself why in this case. And it says, oh, I was doing it for this reason, I was doing that reason. Why, if not fraud? Why keep it secret? Why drain the bank account? Why send the smoking gun emails? Why contact Todd and urge him to blow the deal up? Why not tell Alston and Bird the whole truth about the relationship? Why edit the settlement agreement so that only the PC applies and you try to build a backdoor in? Why not just speak to Nick as their lawyer? Why would you immediately disparage the other side? Why draft the rejection letter the day before he turned 18? What's the rush? Why not say, all right, he's 18, we got an issue now? You'll also hear the defendant say, oh, well, you know, I offered them arbitration and private mediation. You also saw the evidence that a mediation happened in 2020 and it went absolutely nowhere. Their promise of a mediation was fulfilled with a retired judge and a talented senior attorney. Todd, what has he said? That the fee was reasonable? Lynn never wanted Nick to consent. Lynn wanted to blow up the deal. Nick did not want timesheets. Todd would never determine quantum merit. And think to yourselves, ladies and gentlemen, when the defendant gets up here and talks about timesheets, how credible is it that a 17-year-old kid knows what an attorney's timesheet is? How credible is that? Ask yourselves, ladies and gentlemen, about your own state of mind when you were 17. Did you know what attorney timesheets were, or did you care? I've been an attorney for a long time and I don't care about them. When I was 17, what does Nick say? Never objected to WGW working on the case and participating in getting paid. Want them to get paid. Met with Lynn and Todd repeatedly. Does not even know what quantum merit is. Can't even offer a possible definition. Never asked to look at the file. Never asked to talk to Todd about who did what. Do not suspend your common sense and your judgment. And thank you very much, ladies and gentlemen.
All right, members of the jury, feel free if you want to stand or stretch in place. Mr. Wood, I would ask, let's go till right around 5, and then you can tell me if that's a good stopping point or right around then where a good stopping point is, or if you think you want to push forward. We
took 10 or 15 now, and I'll roll right through and be done.
But if you use the full 2 hours, we'd be here till.
Judge, I'm not going to use 2 hours.
So what time would you propose we'd be wrapping up for today?
So is that clock 4?
4:04.
4:04. Take a 10 or 15 minute break. That'll put us closer to 4:30. I'll come back. Clearly before 6, I'll be done, I think, by 5:30. I think it'll be an hour, but I understand the court's concern, but none of that. Here's what I don't want to do. I really don't want to split it up, but if I have to, I will.
Yeah.
But I would like a minute to take my notes from Mr. Oh, I want to take my notes from Mr. Bill's argument and have a few minutes to talk to my colleague, and then I'll come back and start. If you give us 10 or 15 minutes.
I don't know if I can do that, Mr. Wood. Let me check with the jury. Is there anyone here who is able to stay past 5:30? You've got lives and things to do. So I'll just, it only takes one to veto. Is there anyone that would rather be leaving by 5:30 on the dot? Yeah. All right. So we're not going to be doing that today. And so unless you were to tell me it's definitely over at 5:30, I think we have to get started. I'll give you 5 minutes to collect yourself, but I think we need to start today.
So we're not going to finish today with my argument. That's what I'm hearing.
That's up to you.
Well,
Why don't we take?
I don't mind.
We're gonna take
5 minutes is fine, but 10 minutes would give me a chance to have a meaningful discussion. with my co-counsel.
Okay. We're going to take 5, but then we're going to get started right after that.
I don't need the 5. Let's go ahead and go.
Okay.
Get it done. Hey, if we can get it done today, I'll stay as long as.
Well, here's the problem, folks, is that I still need to charge you on the law. That process takes about 15 to 20 minutes. And then I don't think they have the exhibits ready to give you in bulk so that you could begin your deliberations.
First thing in the morning.
Yeah, so we could do the charge. It would give you more time tomorrow.
Plaintiffs have their exhibits
Yeah,
ready.
that's something we need to address.
Are we okay staying through him finishing? Okay.
Okay, well, there's a request to go to the restroom, so we're going to do that. All right, absolutely, Mr. Wood. We're taking our 5. Whenever the jury's ready, we're going to be ready. I just do as best you can. Do as best you can. Just be back when you're done. Okay?
I need to go downstairs and stretch my back. I walk. May I approach the bench?
Or you can just wait till they're done. You don't need to approach.
Yeah, that's whatever.
Yeah, let's keep it on the record. Just wait till the jury's out.
I usually run to the restroom either before or after. I go downstairs, I stretch my back and walk, and I smoke a cigarette. Why? I quit smoking for years. When the doctor diagnosed me as having hyperacusis, he said, there's only one reason you're having it, stress. And so what does Lynn do? He occasionally starts smoking a cigarette to reduce the stress. So that's what I do. I go down there, I'll have a cigarette. It helps reduce the stress. It helps my hearing. And then I'm back.
Well, what I was saying is I can give you 5 to 10 minutes, but a smoke break is
10
going to
minutes.
take longer than that.
I think I'll run down there and get 2 or 3 drags and I'll be back in 10 minutes.
All right, well, the jury's
I'll
going
be a
to
lot
be,
calmer. Don't y'all want me to stay calm?
jury's going to be coming in at 4, no later than 4:18. They'll be sitting in that box. I'll just put it that way.
Okay.
Okay? And the clock will start at 4:18.
Now you've got me confessing on the records that after all these years, I would like to smoke a cigarette. But I'm a sinner, but that's okay. The Lord forgives me.
We're off to recess.
I called him right going to lunch, but he answered the phone. I guess he gave it. But it was just.
She didn't come back. They must have had, she must have back up. What's your?
She didn't know. Patrol. What is it? I think he had to leave. I think it was like happens.
It is, huh? It's the key, you're like one of those.
Oh, yeah.
Yeah, we missed one in this morning.
I never missed one.
Maybe that's seven more. I was sitting on it, they might tell me I go blind.
Yeah, that's good. But you don't want it to occur the fees.
Don't go home that one more time, maybe get one. Maybe get it. Usually don't. They got line for what you got the good. That's how much it was.
That's wow.
And I feel good.
Yeah.
Watch. Oh, man. I want you to go to the time. It was a one of these one. Said everything.
I better have ball.
We have a big nod.
That's so great.
I'm sorry. Here's the come back. Sorry.
It didn't go.
All right, we're back on the record. Let's bring in the jury.
It's a good one.
All right, then here.
Hopefully we got.
Not quite. All right, thank you. Please be seated, everyone. Defense may proceed when ready.
Thank you, Your Honor. Ladies and gentlemen of the jury, thank you for your time this week and last week. You come from your jobs, you come from your homes, you come from your families. You're not skilled in the law. That's not what God trained you to do. And you come in here and you sit for 8 or 9 days. And you got some very skilled and clever lawyers. And you see this mountain of evidence. I mean, I've never seen so much. And then you get a law all of a sudden read to you by the judge. Now, does any lawyer believe that you can truly comprehend all that? No. We go to law school for 3 years to learn the law. And then we practice law for a number of years before we even get experienced at it. And so we make what I believe is an unreasonable demand on jurors. You're supposed to come in here and all of a sudden be experts on evidence, experts on the facts, experts on the law. And that's asking a little bit too much. Now, that doesn't mean the evidence is not important. That does not mean the law is not important. But what I believe is the most important thing that you bring into that jury deliberation is your common sense and your life's experiences. You don't leave that behind when you go in the jury room. Does something make perfect sense? Perfect truth. Does that make sense? Truth. That doesn't make sense. watch out. That's gonna be your lie. That's just nonsense. Well, nonsense is nonsense. So remember to use your common sense. God gave it to you for a reason. And remember the body of your life's experiences. God gave you those experiences for a reason. Now, this case is Nicole, and we'll just call them the individuals instead of all the fancy corporate names for the moment. Nicole Wade, Jonathan Grunberg, Taylor Wilson, Lynn Wood. Flesh and blood. Finally, my brethren, be strong in the Lord and in the power of his might. Put on the whole armor of God, that ye may be able to stand against the wiles of the devil. For we wrestle not against flesh and blood, but against principalities, against powers, against the rulers of the darkness of this world, against spiritual wickedness in high places. This life in earth is not about struggles between flesh and blood. It is about a struggle between God and the devil. The Holy Spirit versus the spirit of the Antichrist. I'm so happy and thankful and praise God for Apostle Paul. Because in the last 5 years, I've had people say things about me, do things to me that I loved, like these gentlemen and this lady, that I had been good to. And then they turned on me like a snake. If I didn't have Apostle Paul, I would sit there and go, whoa, there's something wrong with me. My children are upset with me. You hadn't heard the half of what I've been through the last 5 years. Been in this case for 5 years plus. What's wrong with me? Everybody thought I was a great lawyer, an ethical lawyer, an honest lawyer, a generous lawyer, a generous and friendly and loving and caring boss. What happened to me? But thanks to Apostle Paul, I know it's not about me. It's not about them. It's about powers and principalities. We do not struggle against flesh and blood. And if you think we do, I pray that you will read that Bible and hear what God's word says. Because whatever your verdict is, as you decide about the truth, and you do the best you can, if you're fair and you're honest, if you do the best you can to go through all this evidence, to listen to this law, and if you do the best you can, being fair and honest and not biased, then you'll decide the truth of the case. I've looked at it. I know the truth. Andrew Bills looked at it. He says he knows the truth. So you got Andrew Bills' truth. You got Lynn Wood's truth. You got Wade, Grunberg, and Wilson's truth. You even have the judge's truth on what he says the law is. There is only one person that knows the truth. And he knew it before it even happened because he is God Almighty. He knows everything. Jesus Christ is the way. He is the truth. He is the life. He knows the truth. He knows your thoughts. He knows your feelings in your heart. He knows your actions. He knows your thoughts. He knows all of it before you even do it, thinking or feeling. Because he knows the future. So I'll put my life in this part of my life in earth, which is a wisp of wind, by the way, a vapor. I don't live for this world, I live for eternity. Eternity in heaven. Because I am an imperfect son of a living God. But I'll have the rules here in earth are you'll be able to find your truth. And God would judge us all and reward us all according to our works. Because he knows everything. You heard me say it from the stand. Judge McAfee's not in control of this courtroom. He is, as a judge in the black robe, anointed by God to be a judge. God will judge how he judges. God anointed me to be a lawyer. He'll judge how I practice law. He'll judge Andrew Bill. He'll judge Jonathan, Taylor, Nicole, my Linda. And then he will reward us according to our works. God is sovereign. He created everything. Without God, nothing that was created, would have been created. He is the creator. And as the creator, he is sovereign over his creations. God is even sovereign over the devil. So I have the peace of mind that passeth all understanding. That for whatever reason, you might get it wrong. But I have the peace of mind of knowing God never gets it wrong. His judgment is perfect. And I love him with all my heart, soul, and mind. And I'm not ashamed to admit it. Every word in the Holy Bible is absolute truth. He saved me in August of 2018. I was reborn. Born of the water. Reborn of the Spirit. And unless you're reborn of the Spirit, you will not see the kingdom of heaven. I'm going to heaven. Money, 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 money. Give us some more money. Take it if you deserve it. I've always been fair to the people that worked with me or for me. Yeah, look at Taylor Wilson. He's 1 year out of law school. He's got a big case. And I hire him as an associate. Instead of getting $45,000 a year, I said, I'll hire you for $75,000. I think that's more fair. 1 year out. My first year out, I think my first year price only made $14,000. Seemed like I was rich. And I'll let you keep your case. Do it yourself. And take 80% of the fee. And then in 3 years, on a case that I worked on for 20 years, I get them to come in and help me for a few months. And I give them each $750,000. There's not an associate in the United States of America that could come out and in 3 years or 4 years be paid $750,000. He wasn't even hardly wet behind his young ears. He wasn't able to produce business except the one case he brought, and I gave him 80% of that. He wanted to eat what I killed. And I was willing to be generous in what I let him eat. No good deed goes unpunished. I knew, well, I know this because it is written. It is written that the love of money, not money, it is written that the love of money is the root of all evil. And these people love money. The more the merrier. God will reward them according to their works. I knew, because I've been dealing with Andrew Bill for a long time. I told you he's clever, so is the devil. Very sneaky. He'll take somebody's words, the devil will take God's words and twist it just a little bit because he's sneaky. And the devil knows the Bible. He's been studying it for 4,000 years or more. I don't know why poor Sharon Lindsay came from an out of state to be their last witness. Well, I think I do know why. I think I know her connection to Rick Miller, just like I know Rick Miller's connection to Nicole Wade and his connection to Jonathan and Taylor and Andrew Bill. And she gets on the stand. Remember, this was his witness. He's supposed to bring you the truth. And Sharon Lindsay gets up here on the stand and she looks at the settlement statement, which is the one I had because I didn't know she was going to be a witness, and it was unsigned, where I showed the division of the fee, and she consented to it. And she said, I don't know who Sharif Fuzell is. I don't know who she is. Do you remember when I asked you to sign this? It's not signed. And then my office found it. Defendant's Exhibit 106. There's Sharon Lindsay's signature. She signed it. Do you think she signed it not knowing who Sharif Fazell was that was going to get $28,500? Or did she come in here to try to fool you and got caught? Every lie will be revealed. That's not Lynn Wood. That's Luke 12:2. Every lie will be revealed, and God keeps his promises. If he tells you every lie will be revealed, every lie will be revealed. And Sharon Lindsay was revealed. And they brought her in here and let her knowingly sit up there and tell you less than the truth. God controls everything. He got me up this morning. And I knew it was the will of the Father that I come here and suffer through this. I've been suffering through it for 5 years. Persecuted. Persecuted for his name's sake. They persecuted him, they'll persecute me. They'll call him a liar, they'll call me a liar. They called him crazy, they'll call me crazy. And so I will suffer his persecutions with him in earth, but I will share with him his glory in heaven. Do you think $600,000 or $700,000 matters to me? It matters in the sense that if I earned it, then God has allowed me to have it to take care of my needs and my family needs and to try to help other people. And all of my life, I have tried to help other people. I have been generous with my money because it wasn't my money. It came from God. He gives you life. He gives you breath. He gives you all things. All things come from God. All things, including the money. including your health. If my heart beats one more time right now, that is because God allows it to. If I take a breath, that's because God allowed it me to take it. He gives you life. He gives you breath. He gives you all things. I'm not happy with what Jonathan Taylor and Nicole have done to me for 5 years. I feel sorry for them. And every night, by name, I pray for them. I pray every night by name for Andrew Bill, that they'll wake up and realize what they're doing and the eternal consequences of what's going to happen to them if they do not be found by Jesus Christ and forgiven of their sins. I praise the Lord for choosing me in the beginning, so that at the time of his choosing, I would choose him because he chose me. And he came and got me in August of 2018. And wow, is God's timing always perfect? Because I don't believe I could have, as a human being, survived what has been done to me since August of 2019, increasing in the fall of 2018, the fall of 2019, boom, 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 boom. The state bar's after me, people suing me all over the country. And I'm sitting there going, I didn't do anything wrong. Neither did Jesus Christ. Every word he spoke was truth. Every act he committed and undertook in this earth was a miracle because he spoke the word of the Father. And his actions were the actions of the Father. And they brutally murdered him. So he lost in the flesh, didn't he? He might plan for me to lose in the flesh. But I know he tells me that all things work together for good to those who love him and are called according to his purpose. And I love him and I'm called according to his purpose. So whatever your verdict is today or tomorrow, whatever this judge rules about me at any time in the future, I know that God is in control and that in time he works it all together good for his children who love him and are called according to his purpose. I knew, because candidly, the devil is repetitive. If you read the Bible, you'll see that. I knew Andrew Bill would be repetitive. This ain't the first opening statement or closing arguments I've listened to from Andrew Bill about Lynn Wood. And I knew he was going to get up there and he was going to go and play those clips where I used some rough profanity. I told you I wasn't proud of it, but I also told you, like Jonathan told you, he knows I'm passionate. And when you mess with my children, when you mess with my clients, like Richard Jewell or Nicholas Sandman, or if you mess with my 4 puppies, you better watch out, because I'm hot-blooded. You can mess with me, but don't mess with my children, don't mess with my clients, and don't mess with my puppies. And I've told people that for years, and they knew it. Why Taylor Wilson took it upon himself and Jonathan Grunberg to talk to my son Matt behind my back. You want to talk about things done in the dark. You want to talk about people that were trying to hide the truth. They didn't jump out and admit that they were conspiring with my son. I had to find the text because they were trying to hide it. What in the world Why in the world would someone stoop so low as to do anything that would further any type of a problem between a father and his son? You better watch out. God protects his children. He is our father. We are his sons. You mess with one of his sons, he's going to get you. He's going to cut you down because you don't mess with God's children. Apostle Paul persecuted untold numbers of God's chosen people, Jews. He knew all about the law. He was the expert in Jewish law at the time. And then on the road to Damascus, all of a sudden a light blinded him. And he heard a voice, and he knew the voice was Jesus. He'd never met Jesus in the flesh. And the voice said, he was Saul of Tarsus at the time. He changed his name to Paul after the road to Damascus. That was his Roman name. And the voice said, Saul, Saul, why do you persecute me? Saul, why do you persecute me? Saul had never seen him in the flesh. Because Jesus was telling him, when you persecute my children, you are persecuting me. And then Paul regained his sight after 3 days and went from being a lawyer, in effect, to being a preacher. And he was persecuted, imprisoned, beaten, stranded out in the water, thrown in a prison in a hole. And during that persecution, Apostle Paul wrote the epistles, which make up the greatest portion of the New Testament. If we didn't have Apostle Paul's epistles, we wouldn't know how to live the life of a Christian. He told us. Sometimes I look over and I think about these people who I loved and still love. My Father tells me to love all, to pray for all, to forgive all, and I do the will of my Father. When my day comes and I'm looking at Jesus Christ, where I see him by sight, after I believe in him by faith, and I see him in all of his glory, he's going to look over at me and say, well done, my son. Well done, my good and faithful servant, because I'm doing his will of the Father. And there's no doubt in my mind. If I drop dead right now, celebrate, because in the twinkle of an eye, I'll be in heaven with Jesus Christ. I don't fear death. I'm dead in Christ. I live in Christ. I don't fear death. I don't fear any man. I don't fear any situation. I only fear God. And if you don't fear God, you better watch out. If you don't fear God, when you or somebody falls over and dies, in the twinkle of an eye, they're going to see Jesus Christ. And they're going to bend their knees and praise him and say, you are the Lord God Almighty, because they've seen him now. They didn't know him by faith in their life in earth. But they're going to know he's real then. And he's going to look at them and say, I do not know you. And he's going to send them to hell for eternity. He's a God of love, mercy, and grace. But he is also a God of wrath and vengeance. Don't you mess with God's children, because your time is coming. In his way, on his time, he will deal with you. Not, I listened to what I said to him and I said, man, that was really profane. People used to say in the day when I was mad at somebody in my office, I could rip off a line of profanities that was better than a drunken sailor. And some of the people who work with me come back to my office and go, whoa, where'd that come from? I said, no, I just got angry. Try not to be angry now, unless you mess with my children, my clients, or my puppies. I knew he was going to play it first. To prejudice you, Len Wood says he's a man of God. Listen to what he said. What kind of man of God talks about people like that? Jesus Christ looked at the scribes and the Pharisees and he said, ye serpents, you generation of vipers, how can ye escape the damnation of hell? In Jesus Christ's time in earth, the words he used when he spoke to the Pharisees and the scribes were essentially profanity. He let them have it. Ye generation of vipers, ye serpents. But look at sometimes what people, you learn a lot from what a person says to you, or shows you, or tells you. Sometimes you learn a lot more by what they don't tell you, or what they don't show you. So they come in here and they give you these clips that they recorded, knowing that I was mad, knowing how to push my buttons. And they are in a brief 2-week time period in February of 2020. Where are the tape recordings before February of 2020? Where are the tape recordings after March the 18th of 2020? There are none. They don't want you to look at what I did and how I talked to them and how I treated them before that 2-week time period in February, or after I made the deal with them in March. They want you to focus on February. Now, if I'm such a bad guy, where's all that bad guy Lynn before February? Not there. We love you, Lynn. We love you. And where's that bad guy Lynn after March the 17th of 2020? No evidence. They want you to decide the body of my life's work. They want you to decide my integrity and my character and what I've worked for all my life based on what God gave me. And they want to pigeonhole that into less than 1 month and try to convince you that's the truth of Len Wood. What they're doing is not the truth of Len Wood. What they're doing is a lie. A lie. The devil is the liar of liars. His children will do as their father, the devil, does. They will lie. And if you don't believe in Jesus Christ, your father is the devil. If you believe in Jesus Christ, you'll do as your father does. If you don't believe in Jesus Christ, your father is the devil, and you will do as your father, the devil, does. You'll be a liar. You'll want power. You'll want money, as if you're going to take it with you. I give you a big block of gold. Hopefully, we'll go back to the gold standard soon. But I give you a big block of gold. And you can show it to everybody and go, look, it's a block of gold. This is worth a lot of money. What's going to happen to that block of gold when you die? You can't take it with you. You gonna pack it in a bag and take it to heaven or hell? No, you came into this world naked, and naked ye shall leave. These people that think, I want to be rich and I want to be famous, I want to be powerful. Good luck. Because when your time in earth is over, you cannot take that wealth, that fame, that power. You leave this world naked. That's Job. When God told the devil, go down there and get my boy Job. You can put your hand on everything he's got, but you can't put your hand on his life. And Job, who was it says perfect, but it meant that he was an upright man. In one day, he lost his family, he lost his house, he lost his wife, he lost all of his cattle, he lost everything. God let the devil take it. And what did Job do? He rent his mantle. He shaved his head. He fell on his knees and said, blessed be the name of the Lord. He giveth and he taketh away. Blessed be the name of the Lord. I came into this world naked, and I will leave this world naked. Blessed be the name of the Lord. Job understood that what he had in this earth didn't matter. It's what he had in his relationship with God that mattered, because that was going to give him eternal life in heaven, and not eternal life, which is not life, but eternal death in hell. Systematic pattern of hatred. Did you see a systematic pattern of hatred in my life? From the beginning of the evidence that you heard about me until the end, did you find a systematic pattern of hatred? Or did you find a consistent pattern of a man that loved others, that cared for others, that tried to help others when they were needy? Just like I helped Jonathan Grunberg when he fell off that wall. Tried to see if I could get him a lawyer to see if he could be compensated for what happened. Didn't fire him or didn't let him go. Let him work from home. He never missed a paycheck. He went hard at times and did some work from home. And then he came back and I wrote him and said how happy I was. I even gave him a raise and a bonus because he had tried to work from home. Was that a pattern of hatred? When Nicole left Brian Cave, I gave her a place to work. Gave her an opportunity to continue to work with me and make money on cases that I might get her involved in on a case-by-case basis. Was that a pattern of hatred? Was it a pattern of hatred when I gave Taylor Wilson a job at a high salary, and then 3 years later, he put over $1 million in his pocket? 4 years out of law school. No wonder he wants more. He got too much too early that he didn't earn, but I was trying to be good to them. Is that a pattern, a systemic pattern of hatred? It is not. What this man said to you about me is not the truth. He is a liar. Now, it's not just enough that they get me. You'll hear the judge talk to you about, what's that word? Proximate cause. What was the cause of Nicholas Sandman not signing the consent to the fee division? Well, they're going to tell you it was me. Len Wood conspired with all of these people. Wait a minute. Len Wood couldn't conspire with anybody, or Len Wood didn't control Nicholas Sandman. Lynn Wood couldn't say, Nicholas, don't sign that. Nicholas would have had to agree. So I guess Nicholas was conspiring not to pay them. Todd McMurtry would have had to agree. So Todd McMurtry was conspiring not to pay them. They sued him for that. And then they dismissed him, oddly enough. Then he came in here and testified, hurt me. Wonder what the deal was. They won't tell us. Then you've got Joey Burby and Chris Marquardt, two very lawyers of integrity, of long standing in their careers. Well, they had to be part of the conspiracy. They had to come up and go, we'll come up with a memo that says Wood, that the client has to consent. That'll screw him. You think Joey Burby and Chris Marquardt are liars? Do you think that they are people of evil to do something like that? You think there's anything in the world you could give them where they would jeopardize their legal careers to try to somehow help Lynn Wood screw over Jonathan Taylor and Nicole Wade, people they barely knew. They knew Nicole more than they did the other two. Don't forget Nicholas's parents. Ted and Julie would have had to be in on it too. It would have taken a lot of people to come up with this master plan that resulted and caused Nicholas Sandman not to sign the consent. So it can't just be me. If it's me, it was all of them. Let's look at what Nicholas Sandman said under oath. In February the 8th of 2021, a mere 5 months after the event. When your memory's pretty good, 5 years, it gets a little weak. 15 years, it gets even weaker. God bless me with a good memory. Nicholas Sandman. In January of 2019, my parents engaged L. Lynn Wood, PC, and Todd McMurtry's firm to represent them, both individually and in their capacities as my parents and natural guardians, with regard to certain potential tort claims against entities and individuals who had published false and defamatory statements about me. At that time, I was a minor. I turned 18 years old in July of 2020. My parents signed a letter from attorney L. Lynn Wood, dated January 28th of 2019. The letter did not mention attorneys Nicole Wade, Jonathan Grunberg, or Taylor Wilson, or indicate that they would be working on my case. I did not have a separate engagement agreement with any of those three lawyers. And then he tells us under oath, it was read to you. I viewed Mr. Wood as my lead counsel in those lawsuits. Mr. Todd McMurtry was my primary contact. Although I met attorneys Nicole Wade, Jonathan Grunberg, and Taylor Wilson and knew they were working with Mr. Wood on my cases, I did not know exactly what roles they were playing or their precise relationship or the precise relationship between them. LLWPC and Mr. Wood. The sole reason we retained LLWPC was to have Mr. Wood handle the case. We chose him for his experience and success in handling defamation cases. With all due respect to Ms. Wade, Mr. Grunberg, and Mr. Wilson, we had never heard of them. And they were not the reason we hired Mr. Wood's law firm. Then on March the 17th, Mr. McMurtry showed me a copy of a document entitled Settlement Agreement and Mutual Releases, dated March the 17th, 2020, between L. Linwood PC and Mr. Wood and Wade, Grunberg, and Wilson. The settlement agreement indicated that LLW PC would pay, my PC, not me individually, would pay to WGW $843,750 from the fee that LLW PC received in the settled case, Salmon versus C&M. Mr. McMurtry also provided me with a document attached as Exhibit A. Among other things, the document stated that L. Lynn Wood requests that I consent to the agreement and included a place for me to sign indicating my consent. I understood during that meeting that Mr. Wood was authorizing me to authorize him to use the fees he earned from the settle case to pay $843,750 to WGW under the settlement agreement. After consulting with Mr. McMurtry and receiving his independent advice, I declined to sign the document. I decided that before I could make a decision giving consent, I needed to review time records or other documents showing the work that attorneys Wade, Grunberg, and Wilson had performed on my case. $843,000 is a lot of money. I requested that information so I could assess the portion of LLW's fee in the settle case that was to be paid to WGW and if it was in proportion to the services they had rendered. Mr. Wood did not do or say anything to discourage me from giving my consent to the payment he wanted to make under the settlement agreement. I made the decision to request documentation from them on my own after consulting with Mr. McMurtry and receiving his independent advice. Proximate cause. I'm sitting there saying, sign this. For some reason, Mr. McMurtry gave him advice and he decided not to sign it. Did I cause the boy not to sign it? Nope. There's no proximate cause. It's just hard for me to fathom that Mr. Bill wants you to believe that this large cast of characters, including fine lawyers at Austin and Byrd, would commit, in effect, crimes or unethical conduct to somehow help me hurt them. People that I had helped all their careers when they knew me. What happened? Did God turn me into a devil? I'll get him. No. They didn't have an agreement with me in Salmon before the case settled. They shared space with me. I let them work on cases on a case-by-case basis on a fee that was agreed to on my terms. And I was always generous with it. Then Salmon settles. They know the amount. So now we're going to go in and say, well, what do you want out of the case? When you know the amount. And you know that 50% of it is going to get you a lot of money. We want 50%. And I said, well, wait a minute. You're only entitled under law to quantum merit. Now, there's nothing wrong with quantum merit. Quantum merit is fair. Quantum merit says you put in 10 hours of work, give us the hourly fee for a lawyer of your caliber, and you pay it. Nobody was going to beat them out of a dime. They were going to be paid at a minimum quantum merit. They were going to get what they earned. But they wanted more. And I wanted to give them more. I always have. But I tried to use the leverage of quantum merit in a couple of conversations with Todd when I said, if the clients will say quantum merit, that'll help me get rid of these people who were interfering with my son, who were interfering with my efforts to get Richard Jewell the Presidential Medal of Freedom, and who were interfering with my efforts for Nicholas Salmon in his cases going forward. I wanted to stop. And then I finally got to the point where I said, you know what? Heck with it. I'm tired of the late night calls. I'm tired of being so upset. I'm tired of being angry. Life is too short. Life is too short. Joy and Chris, just get me a deal and let me put this behind me. And then I had told him I had split up the fee a certain way, and I said, I'll live up to it, even though at the time I did it, it was tentative, and I didn't really feel like I should give them that much money, but I did give it to him. On March the 17th of 2020. Don't be misled about this nonsense about bar rule 15.1.3, 1.5. The determination of whether you are in a firm, whether you are even associated with a firm, whether you're even working on behalf of a firm, it's decided on the date of the agreement to share the fee. August 17th, 2020. Sorry, March 17th, 2020. What was the relationship? By their own admission, undisputed, they quit on February the 14th. The
Objection.
same day that I was going to fire them.
Objection.
Yes, Mr. Beal.
And did fire them.
It's not the law. And he says.
All right. I'll start with this. Members of the jury, all instruction in the law, you'll receive a copy of that law during your deliberations.
And then Mr. Bill gets up here and runs up the figures. This is amazing. He puts up the figures for the fees in the contract. And instead of deducting what they agreed to pay me, the $285,000, he leaves that in there. He doesn't deduct it like his clients agreed to do. And then he throws $60,000 more in there for some rent they claim they had. Are you kidding me? Greedy, greedy, greedy. Love of money. Look at its agreement, and I would ask you to take a hard look at this agreement. This is not lawyers talking. This is the words used by me, Nicole, Jonathan, and Taylor. And they signed this deal fully advised about it by Andrew Bill. And now they want to try to wiggle out of it. But we didn't know what that meant. You signed it. And what did they say? WGW shall pay to LWPC the amount of $285,000 in full satisfaction of any obligations WGW may have or be alleged to have under the lease agreement with Regions Plaza, where we were sharing office space. And they agreed to pay on the buyout. They agreed to pay 75% of it. Because you'll see the agreement with Regions Plaza. The lease was in the name of L. Lynn Wood, PC. Signed by L. Lynn Wood. Signed by Jonathan Grunberg, writing partner. Signed by Nicole Wade, writing partner. Signed by G. Taylor Wilson, writing partner. The partners. We were partners. We were partners in an office sharing arrangement, and we were partners on that lease. What happened to being my partner on the lease? Now they don't want to even live up to the $275,000 they agreed to pay. They want all the benefit, and they don't want the responsibility for paying what they agreed to pay. Does that sound like honesty? Or does that sound like some lawyer being clever to try to jack up a claim? Because God gave me the blessing of handling DeVita. And I made, according to Mr. Bill, $20 million. I didn't know what to do with it. I know that Sharif Azell got 10 million. I know that Marlon Wilbanks got 28 million. I know it was divided up, and I gave a lot of people money. I gave Catherine Hernacki 10 million. I gave Stacey Godfrey Evans, I gave Catherine Hernacki 5 million. I gave Stacey Godfrey Evans 10 million. I guess that's why she decided she wanted to run for governor. I funded her campaign. Now they want, that's what they want. They want the money that I made in DeVita before any of them were involved in it. Let's get the money from DeVita from him, even though we didn't have anything to do with it. Let's emphasize to this jury that Mr. Wood lives at Tomatley Plantation. Why would you emphasize that? Because he's playing on your color. Don't let him do that. When I bought Tomatley, I changed the name to Tomatley. Not that I thought there was something inherently wrong with plantations. That's where people grow food. But the stigma was too much over time. When I bought the property, I dropped the name. I called it Tomatley. When I'd earlier had a condominium at Reynolds Plantation, within a year of buying that condominium, Reynolds dropped the name and changed it to Reynolds Lake Oconee. Because the word plantation has a connotation to it of slavery. And that's why he keeps using it. Because he thinks you're going to fall for it. And he's going to think I'm some rich landowner with a plantation that treats the black folk bad. You wouldn't believe how many blacks I have represented. I don't usually keep up with that because I don't see color. I see a fellow creation of God. I don't see color. I never have. And it's offensive for me to him to play these little lawyer games and to try to prejudice you by saying Wood lives on a plantation. Shame on you. Shame on you. Lynn had already put the fix in. What was the fix? And how many people had to be involved in the fix? God blessed me with talent as a lawyer. Before I found him, he found me in 2018. I thought I'd come from nothing after my mother's death and that I had made it. I had worked hard, studied hard, given my every bit of energy to my clients, and I had made it. I was one heck of a trial lawyer. And then in 2018, God knocked me down on my knees. He humbled me because I knew at that point in time that everything I had done was never about me. He did it. He gets all the praise and all the glory, not Lynn Wood. He humbled me. And I finally understood. All the crazy things that happened in my life, I finally understood. And I was at peace with him. Because he planned every minute of it. He planned every detail of my life. Your life, your life, your life, your life, your life, your life. He plans every detail of it. And he planned it in the beginning. Because he's Almighty God. And he knew everything in the beginning. Who he would create, when he would create you in the flesh, what he would name you, what talents he would give you, and whether you were going to be his child to go to heaven or a child of the devil to go to hell. He knew it all in the beginning. It is very difficult. It is very difficult for people to take a finite mind and comprehend an infinite, all-powerful, supernatural God that controls everything, created everything. It's hard to get your mind around it. That's why you have to believe in it by faith. And your faith grows the more you read his word. The word of God is Jesus Christ. In the beginning, there was the Word, and the Word was with God, and the Word was God. And then the Word came in the flesh in all of his glory. Jesus Christ was the Word of God. In Revelations, John saw him. On his vesture, it said, the Word of God. This Word of God will cut sharper than a double-edged sword. Demons tremble at the name of Jesus Christ. You mentioned the Holy Bible, that's like saying Jesus Christ, the demon will look over. Don't talk about that. Because it cuts sharper than a double-edged sword. And when John saw him in Revelations, in all of his glory, he said his hair was gray. He had fire in his eyes. And his tongue was sharper than a double-edged sword, the Word of God. And he came here in the flesh as the Son. And he said, the Father and I are one. Jesus Christ came as a humble man. And they hated him because he told them the truth. He convicted them of their sins. And they hated him. And they killed him. Even though they'd seen him walk on water, raise the dead, feed 5,000 with 3 fish and 5 loaves. They killed him. But they couldn't kill him. Because he's God. Our Creator. Our God came to the flesh. He was Jesus Christ, and he is Jesus Christ, and Jesus Christ is God. Sometimes I ask him, Lord, I tell you, I prayed many times in the last 2 weeks. I didn't want to come back here. I didn't want to leave my puppies, leave Tomatley. My health is not good. I said, Lord, don't make me go. Haven't I suffered enough? Don't make me leave Tomatley and my puppies and go back down there for a couple of weeks and have those people lie about me and say these things about me. Don't make me go, but your will be done. Then he made me go. It was his plan for me to go. It was his plan for me to be here with you. Apostle Paul said, when you're called before the tribunal, don't worry about what you're going to say, because the Holy Spirit will give you the words to say at that moment, because he knows what you're supposed to say, and he gives you the words. So my own belief is, as tough as this has been, as difficult as it has been, as insulted as I have been, as mistreated as I have been, I was supposed to tolerate it and suffer it, because I pray that somebody watching this on YouTube or sitting in this courtroom, that God will use me to bring you to him. And just one person, if he uses me to just bring one person to take them out of the road to perdition, the road to hell, and put them on the road to heaven, if he uses me to just get one person, everything I've been through is worth it. Everything. Every time Apostle Paul was called before the tribunals and falsely accused, he represented himself. And every time that he defended himself and said, I've done no wrong, I've broken no law, he used every tribunal they called him in front of to share the word of Jesus Christ. So I'm called before the tribunal. Have I shared the word of God with you today? They cut off Apostle Paul's head. He was a martyr for God. The second they cut off his head, he was with his Lord and Savior, Jesus Christ, forever. And then he was rewarded for his suffering. He was rewarded for his work that God did through him to write most of the New Testament. So I don't know why. I don't know why God said, Lynn, got to go. But I told him when I said, I don't want to go. But if it's your will, I will go. The day before he was crucified, because he was 100% flesh and 100% God, Jesus knows our pains in the flesh. He went to the mountaintop 3 times because he knew what they were going to do to him. The beating, the suffering, the mocking, to drive nails in his hands, to beat him beyond recognition as a human being. He knew what was going to happen to him because he's God. But he was in the flesh too. And he went 3 times to the top of the mountain alone to pray to the Father. And he said, can you take this cup from me? But your will be done. Second time he went and prayed. He said, can you take this cup from me? But your will be done. Third time he went to pray. He said, can you take this cup from me, Father? But your will be done. He knew what was in the cup. He knew that in that cup was every sin of every human being in the world, past, present, and future. And that in that cup there was a time, very brief, that he would be separated from the love of the Father. But he said, your will be done. And God's will was done. He died on the cross, shed his blood to defeat sin. And then he rose from the grave to defeat death. Excuse me. I don't know exactly why God has put me through what I've been through. I have a pretty good idea. He'll give you the mind of Christ if you're his son. But I know this. He'll tell me in heaven. But he does a pretty good job of telling me enough in earth. I don't want your sympathy. My life is the life God planned for me. I respect and love every one of you. You're God's creations. I just want you to be fair. Don't let anybody influence you. Don't let anybody buy you off. And do your human best to tell the truth. You decide, Linwood's a liar. Okay, if that's what you think. That's your right to do it. God knows different. He knows I'm telling you truth. And the truth sets me free. I pray that God will guide you if you'll let him. That you'll seek guidance from the Holy Spirit. You'll hear the judge talk about the law. You'll hear the lawyers talk about the facts. Ask for guidance from the one that knows everything. You don't get any better advice than from the one that knows everything. So I pray that you'll ask the Father in the name of the Son for the Holy Spirit to guide you to come to the right decision in this courtroom this week. God bless you. God bless Judge McAfee. And God bless my enemies. God bless them if they love him. He will bless them. If they don't love him, he will condemn them to hell for eternity. Thank you for listening to me. Didn't know what I was going to say. And look what the Lord told me to do. He told me to preach a sermon. And he gave me the words to say. And when I leave this room, go back up to stay tonight, I'll give him all the praise and all the glory. Because he's with me. Wherever I go, he is with me. Joshua 1:9. The Lord thy God is with thee whithersoever thou goest. Wherever I go, God is with me. Why is he with me? Because the Holy Spirit is indwelled inside of me. Jesus Christ lives inside of me and inside of every one of his children. And I pray that when you reflect back on today, whether it's tomorrow or a week or a year or 5 years from now, I pray that when you remember Lynn Wood, that when you saw me, you saw Jesus Christ in me. That's the Great Commission. To share him to the world by letting everybody we come in contact with, me and the judge, me and these lawyers, God wants these people to see Jesus Christ in me. That's how you share him to the world. Those conclude the closing remarks on behalf of myself and Dale Linwood, PC. Thank you very much, Judge McAfee, and thank you, ladies and gentlemen, for your attention, especially when I know it's late in the day. God bless you.
All right, members of the jury, we will reconvene at 9 o'clock tomorrow. As I mentioned to you, the plaintiffs have the right to conclude the closing arguments. They have some time remaining. From there, I'll charge you on the law. And after that is when you can begin your deliberations. Over the lunch hour, again, will be on your time. We've arranged for lunch to arrive, I think somewhere around 11:30. So you can you could choose to break for lunch if you want, or you could just work through lunch as well, or you can break and go get your own lunch. It's up to you. But that will be the plan for tomorrow morning. Don't discuss this case with anyone, including amongst yourselves, and don't do any research to this case. Everything you learn about this case happens in this courtroom. Thank you so much. We'll see you tomorrow morning.
9 o'clock, Judge.
Yes, sir. Always have some housekeeping, though, before we go off the record. We're going to have a little housekeeping before we go off the record,
Okay.
though. All right, just two things I want to address before we recess for today. One, I think we touched on it briefly, or at least I think the plaintiffs had, about the exhibits we need to have a physical copy of what's going back and what's staying in. As I understand it, the plaintiff said they had printed everything out. And have y'all also identified what in your belief goes back? All right. And so what I would ask you to do is if you could have those numbers, provide those by email to defense so that we can just hop right to where the points of contention are. I'm just going to ask the defense, what of the plaintiff's exhibits that they have said are going out do you disagree with? And that's where we'll take it out. We won't need to go one by one by one by one. And same with vice versa, the defense. Yeah, or maybe y'all didn't print out the defense exhibits, I presume, but where there's any overlap, I guess you could note that. But just have everything printed out that you think needs to go back, have that listed, and then send to them what that list is. And so everything that you've sent them is everything you think they need that goes back, and then we can just get right to any objections. And it might even be easier for the record if you just print that out and enter it as an exhibit instead of reading out all 200 numbers or something like that. Just an idea there. All right. Then the other matter of housekeeping is I'm just trying to plan efficiently for tomorrow. Obviously, have no idea how long it would take for them to reach a verdict, but there's still things that we would need to do depending on what that verdict is. And essentially, if there is a phase two, instead of just finding out in the moment and then figuring out where we go next, I would plan to use some of that deliberation time to work through those issues. So I would want to go ahead and be talking with you about the charges that would be applicable, about how much additional evidence the plaintiffs or defense would plan to present, and how that would look. I don't know offhand what you think that looks like, Mr. Beal.
Well, for attorney's fees, I'm gonna offer in the evidence and state my place. If he wants to cross-examine me, he can do that. We've got them all printed out. So that should be pretty fast for
What's printed in?
attorney's fees.
What's the printout?
All the time spent on this file.
Can we get a copy of that tonight?
Yep.
And in fact, Mr. Beal, I would say just in the interest of efficiency, if you could provide those to him by tomorrow morning, just so
I'm
that
gonna do it tonight.
even better,
They can do it by email.
even better,
Okay.
even better.
So half of them got redacted. The half at the other firm, for some reason, it's somebody else's software because I'm no longer at the original firm. That software is gone, so we had to do it manually. So that's why we don't have it done today. We had thought we would have.
And let me go ahead and throw this out there because I could see it coming up mid testimony and then we having us having to scramble. You've already been compensated by Mr. Linwood for probably a little slice of your fees through the contempt hearings. Have those been reflected in the amounts? Okay.
And
I have no idea what the total pie looks like, so I couldn't tell you.
let's put it this way. The portion of the contempt hearing that relates to compensation for attorney's fees is deducted. The portion that relates to a sanction is not deducted.
Okay.
What about the $750,000 verdict they got against me in the defamation case for attorney's fees? That should be deducted if it holds on appeal.
Have you been able to do some accounting or?
We haven't been paid on that. And
Yeah.
so there would be no deduction for something that hadn't been paid. Secondly, that time is in a separate billing system for a separate case. So one of them's called WGW Fed and one's called WGW State.
All right. So y'all clearly you've thought through these things and it's good to flag those. And it sounds like we can address that. What about other evidence?
Well, then I think we would put in a little bit about Mr. Wood's worth. And we don't plan on putting in tons of additional damage about something would constitute that would give rise to punitives. I think we're just going to put in his monetary his net worth so to support the claim for punitives and make a closing argument on
But
that.
when he goes into my financial status, he's gonna have to go into the fact that I've got that $4.5 million verdict against me in judgment. And I've had to secure it with security that totals $8 million. So when you're gonna go into.
That's good to raise that now. That seems relevant.
It's got a problem.
Well, none of the amounts listed there are the amounts pledged for the bond in the state court case. So we would only be talking about amounts that are not pledged to compensate the
Okay,
plaintiffs.
but when you say net worth, you're deducting because of that amount that you've already got
No,
a
I'm just
judgment
talking
for?
about his assets and his cash that are reflected on the documents he gave us that are not included in the bond.
But not mentioning the assets that he's used to secure it.
I know my assets.
That's correct.
That financial statement is outdated. But I know my assets. It's all in 3 pieces of property, 2 of which are under a security bond in the federal case. And
Yeah, so it seems the plaintiffs, to me, the plaintiffs are conceding that the net worth they introduced in evidence is reduced by the judgment
Just
or offset
I
or,
misspoke by saying net worth. I'm saying assets and cash that we are talking about are not the assets that have been pledged in the federal case.
okay.
I got $2 million in cash that I got from the net on HUSPA that I pledged, and the judge let me pledge it. And then I had to take the other $500,000 I made on the sale and put it in a separate account for paying taxes when the time comes. So there's not a lot of cash.
I mean, I definitely want to say that this seems, his point is just that there should be some recognition of liabilities is relevant to, so that, I think that's the core of the point. And I'm wondering, do you believe that you are reflecting that in the evidence you would plan to introduce?
Certainly offer his own rebuttal testimony that
He's going.
he has certain liabilities. What I'm talking about, can I just?
I'm sorry. I'm sorry.
I'm talking about cash and assets that aren't pledged.
Okay, but the point being is he would have every right, because we had the motion in limine that regarded that other lawsuit, but now that aspect of it is at play.
Because on any.
Should not be he should not be introducing testimony about the other case, period. Because we're not.
But the.
There's no way to avoid it.
Yeah.
Go ahead and
Yeah.
finish.
If you fill out any financial statement.
What I'm saying.
All right, Mr. Wood, I'm going to let you have a word. I'm going to let you have your word. I mean, I understand what you're saying, Mr. Beal, but he can say that he's got this large judgment against him of this amount.
No, because we're not. The judgment is $4.5 million. He has pledged assets that are in excess
$8
of
million.
that are up to between $6 and $8 million. So.
Mr. Wood, you said you'd let him finish. And again, the numbers, let's not get into the weeds of the numbers. The point is,
Let me go ahead and finish.
yeah,
Those assets are not going to be addressed. We're not going to be talking about those. So he doesn't need to talk about $4.5 million. He doesn't need to deduct $4.5 million because I'm not talking about those assets. I'm not talking about total net worth. I'm saying this account, that asset is what you got. And that's what we're
Any
tackling.
attempt. I'm sorry.
understood. Mr. Wood, your turn.
Any attempt to establish my financial situation, just like you fill out a financial form, financial statement, you list your assets, you list your liabilities, you list your ongoing expenses, you list your income, I don't have any, and you list your contingent liabilities. I'm sitting on top of potentially $8 million liability. It's not that contingent unless I reverse it on appeal, and I believe I will, but I don't know the future. So this idea of trying to run up the Linwood's got $20 million, that's just nonsense.
Okay, we're going to have to explore this tomorrow. Again, this is what we'll use our deliberation time for. Are you presenting this evidence through documents or testimony?
Well, it's the documents that he gave us and grab those and I guess some testimony from him. This is true and accurate. This is what you.
Okay, so he would.
We're thinking real fast.
Wow, that's no surprise there, but what will it actually be?
I mean, we're not gonna put up witnesses. We're not gonna introduce extraneous documents, I don't think. And so, you know, I'm not gonna.
Understood.
I'm not planning on doing any of that. I'm planning on putting in the attorney's fees. And I'm planning on putting in some evidence of his worth. And then I wanted to make a closing about punitives for a couple of minutes to explain to the jury what they are and how you measure them and a little bit of that.
Okay. got the roadmap. And Mr. Wood, anything you want to add to that? Is the roadmap?
Just that he's opening up the door, I'm afraid, because the financial statement that we gave them was the most recent, and I think it's at least 2 to 3 years old. It's not accurate now. A lot has happened. I've had that defamation case that they brought. I had to spend a lot of money on that fraudulent transfer case they filed that even they finally dismissed. I probably had to spend $250,000 defending a frivolous case, a fraud. And I'm going to listen very carefully and make sure that I follow the court's rulings. But I'm going to be walking on eggshells, and so are they. I've never understood why they didn't want the jury to know about all the cases. Yeah.
Okay. Well, we'll use our time tomorrow to make sure we're clear on exactly what comes in. And the last point I would have on that, when you say you want a few minutes on closing, I do not believe I'm bound by the uniform rules or statute or anything to set whatever time limit I want. So there will be a much lower than 2-hour time limit on phase 2 closings. And we can talk about the length when we get there.
I'm done.
We're only gonna be talking about, monetary damages. We're not gonna be talking about evidence in that phase.
All right. I know. Understood. Okay.